ಫ್ಯೂಚರ್ ಬಾಯ್ ನೆಟ್ ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ, ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿತ್ತು, ಕನೆಕ್ಟ್ ಅನ್ಕೊಳ್ಳಿದೆ ಹಿಂಗೆ ಬರ್ಲಿಕ್ಕಲ್ಲ. ಇದು ಮತ್ತೆ ಇದನ್ನ ಡಿಸ್ಕನೆಕ್ಟ್ ಅಂತ ಬಂತು ನೋಡಲ್ಲ,
ಕನೆಕ್ಟೆಡ್ ಅಂತ
ಎಲ್ಲ
ಕನೆಕ್ಟೆಡ್ ಸೆಕ್ಯೂರ್ಡ್ ಅಂತಿಲ್ಲ.
ಇದನ್ನ ಆಫ್ ಮಾಡ್ಲಿ ಬಾರ ಇಲ್ಲ ಒಂಚೂರು, ನಾನು ಇದು ಬರೋ ಇದು ನೋಡಿ ನೆಟ್ಟಿಂಗ್ ತಿರ್ಲಿಕ್ಕೆ ಇಲ್ಲಾದ್ರೆ ಬಂತಿಲ್ಲ ಎಲ್ಲ
ಇಲ್ಲೂ ಬರ್ತದೆ ನೋಡಿ. ಈಗ ಕರೆಕ್ಟ್ ಆಗಿದೆ ನೆಟ್.
ಡಿಸ್ಕನೆಕ್ಟ್
ಏನಂತ ಅದು
ನೋಡಿ, ಇನ್ನೊಂದು ಕನೆಕ್ಟ್ ಬರ್ಬೇಕು ನೋಡಿ, ಇಮಿಡಿಯೇಟ್ ಬರ್ಬೇಕು.
Page 21, 74 to 80. Page 22, 81 to 85.
81 2 weeks time maybe contact.
81 ಯಾರಿಗೆ ನೀವು petitioner
Petitioner DB Kari.
request of counsel for the petitioner released on 21st March.
Lord, in this case, we made a submission that only a mutation proceedings have been questioned, and the lordship has taken note of that, and a date was fixed today. All appeal hack mutation, Tahsildar mutation challenge ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ದು. No interim order, nothing is there in the date petition.
ಮತ್ತೆ ಸುಮ್ಮನೆ ವೇಸ್ಟ್ ಮಾಡ್ತೀರಾ ಟೈಮ್ ಇಲ್ಲಿ, ನಿಮ್ದೇ ಟೈಮ್ ವೇಸ್ಟ್ ಆಗುತ್ತೆ. ಕಾರಿಗಾರ್ ಅವ್ರು ಹೇಳಿದ್ರದ ಟೈಮ್ ತಗೊಳ್ಳಿ ಅಂತ ಅಷ್ಟೇ. 81 21st.
Page 23, 86 to 90.
Lord, serial number 88. On the last occasions, I have made a submissions that pursuant to, they are seeking a writ of mandamus, pursuant to which an endorsement has been already issued. That is not questioned till today. That has been already recorded on the order sheet.
But it has become infectious.
You have issued the
How?
The prayer is that my lord, husband should not interfere with the administration. Wife as a president
husband should not have.
should not, my lord, interfere in the administration of the wife who is the president. The term itself is over.
So we should grant that relief. Let us see what.
Please.
Page 24, 91 to 96. Pa-
90?
95.
I'm for the petitioner.
That counsel for respondent number 2 and 3 seeks bond is grant 2 weeks time to
Not
file a statement of objection. Objections if any by
May I seek on 25th month? Short matter. madam.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡ್ತೀರಾ objection?
That's one. Minimum 2 weeks.
2 weeks ಬೇಕಂತ. 24th March.
It's a simple matter. madam.
Objection.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನಿದೆ? We have sought for transfer of the license matters, APMC license matters. They have ordered for forfeiture of the entire property.
Stay ಇದೆ ತಾನೆ.
Stay there,
Released on 18th March.
please. Interim order,
Interim order earlier granted is extended.
please. Great.
Page 25, 97 to 102.
Lord, serial number 101.
Hmm.
I undertake to appear for respond number 1. I'll file wakalat during course of the day.
Respond number 2 ಗೆ
Respond number 2, I only undertake to appear for respond.
so on to submit that you appear for respond number 1. Registry's direct print is name as such. Interim order ಇದೆಯಾ?
Not for it.
You're not sought. Released on 10th March.
Page 26, 103.
Serial number 105, yesterday's matter. Seek apology, my lords, before my lords. Yesterday, my lords, immediately after hearing, I, my lords, shown the records to my clients also. And I strictly warned to them, my lords, if you won't withdraw, my lords, then the situation will be different. And I also, my lords, convinced him. So he sought, my lords, 1 day accommodation. Friday, my lords, if he,
Accommodation ಮಧ್ಯಾಹ್ನ
ಅಲ್ಲ ಫ್ರೈಡೆ ಅದು ವಿಡ್ರಾ ಮಾಡ್ತೀನಿ ಐ ವಿಲ್ ಇವತ್ತು ಕನ್ವಿನ್ಸ್ ಮಾಡ್ತೀನಿ ಇವತ್ತು ಫ್ರೈಡೆ ಎನಿ ಕಂಡೀಷನ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಐ ವಿಲ್ ವಿಡ್ರಾ ಅದರ್ವೈಸ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಐ ವಿಲ್ ಯು ಟು ಆನ್ ದಟ್ ಡೇ ಮೈ ಲಾರ್ಡ್ಸ್ ಫ್ರೈಡೆ ವಿದೌಟ್ ಎನಿ ಕಂಡೀಷನ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಐ ವಿಲ್
105 at the request of counsel for the petitioner released on Friday
21st 21 please
1, Narayan D. Yazi.
Lord's kind permission, may I make a submission?
Yes.
Serial number 59, Lords.
Uh,
May I permitted to withdraw, Lords?
59 the petitioner is before this court seeking for the following reliefs. Memo dated so and so has been memo dated 19/2/25 signed by the counsel for the petitioner has been filed, which reads as under accepting said memo petition is dismissed as withdrawn. Yes.
Lord,
1,
Madam, may I seek pass over, my lord, since the petitioners have engaged the service of senior advocate.
Pass over ಆದ್ರೆ reach ಆಗುತ್ತಾ ಇಲ್ವಾ doubt.
May fix Friday, my lord. Friday 2:30.
ಮತ್ತೆ ಅವತ್ತೂ pass over ಕಡೆ.
Senior counsel ಇರ್ತಾರಂತೆ. Friday 2:30 it may fix.
Released on 21st at 2:30.
Please.
The meanwhile office objections to be complied with.
Yes. Please.
2, Omkar Desai.
And I filed I for seeking direction to appear the examination, my lord.
The virtue of interim order, my lord, 23/2/2024, my lord. She appeared the examination, my lord, and virtue of interim order 29, my lord.
Hmm.
That the results was announced, my lord, but surprisingly she got failed, my lord. She got failed, my lord, subjects. So again, we are not permitting to appeal. That's why I filed application once again.
So you again application ಹಾಕಿದ್ದೀರಾ?
Yes, my lord. Earlier, that is for declaration of result, my lord. 21/1990, 24, my lord.
Supplementary exam scheduled on 3/3.
Sir,
He sought for permission to appear in the supplementary exam scheduled on 3/3.
through my lords, KEA, lords, the allotment letter has not been issued.
Yeah, okay.
Sur-
10?
That is serial number
That is
3.
serial number 3, my lord.
ಇವಾಗ serial number 2 ಕರೆದಿರೋದಮ್ಮ. 101187.
Same matter. That matters also they are seeking allotment later, my lord.
Afnam Khan.
Para number 7.
These are different.
They are all my lords direct admissions. The college has taken the direct admission. Through KEA counseling, they have not attended. Direct admissions they have taken.
No, my lord. The admission
Their
order
admissions
passed
have not been approved.
KE board, my lord.
Intake ಏನು? Intake
Intake 60.
Intake 80, my lord. 80 or 60.
60.
who appears for the college?
The petitioner, one of the petitioners is the college.
One
Second
of the
petition.
petitioners is the college.
Yes.
How do you take?
Intake is 60, my lord.
No, both of you are appearing together. So how did you take them directly?
No, they themselves passed the order, admission order, my lord, KE board. That is,
Direct ಅಂತೀರಾ, they have approved ಅಂತೀರಾ.
That's only serial number 3. First petitioner.
ಇವಾಗ we'll go by only one by one. ಮತ್ತೆ ನೀವು ಕನ್ಫ್ಯೂಸ್ ಮಾಡಬೇಡಿ. 101187 ಅಲ್ಲಿ ಏನಾಗಿದೆ? How is the admission made in 101187?
Out of 80
that
my lords,
page,
out of 80 students, my lords, 79 my lords admissions have been approved. One student admission, that is the petitioner's, the first petitioner's admission was not approved due to my lords, the non-availability of the allotment letter by the KE.
Hmm.
That my lords they have questioned.
meantime, my lord, if the permission to appear the examination, my lord, respect of the outcome, there is a writ petition, my lord.
Your petition number 1 was not given a seat. She made a representation that was not considered. Just because she came to know that some vacancies are there, she applied to you.
Apply, yes, my lord.
And you admitted.
Yes, my lord.
What is the point in having the process of counseling if you are going to admit directly?
She admitted through NEET exam, my lord. Annexure A, which I produced, my lord. NEET, she appeared, my lord. After she getting note that the some
ಇರ್ಬೋದಪ್ಪ, NEET is only the
Counseling-
exam. Counseling process ಏನಕ್ಕಿರೋದು?
counseling second round.
And how can you as a college admit somebody without counseling? A student ಗಾದ್ರೂ equity ಇರತ್ತೆ, ನಿಮ್ಗೇನ್ equity ಇದೆ? You have violated the rules. ಎಷ್ಟು fees per year? Fees ಎಷ್ಟು charge ಮಾಡ್ತೀರಾ per year?
Per year, I think 5 lakhs.
5 lakhs.
4 lakhs.
ಎಷ್ಟು year course ಇದು?
Done. For 5 years, my lord.
So 5 into 5, 25 lakhs ಮಾಡಿದ್ದೀರಾ. So ಅದ್ರಲ್ಲಿ 20 ಲಕ್ಷ ಕೊಡಿ. So next time you don't do this.
Yes.
20 lakhs
I request on tomorrow, my lord, make my
to
submission.
KEA fund. So that they can initiate proceedings against errant colleges, engaging lawyers. ಮಾಡಂಗಿಲ್ಲ ಇದೆಲ್ಲ ನೀವು.
I request on tomorrow, my lord. Make my
We'll
submission.
permit the exam, but you will pay for it.
No, my lord.
You will pay for it.
I request on tomorrow, my lord. Exam only permitted.
Exam permit ಮಾಡೋಣ.
Yes, my lord.
But college will pay for it for having violated. So next time ಮಾಡಲ್ಲ ಆಮೇಲೆ. At the request of counsel for the petitioner, relist tomorrow. 2.1 ಏನು?
Requires hearing. In this case, my lord, it is a PG admissions wherein, my lord, there are no regulations framed by, my lord, the NCISM.
No regulations.
Just only by virtue of
NCISM ಯಾರು?
ಅಂಗಡಿ ಅವಿನಾಶ್
3.3. Not 2.
2.1.
2.1.
Where is he? There are no regulations by NCISM.
PG regulations illa.
ಎಷ್ಟು ದಿನದ ಅವ್ರ ಜೊತೆ ಇದ್ದೀರಾ? You are working with Mr. Angadi for how long? From
8 months.
8 months. Then so many matters come up. Whether NCISM has a regulation for PG ಅಂತ ಅದು ನೀವು ಗೊತ್ತಿರಬೇಕು ನಿಮಗೆ. So no regulation by NCISM.
PG ಗೆ regulations ಇನ್ನು ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ. By virtue of, my lord, guidelines, they they are applying, my lord, UG regulations, and entire, my lord, under the UG regulations, all the admissions are to be carried out, my lord, through KEA counseling, my lord, which is not provided, my lord, in the regulations for PG.
Have you challenged the regulations?
ಅಲ್ಲ regulations ಇಲ್ಲ.
Have you challenged that application? You only challenge the endorsement. Making applicable the PG regulation to UG, have you challenged it?
UG regulations also they make apply only by way of, my lord, notification.
Have you challenged that notification, Mr. Malli? Then otherwise you can't maintain this.
ಯಾಕಂತಂದ್ರೆ, my lord, I am relying upon a previous enactment that was, my lord, Indian Mediation Center.
Once there is a notification is issued as a subordinate legislation, you are bound by it.
That is only for regulates, my lord, UG admissions, not, my lord, PG.
Which is made applicable to PG by a notification ಅಂತ ಇದ್ದೀರಾ ನೀವೇ.
ಅದು ಗೈಡ್ಲೈನ್ಸ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹಾಕಿದ್ದಾರೆ. But same thing have been, my lord, repeated in the
Yes, Mr. Angadi. ಅವ್ರ ಕೈಯಲ್ಲಿ ಎಲ್ಲ ಓದಿಸ್ಬಿಟ್ಟು ಏನೇನ್ ಪೆಟಿಷನ್ ಏನೇನ್ ಡಿಫೆನ್ಸಸ್ ಅಂತ ಎಲ್ಲ ಓದಿಸಿ ಅವ್ರಿಗೆ 8 months ಅಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಇದೆ. NCSM doesn't have any regulation for PG admission. Then what are you making applicable?
We have a new regulation. Serial number 35. PG or UG also. But without there being no CET, the college has no authority to get the admission. They will have to come through.
PG ಗೂ ಇದೆ. Madam, you are dealing with PG also under KEA?
Yes, for the UG.
Only for UG.
It is for the UG. It is for the UG, not for the. We have adopted the earlier rule. That is why.
How have you adopted it?
There is a provision under NCISM Act, unless within 6 months, the NCISM has to.
ಯಾವ provision ಕೊಡಿ? Because if you don't have rules, KEA doesn't accept PG. You don't do counseling for PG.
In remaining seats, they are taken. After counseling, whatever seats remain vacant.
You do counseling for PG. They do counseling for PG.
That is, my lord, by way of annexure E, your lordship may kindly take page number 77. Guidelines, comprehensive guidelines for counseling and admission in undergraduate UG and postgraduate PG courses for Ayurveda, Siddha, so for the academic year 22-23 ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ದಾರೆ. My lord,
Undergraduate and postgraduate.
ಅದೇ, by way of, my lord, guidelines.
Yes.
My lord, NCISM is empowered, my lord, to regulate the mode, manner, and this thing, my lord, of admission, my lord, mode, method, and manner, my lord, by way of only, my lord, regulations, which, my lord, will have to be framed, my lord, by the.
There is an annexure E which has been issued rightly or wrongly. You have not challenged it.
Annexure D, my lord, are not
E.
actually.
Annexure E.
These are only guidelines.
So don't challenge it. Then we'll make the guidelines applicable to you. That's all.
By way of guidelines, my lord, what they say is all admissions in all quotas shall be through counseling conducted by state or company.
Yes. So how do you admit? You are the college?
I am the college, my lord.
College.
College, my lord. two seats, my lord, which were,
So you don't want to follow the NCIM ISM guidelines.
as per, my lord,
You want to follow or you don't want to follow?
we want,
Then follow it.
so far as in this case, what has happened is, now, my lord, previous enactment under the 1970 Act,
Hmm.
management quota and NRI seats, my lord, were directly filled, my lord, by the colleges. So the vacuum, my lord, under my lord, section 59 of my lord new act deals with the transitory provisions, my lord, wherein there are no rules or regulations framed under the new act. The provisions of my lord previous act and the rules and regulations of the previous act would, my lord, apply is what new act says.
That has been held against you. That has been held against you. There are 2-3 judgments
So
on that.
previous,
That cannot be. That transitory previous will apply illa. If there's a guideline which has been issued and if there's a notification which has been issued, making this applicable, which they are entitled to issue guidelines, those guidelines will be applicable and you have to follow it.
they can't do that, my lord, under the provisions of the act.
You're not even challenge this.
They have to do only, my lord, by way of regulations. And under previous, my lord, regime,
Kamali, please understand a simple legal issue. There's a guideline which has been issued. You are not challenging the guidelines. So you have to follow the guidelines. You cannot say, let there be guidelines, I won't follow.
I shall, my lord, seek proper amendment.
That means that your college doesn't need to exist if you are not going to follow the guidelines.
Monday, my lord.
You are bound by NCISM.
Monday, my lord.
All the other students are going through counseling and you want to take students out of counseling.
Only 2 students.
Only 2 or only half. There's no 2 students that you have taken, you have deprived 2 students from KEA.
ಇಲ್ಲ ಅದು mop-up round ಆದ ನಂತರ vacant seats, my lord, were.
We fill up some.
After, my lord,
Same.
all the rounds were over. ಆಮೇಲೆ ಏನಾಗಿದೆ, my lord, very ironic and unfortunate thing. These 2 students who have been admitted, they are highest scorers than the KA allotted students.
Then why did they not go in for the counseling?
ಅದಕ್ಕೆ there are certain issues, my lord, I shall.
Can't be allowed like that, Mr. Mali. There's a system.
These 2 students, my lord, they have secured 137 and 145, my lord, score in AIA PGET. Whereas,
ಒಂದ್ ಕೆಲಸ ಮಾಡ್ತೀವಿ, ಲಿಸ್ಟ್ ಪ್ರಕಾರ ಹೋಗ್ತೀವಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನಾಳೆ ಯಾವ್ದು ಬೇಕಾದ್ರೂ ಒಂದು ಫೈಲ್ ತೆಗೆದು ಕರೀರಿ. ಎಲ್ಲ ಮಲ್ಲಿ ಅವ್ರ ಫೈಲೇ ಇಟ್ಕೊಳ್ಳಿ, ಅದೇ ಕರೀರಿ. Mr. Malli is not prepared. Dismiss. There's a system and a process. If the system is for, now 2 of the students could have come through KEA. We're not on them being meritorious or otherwise. That way everybody will claim. Then what is the system?
academically qualified, registered with, my lord, this AIA PGT appeared, academically qualified, registered online, my lord. Seats were not allotted. 2 seats, my lord, remained vacant. These, my lord, academically qualified.
What is the process for vacant seats?
ಏನಿಲ್ಲ.
ಅದಕ್ಕೇನು ಮಾಡಿಲ್ಲ ಅವರು.
After all rounds of, my lord, seat allotment to.
ಅಲ್ಲಪ್ಪ ಇವಾಗ vacant seats ಇದೆ.
ಅದನ್ನ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಲ್ಲ.
If KEA has not allotted any person, why should the seats go? Why should the seats go vacant?
That is what the.
That is, I fill up my list.
You have to come up with some process. Otherwise, these problems will keep on persisting. You regulation ಮಾಡಿಲ್ಲ, guidelines ಅಂತೀರಾ. Your guidelines challenge ಮಾಡಿಲ್ಲ.
Within 6 months, my lord, this act, particular 220 act, my lord, has come into existence in the year 2020. But the law says that it has, the new rules have to be framed within 6 months of the act of today.
So who is to frame the rules?
NCISM has to.
Why aren't you not doing it?
But we have adopted the earlier regulations, my lord.
Who is the head of NCISM?
My lord, it comes from the Ministry of Ayush.
Chairman, President,
Chairman.
Monday chairman affidavit haki. Why the rules have not been framed till now? Giving rise to all this. No time. So we'll take note of that and then deal with them if they are required to be dealt with, or we'll deal with you. You are the cause for this problem. These are all students' issues which cannot wait,
Recreate the same issues.
which cannot wait. And then colleges will also make merry. 5 lakh rupai per seat. KA ಇಂದ ಹೋದ್ರೆ ಎಷ್ಟು?
It will be lesser only if it was from college.
ಅದು ಜಾಸ್ತಿ ಮಾಡ್ತಾರೆ. The submission of learned counsel for the petitioner is that there are no regulations which have been made under the
NCSA.
2020.
NCISM Act 2020, even though regulations were to be made within 6 months from the act coming into force. And it is in that background that the learned counsel for NCISM would submit that though regulations have not been framed, guidelines have been issued on 14/10/2022, and it is those guidelines which are being followed. Ex facie guidelines cannot have statutory force. The NCISM being required to formulate regulations within 6 months of the act coming into force on date and act. NCISM Act ಇದೆ.
May person.
ಯಾವತ್ತು effect from? National Commission for Indian System of Medicine Act 2020, which came into effect from 21st September 2020. Which is the provision for the regulations? 6 months?
Section 55.
Regulations have to be framed within 6 months ಅಂತ ಎಲ್ಲಿದೆ? Where does it say 6 months?
6 months ಅಂತ ಇಲ್ಲ. 55 my lord enables the NCISM to formulate regulations which will have to be placed.
No regulations have been made. Counsel for NCISM submits that guidelines have been issued on 14/10/2022. The guidelines, in my considered opinion, cannot have any statutory force. In terms of regulation, clause N of subsection 2 of section 55, the commission is by notification required to make regulations consistent with the act and rules as regards the manner of conducting common counseling by the designated authority for admission to the postgraduate seats in all medical institutions under subsection 3 of section 16. No regulations have been made, have been formulated in terms of understanding the rigor of rule-making power under the NCISM Act 2020. Guidelines have been issued by the competent authority, and issued under the direction of the competent authority. Who is the competent authority?
Chairman NCISM.
ಎಲ್ಲಿದೆ ಅದು? Competent authority is not defined under the act. An inquiry as to who the competent authority is, the counsel for respondent for NCISM submit that it is the chairman a perusal of the act does not indicate any particular power vested with the chairman to issue such guidelines. In that background, an affidavit of the chairman is directed to be filed as to how guidelines have been issued without regulations being formulated as indicated above. The affidavit to be filed by Monday, 24th February, released on 24th.
Plus seal number 2. Plus,
Secure it.
my lord,
Saying a short date is granted, taking into consideration that it's the interest of students which is at stake, and the NCISM cannot delay the matter any further.
lord, plus,
That's Bharat.
lord, kind submission, my lord.
ಅವ್ರನ್ನೇ ಕರ್ಸೋಣ.
My lord.
Hmm.
The meantime, if they are permitted to appear the examination,
Yavat exam?
seal number 2, my lord.
Third exam ತಾನೆ.
Yes, third, my lord.
Third, by 24th we'll deal with
24th ಬರುತ್ತೆ
both matters.
Monday.
Serial number 3.
At 2:30 p.m.
Serial number 3.
3 ಏನು?
First petitioner is allotted to KEA. The other two petitioners were not registered with the KEA.
Not registered. ಇದನ್ನು PG ನಾ?
Petitioner number 1 was allotted.
This is also PG.
UG.
UG. Then UG is through KEA.
I filed the application behalf of petition number 3, my lord.
Hmm.
She failed the examination, my lord.
Allappa, they are not even registered with KEA.
Yes, my lord, vacancy we fill up.
produce certified copies.
If they are available online, you can take a printout and say 65B
That's what,
and
same,
use it.
my lords, copies will be uploaded in the law online. So therefore not.
So these are printout from the online. Illa, it's photocopy.
Certified copies were given to me. And I have produced certified copies of all these documents.
And what is the relief you are seeking?
Notes, the grievance is that
Certiorari.
insofar as PODI,
Asking
survey
for
conduct,
certiorari of quashing B series.
yes, B series, as well as my lords, D.
To produce it, in they're correct ones or
Plus, I have produced ones. They are
the
the,
dispute on B series? Counsel for the petitioner has sought for dispensation production of annexure B, B1, B2, B3 and B4. On inquiry with the learned AGA, if there is any dispute with the documents produced, as regard the dispute as regard the veracity and contents of the documents produced by the petitioner at annexure B, B1, B2, B3 and B4, he submits that there is no such dispute. As such, I1 1 of 2024 is allowed. Production of certified copy of annexure B, B1, B2, B3 and B4 is dispensed with.
please. The order, different orders are my lords, B series and that preparation of survey. Lords, based on the application, this your lordship may kindly peruse my lords in page 18. I filed this repetition on mainly on two grounds. One is my lords, the no notice was issued to the my lords petitioner in page 18 and 19. This is the statement my lords given by the respondent number 6 to 8 herein. In the left side my lords in page number 18, ಪಾಣಿದಾರರಾದ ಸುಭಾಷ್ ಚಂದ್ರ ಬೋಸ್ರವರು in the bottom my lords. ಸುಭಾಷ್ ಚಂದ್ರ ಬೋಸ್ ಅವರು ಬೇರೆ ಊರಿಗೆ ಹೋಗಿರುವುದಾಗಿ ತಿಳಿಸಿದ್ದು ಅವರಿಗೆ ಅರ್ಜಿದಾರರು ತಿಳಿಸಿರುತ್ತಾರೆ. And thereafter my lords.
ಯಾರು SS ಬೋಸ್ ಅಂತ ಬರೆದಿದ್ದಾರೆ?
ಎಲ್ಲಿ
ಬರ್ದಿದ್ದಾರೆ ಸರ್.
ಎಲ್ಲಿ?
Page 18.
18 ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ.
ಪಶ್ಚಿಮಕ್ಕೆ ಡಿ ಸುಭಾಷ್ ಚಂದ್ರ ಬೋಸು.
ಅಲ್ಲ ಬರ್ದಿದ್ದಾರೆ. ಬಟ್ ನೋ ನೋಟಿಸ್ ವಾಸ್ ಸರ್ಡ್.
ಅಲ್ಲಿ ಯಾರೋ ಬರೆದ
ಅಲ್ಲ ಯಾರು ಬರ್ದಿರ್ಬೇಕು. ಅದು ಸ್ಕ್ರಾಚ್ ಮಾಡಿದ್ದಾರೆ.
ಸಿಗ್ನೇಚರ್ ಇದೆ.
ಅದೇ ಸ್ಕ್ರಾಚ್ ಮಾಡಿದ್ದಾರೆ. ಇಲ್ಲ ನೋ ನೋಟಿಸ್ ವಾಸ್ ಸರ್ಡ್ ಅಂತ. ಇಲ್ಲಿ ಅವರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ 6 to 8. In the next page my lords, in page 19. After 3-4 lines my lords in the para, RTC ದಾರ ಸುಭಾಷ್ ಚಂದ್ರ ಬೋಸ್ರವರು ಗ್ರಾಮದಲ್ಲಿ ಇರುವುದಿಲ್ಲ ಹಾಗೂ ಅವರು ನನ್ನ ತಮ್ಮನವರಾಗಿದ್ದು ಅವರಿಗೆ ನಾನೇ ತಿಳಿಸಿರುತ್ತೇನೆ. ಭೂಮಾಪಕರು ಈ ದಿನದಂದು ಅಳತೆಗೆ ಬಂದಾಗ ಅಳತೆ ವೇಳೆ ನಾವುಗಳು ಹಾಜರಿದ್ದುಕೊಂಡು ನಮ್ಮಗಳ ಅನುಭವ ಹಾಗೂ ಈ ಹಿಂದೆ ಪೋಡಿ ಆಗಿದ್ದು ಅದರಲ್ಲಿ ನನ್ನ ಮಗನಾದ ಸೋ ಅಂಡ್ ಸೋ ಗುಂಟೆ ಖರೀದಿ ಮಾಡಿರುವುದಾಗಿ ತಿಳಿಸಿ ಅದರಂತೆ ಲೆವೆನಿ ಸ್ಕೆಚ್ ಮಾಡಲು ತಿಳಿಸಿರುತ್ತೇವೆ ಹಾಗೂ ಇದರಲ್ಲಿ ಏನೇ ತಂಟೆ ತಕರಾರು ಬಂದರೂ ಅದಕ್ಕೆ ನಾವೇ ಜವಾಬ್ದಾರಾಗಿರುತ್ತೇವೆ ಎಂದು ಗ್ರಾಮಸ್ಥರ ಸಮಕ್ಷಮ ಹೇಳಿ ಬರೆಸಿ.
Petitioner is before this court seeking for the following relief. The grievance of the petitioner is that the survey records have been prepared after measurement of the properties and a Lebanese sketch has been issued without notice having been issued to the petitioner, who is a neighboring landowner. And as such, he submits that the survey sketch which has been prepared is not proper and correct. The said survey sketch also impinges on the property of the petitioner. Having perused annexure B series, the Mazer, the statement recorded of the persons and the Mazer, it is seen that there is a categorical statement made that the petitioner has gone out of town and is not available. And a statement has been made by your statement.
Respondent number 6 to 8 my lords.
6 to 8.
Brother.
Respondent number 6 to 8.
Yes.
That the petitioner is their brother and that they will keep him informed. The survey sketch having been prepared on the basis of an application made by respondent number 6 to 8. Their statement could not have been accepted. Survey carried out and form Lebanese sketch issued. In that view of the matter, there being a violation of the principles of natural justice, I pass the following order. Writ petition is allowed, a certiorari is issued, the order dated 13/8/24, passed by respondent number 1 at annexure D is quashed. A certiorari is issued, the impugned survey records bearing number so and so at annexure B, B1, B2, B3 and B4 are quashed. The matter is remitted to respondent number 5 for carrying out a fresh survey. Respondent number 3 for carrying out a fresh survey after issuance of proper notice to all concerned, including the petitioners, and thereafter carrying out the survey in the presence of all concerned and processing the applications filed by respondent number 6 to 8.
Please, much.
7, Anandar Kolli.
Petitioner marks. The petitioner challenging the impugned endorsement issued by the respondent number 2, wide annexure B. So the father of the petitioner.
B ಗೆ dispensation ಕೇಳಿದ್ದೀರಾ? ಹೆಂಗ್ ಬಂತಿದ್ದು B ನಿಮ್ಗೆ?
Xerox ಇದೆ.
ಏನ್ ಕೊಟ್ರು ನಿಮ್ಗೆ?
Endorsement marks.
ಯಾರು ಕೊಟ್ರಪ್ಪ? ಏನ್ ಕೊಟ್ರು? ಫೋಟೋ ಕಾಪಿನ ಕೊಟ್ರ? Undertakes to produce within 4 weeks.
Yes.
Accepting the reasons stated in support of IA 1 or 25, the petitioner is granted 4 weeks time to produce the original of annexure B. IA 1 of 25 is kept pending till then. Yes.
The petitioner challenging the impugned endorsement issued by the respondent number 2, wide annexure B. So the father of the petitioner was in cultivation of the property bearing survey number 28/1. The land has been granted in favor of the father of the petitioner in the year 3/1/1991. The third party has, the authority has mutation entry, change in the mutation, so in favor of the third parties. That's
It's a forest land anತಾರೆ.
In
But,
column
the,
number 10, your lordship, it
in-
is mentioned annexure A. It is reserved forest land.
but ಸರ್ಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ ಅಂತ ಮಾಡಿ ಸರ್ 31/1991 ಮಾಡ್ಸ್ ಪೇಜ್ ನಂಬರ್ 10 ಮಾಡ್ಸ್ annexure A ನಮ್ಮ ರೆಫರೆನ್ಸ್ ನಂಬರ್ ಹಾಕಿದ್ದಾರೆ
Please,
ಸ್ವಾಮಿ.
ಕರ್ನಾಟಕ ಸರ್ಕಾರ ನಿಮ್ಮ ಹೆಸರಲ್ಲ.
ಅಲ್ಲ, ಸರ್ಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ ಅಂತ ಕೆಳಗಡೆ ಇದೆ ಸ್ವಾಮಿ, ಕಾಲಮ್ ನಂಬರ್ 10 ದಲ್ಲಿ
Annexure A, your lordship.
annexure ಪೇಜ್ ನಂಬರ್ 10 ಮಾಡ್ಸ್.
ಪೆರಂಬೋ ಕರ್ನಾಟಕ ಸರ್ಕಾರ ನಿಮ್ಮ ಹೆಸರಲ್ಲಿದೆ. Where is your name?
ಅಲ್ಲ 3/1/1991 ದಲ್ಲಿ ನಮಗೆ ಅಲರ್ಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಲ್ಯಾಂಡ್.
ಆರ್ಡರ್ ಎಲ್ಲಪ್ಪ 3191 ಆರ್ಡರ್ ನೀವು ರೆಫರೆನ್ಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು.
RTC ಅಲ್ಲಿ ಆ ರೆಫರೆನ್ಸ್ ಗಳಲ್ಲಿ ಇರೋದು ಪೆರಂಬೋಕು ಕರ್ನಾಟಕ ಸರ್ಕಾರ 788-22
ಇನ್ನು ಓಲಸ್ ಕಲಂ
ಅರಣ್ಯ ನಿಮ್ಮ ಹೆಸರಲ್ಲೂ ಇಲ್ಲ.
ಅಲ್ಲ, ಕಬ್ಜೆ ಅಥವಾ ಸ್ವಾಧೀನ ಕಾಲಮ್ ನಂಬರ್ 10 ದಲ್ಲಿ ನಮ್ಮ ರೆಫರೆನ್ಸ್ ನಂಬರ್ ಹಾಕಿದ್ದಾರೆ 3/1/1991 ಅಲ್ಲಿ.
ಪ್ರತಾಪ್ ಸಿಂಗ್
ಎಸ್
ಕರ್ಕೂರು ರಾಮಪ್ಪ ತಂದೆ ಭೀಮಪ್ಪ ತಾಯಿ ಇದೆಲ್ಲ ಏನಿದೆ? ಕಾಲಮ್ 12 ಅಲ್ಲಿ ಯಾಕಿದೆ ಮಿಸ್ಟರ್?
ಅವ್ರು ರಾಂಗ್ ಆಗಿದೆ.
According to them, your lordship, the land was granted in their 1991. Annexure A, your lordship, produced by them of 2001-2002, record of rights. In between, your lordship, they have not produced any documents regarding that aspect. After
Where is that ಸರ್ಕಾರಿ ಆದೇಶ? Forest land, you're not going to incline on forest land. And AGA accepts notice for respondent number 1 and 2. Counsel for the petitioner seeks fund is granted 10 days time to produce the government order dated 3/1/1991 under which the petitioner claims a grant of land has been made in favor of the father of the petitioner. Learned AGA is also called upon to offer an explanation as to why the names of several persons have been entered into in column number 12 of the RTC at annexure A. Relist on 10th March.
Please.
8, PM Patil.
Please, my lord, I beg to appear for the petitioner. My lord, the grandfather of the petitioner, my lord, was the tenant, and he filed a form number 7 claiming occupancy rights in respect of 4 survey numbers. And so for 3 survey number is
Concerning an order of 1980.
Yes, my lord. my lord, what has happened is, my lord, record of rights, annexure A to D, your lordship kindly see. The petitioner name is appearing in the column number, my lord, 12.
What I've been doing for the last 45 years.
Yes, my lord, what has happened is, and even before this, my lord, I have produced the annexure F to, my lord, my name is appearing. So they are, my lord, tribal people, the Lambani, the illiterates, my lord, they thought that, my lord, they are the occupancy has been right, including that earlier has been granted to other 3 survey numbers. My lord, so for this, my lord, that Devasthana Inam, so rejected. My lord, it's hit by, my lord, 126 of the Land Reforms Act.
And now after 45 years.
Yes, my lord,
we-
illiterate, my lord. They are very illiterate. Your lordship, kindly see, Lambani, the constitutional, my lord, under the, my lord, the constitution, my lord, they have, my lord, rights to.
Form 7 has been rejected.
So far, 3 survey numbers, he is a different landlord, and the occupancy rights has been granted. So for this survey number 13 is concerned, my lord, that has been Devasthaninam, statement Devasthaninam, so it is rejected. But record of rights shows that, my lord, is a crop sharing, my lord. He was cultivating, giving a crop share. And my lord, he was used to pay this one, and the
In petition, there's not one whisper as to why there's a delay. Not one line.
I have stated, my lord, in paragraph, my lord, I have stated in paragraph 7, my lord. 7. My lord, 7, it is submitted a petitioners or belongs to the scheduled tribes, Lambani, which state caste comes under so and so. The petitioner hails from Lambani, Banjara, which is backward class in constitution and also illiterate. The petitioner did not know the order passed by the land tribunal wherein the tribunal has rejected the grant of occupancy in respect of survey number 13, so and so. A further record of rights shows since 1951 and 1988. The name of the grandfather.
Why did you verify the records now?
And my lord, even my name is appearing up to, my lord, 2024. Record of rights I have produced, my lord.
No, Mr. Patil, not.
My lord, because, my lord.
5 years cannot be disturbed on the basis of you claiming to be illiterate.
No, my lord, what has happened is, even the record of rights, your lordship kindly see the record of rights. F to F, your lordship, my name is my father name is appearing 24, up to 24, your lordship.
Yes, Mr. Patil, that was way back in 73, ATL, it has been rejected. That has been considered and rejected from 80.
But law, my lord, Inam lands is concerned, that, my lord, illegal order. And even the tenant can claim occupancy rights.
The order has to be challenged within a time.
Papa, Lambani Jana, my lord. Let the notice, now they are disturbing, my lord.
No, no, not at this stage of 45 years. Learned AGI accepts notice for respondent 1 and 2. Notice to respondent 3 is dispensed with in view of proposed order to be passed. Petitioner is before this court seeking for the following reliefs. What is challenged is an order of the land tribunal dated 3/12/1980 at annexure L, rejecting the application filed by the petitioners for grant of petitioner's father for grant of occupancy rights in form number 7.
Insofar as
grandfather.
No, grandfather.
The peril of the petition itself indicates that during the lifetime of the grandfather, he did not challenge the said rejection of Form 7, nor did the father of the petition challenge it. It is only the petitioners who have now come forward to challenge the said rejection order passed in the year 1980 on the ground that the petitioners are illiterate and did not know about the rejection. I am unable to accept the said contention of the petitioners inasmuch as the order having been passed on 3/12/1980, action has been taken thereafter, and the petitioner cannot seek to unsettle all the actions taken from 1980 to 2020 to the year 2025 over a period of 45 years. In that view of the matter, the petition being hit by the principles of delay and laches, apart from limitation, the petition stands dismissed.
Please.
AGA 1 and 2.
9, Girish Dharwad.
My lords, it may kindly be taken on Tuesday. Senior is out of station.
It is the discretion of the court to appoint a commissioner. At the request of counsel for the petitioner, relist on
Tuesday, my lords.
the grievance of the petitioner in the present matter is that a court commissioner has been appointed by the court when the matter was posted for argument stage, so moto, and as such it is contended the said court did not have the powers to do so. At the request of counsel for the petitioner, relist on 25th February.
Obliged,
We'll
my
be
lords.
dismissing it on that day. ನೀವಿದ್ದೀರಾ ಅಂತಿಲ್ಲ. Senior ಬಂದಾಗ dismiss ಮಾಡಿ.
Yes.
10, R.H. Changdi.
The petitioner is a mobile company, my lordship, which has installed the mobile tower by virtue of the license granted as per Annexure G, my lordship. And that was issued on 17/8/2024 as per Annexure G. And abruptly on 5/12/2024 as per Annexure A, they have cancelled the license which was issued, stating that we should not make further constructions since the neighbors have raised some objections for erection of the tower, my lordship.
Yes.
That is page number 12, my lordship, Annexure A.
Yes, if the neighbors have objected, you can't construct.
No, my lordship. Since
Get there no objection, then we'll consider it.
initially when license was issued, my lordship, that is as per Annexure G.
We submitted there no objection.
Yes, my lordship.
Where is there no objection?
Annexure G, my lordship.
Annexure G is not a
License, my lordship.
license. Where is the no objection? The
After
neighbors.
obtaining the license only, my lordship.
Where is the no objection from the neighbors?
That is also not required, my lordship. In view of the, that is circular issued by the state of Karnataka to facilitate the infrastructures, my lordship.
Where is the circular?
Yes, my lordship. Kindly turn to Annexure E,
No
page number
objection is
30.
not required.
Annexure E, page number 30, my lordship. Only permission of the local body is required, my lordship. And as per the circular, schedule E, page number 52. Some conditions have been imposed.
Item 6 is assessment of measures to ensure public safety and inconvenience of the public
Yes,
is
yes,
likely to be
Manoj.
put to
Yes.
in consequence of the work proposed and the measures to mitigate such inconvenience
Yes.
indicated by the permission holder. That means the other persons have to give no objection.
No, that is not a condition, my lordship. The mode and time of duration for execution of the work.
If you are
The
going to
inconvenience-
satisfy clause 6 and mitigate,
But kindly turn to page number 52, schedule E, my lordship. These are the document to be submitted for erection of a telecommunication tower. Schedule E, my lordship. Page number 52.
item number 8,
Yes, ma'am.
the inconvenience that is likely to be caused to the public.
Seven.
and specific measures
The inconvenience that is likely to be caused to the public
mitigate.
and the specific measures proposed to be taken to mitigate such inconvenience. And 8 is the measures proposed to be taken to ensure public safety during the
What have
execution
we
of the
given on
work.
that? What have we
A
given? on
responsibility has been,
that? What have we given on that?
no, but so far as erection is concerned, my lordship, all the measures have been taken to erect in the property owned by,
No, not what the public feels, Mr. Angadi.
no, that we
You cannot
totally
write
not
rock
causing
star.
any inconvenience to the public, my lordship. Erection of a mobile tower will not cause any
Given the
inconvenience.
objections. Who has given the objection?
Neighbor millards have given the objection.
Make them a party.
No, no such persons have been stated in their, that is a cancellation letter, my lord.
Objections.
I don't have not, but they have sent
Give the
through.
details.
Please,
Make them a party.
please, I will give him the copy.
The contention of the petitioner is that the respondent has cancelled a license issued to the petitioner for setting up of a mobile tower on
For
the basis
erection.
of,
For erection of the,
for erection of a mobile tower.
yes,
On the basis of complaints received from the neighbors. The submission of Shri R.H. Angdi at this stage is that the neighbors cannot object and or their objections cannot be taken into consideration
For erection of a mobile
by
tower.
the respondent
Since it is not causing any health,
once a license has been granted.
yes.
At this stage, I am unable to agree with the said submission inasmuch as in terms of Rule 8 of bylaw 8 of the Bruhat Bangalore Mahanagar Palike and Karnataka Municipal Corporations, telecommunication infrastructure and underground optical fiber cable rules stroke bylaws 2021 and the Karnataka Municipalities telecommunication infrastructure and underground optical fiber cable rules stroke bylaws 2021, page 31. The grant of permission by the appropriate authority stroke urban local body is post the assessment of measures to ensure public safety and inconvenience that the public is likely to be put to in consequence of the work proposed and the measures to mitigate such inconvenience indicated by the permission holder in terms of clause 6, Roman 6 of Rule 8. A perusal of Schedule E, which indicates the list of documents to be submitted for erection of telecommunication tower at clause small 7 and Roman 8 indicate that the inconvenience that is likely to be caused to the public and the specific measures proposed to be taken to mitigate such inconvenience and the measures proposed to be taken to ensure public safety during the execution of the work had to be provided along with the application. These, when taken into consideration, would indicate that if there is any objection by the neighbors and or the general public, the same would have to be considered and the petitioner who seeks for permission has to ensure that no inconvenience is caused and or mitigate such inconvenience. And this aspect would have to be considered by the authority before granting of permission. In the present case, the neighbors having raised.
Not neighbors, they have stated Sarvajanikaru, that is public.
public, general,
Neighbor or public?
Public.
general public.
That the public having raised objections, the concerned persons who have raised objections would be required to be made as parties to these proceedings. Learned counsel for respondent is directed to furnish the details thereof to the counsel for the petitioner to do the needful. Released on 25th March.
Please.
As far as that copy is could you?
Please.
In fact, in the annexure A, what we have stated, ಕಾರಣ ಸದರಿ ತಕರಾರು ಇತ್ಯರ್ಥ ಆಗೋವರಿಗೆ ಟವರ್ ಅನ್ನು ನಿರ್ಮಿಸಬಾರದೆಂದು ಈ ಮೂಲಕ ತಮಗೆ ತಿಳಿಸಿದೆ. ಇಟ್ ಇಸ್ ಓನ್ಲಿ ಶೋಕಾಸ್ ನೋಟಿಸ್. He has to give.
ಇತ್ಯರ್ಥ ಮಾಡೋದು ಅವ್ರಿಗೆ ಕೊಡಬೇಕಲ್ಲ ನೀವು.
ಅಲ್ಲ, if he has come and appear, they would have given. It is only, of course, ಅಲ್ಲಿವರೆಗೆ ಮಾಡಬೇಡ್ರಿ ಅಂತ ಹೇಳಿದಾರೆ ಅವರು.
ಕೊಡಿ, objection copy ಕೊಡಿ.
Yes, I will.
If the objections are genuine, we'll have to consider.
Yes, yes,
If
ultimately.
that is only to trouble.
Yes, yes, his intention is otherwise, then.
In the rural area, what has happened nowadays?
I also asked them.
One person will be making a license, that is an agreement. Thereafter, the neighboring persons will be making a event cry stating that he will be benefited by that erection of tower. That is going on in the villages, my lord.
We'll have to consider it. We can't paint everything with the same brush. ನೀವು ಎಲ್ಲ ಮಾಡ್ತಾ
There
ಇದ್ದೀರಾ
are
ಅಂತ ಹೇಳಿ.
judgments on the point, erection of mobile tower will not cause any, that is injury to the health also, my lord.
may not be on the health, it may
Safety
be
measures
on
has to be taken.
ingress and egress. It could be on so many things, waterways, there's so many issues.
Please, please, please,
Let us see what the objection is.
please, please.
11, Vinay Kausalgi.
Kaujalgi?
Lord, they are seeking for quashing of the layout plan, and also further proceedings pursuant to that. My lord, at annexure D, page 29, it is only a temporary approval that has been issued by the respondent number 2 authority.
Temporary ಹೆಂಗ್ ಬರುತ್ತೆ?
ಅಲ್ಲಲ್ಲ, ಅವ್ರು ಬರ್ದಿರೋದು ಅದ್ರಾಗೆ.
Temporarily layout ಮಾಡ್ಬಿಟ್ಟು
ತಾತ್ಕಾಲಿಕ ವಸತಿ ವಿನ್ಯಾಸಕ್ಕೆ ಕೆಳಗೊಂಡ ಷರತ್ತುಗಳನ್ನು ಅನುಗುಣವಾಗಿ ಕಾರ್ಯರೂಪಕ್ಕೆ ತರಲು ತಾಂತ್ರಿಕ ಅನುಮೋದನೆ ನೀಡಲಾಗಿದೆ.
ಎಲ್ಲ ಲೇಔಟ್ ಫುಲ್ ಇದೆ ಅಲ್ಲ, ಚೇಂಜ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಯೂಸ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಆಗಿಲ್ಲ, ಇನ್ನೂ ಏನಾಗಿಲ್ಲ.
ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಹಿಂಗೆ. Issue notice, land AGA accepts notice for respond number
1 and 4.
and 4.
R2 B Sharanu Baswa.
P. Sharanabasava for 2, Gurudev Gachinmat for 3. Issue notice to respond number 5 and 6, returnable by 26th March. The respond number
Allah, they claim the right only on the basis of the decree.
2 to 4 are restrained from respond number 5 and 6 are restrained from carrying out any works in persons of order dated 29/1/2025 bearing number so and so, produced at annexure D till the next date of hearing. Process fee and copies to be furnished by end of day 21st, failing which the interim order will stand automatically vacated.
12, see has still open.
Lord, so defense writ
My Lord,
petition.
I appear for caveat.
The trial court, my lord, rejected the temporary injunction filed by the respondents on the ground that the plaintiff has not proved prima facie a case regarding the alleged cart road, my lord. The first appellate court, though observed, my lord, your lordship may kindly first appellate court order at page 33, my lord, in page 16.
Yes.
8th line, my lord, the fact remains. In page 16, page 33. The fact remains that the boundaries of the sale deed of the plaintiffs do not indicate existence of any access road to reach the property purchased by them from the defendant number 1. All the 4 corner boundaries indicate the properties of third parties, including the remaining portion of the defendant number 4. Therefore, one has to understand how the plaintiffs have been given access point to reach their purchased land. So next page 17, my lord, after about, my lord, six lines. Therefore, the said fact requires a comprehensive trial. They have not sought for a declaration of easementary rights also.
You have sold the property.
Yes, my lord.
From where will the access be?
Please, my lord.
From ಎಲ್ಲಿಂದ access ಎಲ್ಲಿಂದ ಇರಬೇಕು?
Yes, my lord. And the property.
Access ತೋರಿಸಿ, ನೀವೇ ತೋರಿಸಿ ಎಲ್ಲಿದೆ ಅಂತ access.
Access, my lord, I have produced a map at page 106.
106.
Yes. They claim that 2 plus 3 bar A, my lord.
2 plus 3 bar A. Yes.
Yes, my lord. The sold by defendant number 1, who is the owner of 4A, my lord. 4A.
4A.
Yes, my lord. And this 5 plus 6 bar 1, my lord, is not at all, my lord, the ownership of defendant number 1. It is the property of defendant number 5, which has been acquired by him, my lord, through her grandmother, who has relinquished her rights. This party, defendant number 5, is not a party to the sale deed. So he cannot give a road, my lord, towards my side.
The road is through 4 bar A or through 5 plus 6 bar 1?
2 plus 3 oblique A, 5 bar 6 bar A.
Where is the application?
Please. So page 79, my lord. Plaint is schedule is page 61, my lord.
61 is 61.
61 is page 61, my lord. 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 61 is page and it is as good as a main relief itself, my lord, seeking permanent injunction.
Yes, sometimes it is so.
So, my lord, when defendant number 5 is not a party to the sale deed executed by defendant number 1, how can, my lord, he create a road, my lord, in
Cart track, cart passing, to approach the above said through a cart road passing in his other land bearing RS number 50. Plus 5 plus 6.
The 50 plus 5 plus 6 is of defendant number 5, who is not a party to the sale deed, my lord.
Defend number 5 not a party to the sale deed.
Yes, my lord.
Neevu yaro?
Lord,
Who are you for?
defendant number 1 to 5, my lord.
You are appearing for 5 also
Yes,
together.
my lord. My point is, when they claim that suit cart road through my land, based on the alleged recital in the sale deed, which has been executed by defendant number 1.
The access
Yes.
through to the suit property.
Yes.
In 2 plus 3 A.
Yes, my lord.
Is through 5 plus 6 bar 1.
Yes, my lord. That belongs to defendant number 5.
The cart track. Cart track is a public road.
It is not a public. There is no road at all. They have not produced any corroborative document except sale deed. And I have also purchased the property from my original owner, which also does not contain a recital regarding the road. It is not my ancestral property. I have purchased the property from the different owner, my lord, which does not depict the cart road, my lord. How can I give, my lord, a cart road to the defendant number 5, the plaintiffs, my lord? Except this, my lord.
What basis do you claim the cart road, Mr. Dudley? Is there a village map? Is it reflected in the village?
Yes, my lord, a sale deed is of the 2003. Now the extract of the, my lord, sale deed, my lord, recitals is, my lord, extracted by the trial court on page 29.
29.
Yes, my lord. In page 12 of the appellate court. May I read, my lords?
Yes.
E pura port hissa number the pura bhumiyu. This is sale deed executed by, my lord, the petitioner number 1. E pura port hissa number the pura bhumiyu ನನ್ನ ಮಾಲ್ಕಿ ಭೂಮಿ ಇದ್ದು ಇದರ ಪೈಕಿ 2 ಎಕರೆ 20 ಗುಂಟೆ ಕ್ಷೇತ್ರದ ಭೂಮಿ ಇದು ಪೂರಾ ಮತ್ತು ಇದಕ್ಕೆ ಹೋಗಿ ಬರುವ ಸಲುವಾಗಿ ಪಶ್ಚಿಮ ದಿಕ್ಕಿಗೆ ನಿಮ್ಮ ಮಾಲ್ಕಿ ರೀಸ ನಂಬರ್ 50/4 ನೇ ನಂಬರ್ ಭೂಮಿಯವರೆಗೂ ಚಕ್ಕಡಿ ಗಾಡಿಯ ರಸ್ತೆಯ ಹಕ್ಕನ್ನು ಸಹ ಕೊಟ್ಟಿದ್ದು ಅದೇ. ಈ ಪ್ರಕಾರ ಭೂಮಿಗೆ ಚಕಬಂದಿ ಈ ಕೆಳಗೆ ಬರೆದ ಪ್ರಕಾರ ಇದೆ. So my lord, there is a clear recital in the sale deed, my lord, having given the, my lord, the right to, my lord, ingress and egress of cart, my lord, to harvest the, my lord, the sugar cane. My lord, this was executed in the year 2003. All the 20 years, my lord, they never disputed. Now, my lord, the crop standing sugar cane crop, when at the verge of, my lord, harvesting, my lord, they are obstructing. The sale deed was never disputed. The recitals were never questioned.
Your lordship may kindly see the photographs.
And
109.
one more submission,
Page
my lord,
109.
I will conclude.
The,
I will
the
conclude.
land 50 bar,
Page
50 bar 6,
38.
my lord.
Let
Page
him
38 of,
complete.
my
38.
lord, page 38 impugned order.
Yes.
Lordship may kindly see. The IA number 1 filed by appellant plaintiffs in the said suit bearing is hereby allowed with following conditions. The plaintiff shall execute indemnity bond before trial court by undertaking the following conditions: that they will use the cart road shown in the sketch for a limited period of 1 year from the date of order, and meanwhile they will assist the court in final disposal of the suit. They will pay compensatory cost of rupees 1 lakh to the defendants if they fail to succeed in the suit. They will not use more than the width of cart of said land of defendants for a period of 1 year. Now, this observation and undertaking is, my lord, is imposed on me, my lord, taking into consideration, my lord, the standing sugarcane crop, which is at the verge of harvesting. If, my lord, if the impugned order is, my lord, is interfered, my lord, my 2 acre 20 guntas, my lord, standing sugarcane crop, my lord, will going to waste, my lord. And I am not, my lord, claiming on any, my lord, it is that there is no right given to me, or there is a right given to me in the sale deed, my lord. And it is up to 20 years it has been used. Now, my lord, they are obstructing.
Yes.
Lord, photographs, your lordship may kindly see annexure M. This 50/6 is on the high, upper side, my lord. How can he create, my lord, say that there is a road? Now, my lord, during pendency, your lordship may kindly see. Now they have come with GCB for forming the road. By virtue of the impugned order, your lordship may kindly see. Now, my lord, yesterday they have come with the JCB and all for forming the road. If there is a road, my lord, there was no necessity at all, my lord.
My lord, the road is being, my lord, strengthened to, my lord, move the, my lord, the sugar cane. My lord, straight away we cannot.
To inspect today. Yes. And submit a report tomorrow.
Please, sorry, my lord.
The jurisdictional ADLR is directed to cause an inspection of the property bearing RS number 50/2+3/A2 and 50/5+6A of Nagar Munoli village. Yav taluka na?
Chikkodi taluk.
Chikkodi taluka, Belgavi district.
Belgavi.
RS number 50/2+3/A, now numbered as RS number 50/2+3/A1 and 50/15, as also the property bearing survey number 50/5+6 capital A. Ade number agidya matte?
The same number, 50/6+A. 50/5+6A.
52+3A/2 is now.
Your lordship is right. Earlier it was 50/2+3. Now after dividing, my lord, it is.
Page 57, my lord.
A bar and
Page
A1.
57. 57 and not
Yes.
sir, but the way it is put across is
50, my lord, 2+3/A+2, 50/5+6.
cause the inspection of
My sketch
survey
is
number
a
50/2+3/A, now numbered as RS 50/2+3/A1 and 50/15, as also the property bearing RS number 50/5+6 capital A and RS 50/2+3/A/2 of Nagar Munoli village, Chikkodi Taluk, Belgavi district, to ascertain if there is an existence of a cart track, if so, the length and width thereof, with a sketch being produced along with the said inspection report. The inspection to be carried out commencing from 10:30 a.m. on 20th February, report to be submitted by 24th February. Since the order is passed in the presence of the petitioner and the respondent, there would be no requirement for issuance of any notice to the petitioners or to any of the petitioners or any of the respondents.
Please.
Lord,
on 20th, my lord.
If the parties, if the petitioner and the respondents choose to participate in the said inspection and survey, they are free to do so. Not participating will not entitle them any equities. In the event of either of the petitioners or the respondents not permitting this ADLR to carry out the said survey and inspection, the jurisdictional police to provide necessary assistance and security to the ADLR. Learned AGA is directed to communicate the above order to the ADLR and the jurisdictional police for necessary and effective implementation. Relist on 24th at 2:30 p.m.
Lord, till then, Lord, not to, Lord. Now they have come with the JCB and all. If they create new road, if the report, my lord, it amounts to, my lord, collection of evidence.
The jurisdictional police are directed to ensure that the status quo of the property is not changed till
24.
till orders are passed by this court. This said order, the above order is effective immediately to be communicated to the jurisdictional station house officer.
Please.
Lord, may I seek for hand delivery? May I seek,
And delivery order.
please?
13, Nandish Patil.
Petitioner. My lord, acquisition under the National Highways Act, my lord. My lord, acquisition under the National Highways Act, my lord. The petitioner, my lord, is the owner of RS number 55/1, my lord, measuring 4 acres, 38 guntas. My lord, initially, my lord, on 27/12/22, my lord, there was one notification that was issued, my lord, for expansion of Hubli-Dharwad bypass, my lord. My lord, we did not object for that, my lord. In that, my lord, 145 square meters were, my lord, sought to be acquired.
What are the grounds?
My lord, please, one ground is, my lord, that your lordship may kindly see, my lord, initial 3D notification, my lord, we did not object. Pursuant to which, my lord, the acquisition was completed. The road construction also is completed. Your lordship may kindly see, my lord, the photographs.
So jute factory, already Barangor jute factory.
That is one ground, my lord. Other than that, my lord, your lordship may kindly see page 50, my lord. I have produced the photographs. My lord, under one notification, my lord, the entire expansion is completed. The service road is also formed. The drainage, the barricading, everything is completed, my lord. Now, my lord, on 22/1/2025, my lord, I gave them a request, my lord, saying that there is another notification which they ought to drop it, my lord. Suddenly, my lord, the NHI is saying, no, we are going ahead with that also. And my lord has issued a notice for collection of the compensation.
DGA accepts notice for respond number 3. 2 Gyaro.
BP Matpati.
BP Matpati for respond number 2. MB Kanvi for respond number 1. Counsel for the petitioner served 2 sets of the petition along with annexes on the said counsels. Relist on 24th.
Lord, may I request for an interim order?
No interim order.
Lord, your lordship may kindly see, my lord, page 50, your lordship may.
Hear them and pass order.
Lord,
It's a project
they're
which
trying
is
to take
happening.
possession, my lord. At least let them
If
not
they
take
take the
possession.
possession, we'll give it back to you if you succeed.
Lord,
But
your
if you
lordship
don't
may
succeed,
record.
the road will come to a
Lord,
standstill.
I'll just show your lordship. Otherwise, I will not insist, my lord. Your lordship may kindly see the notifications. Very next day, one notification, my lord, is dated 27/12/22.
So Nandish, we are having it on Monday.
Please,
If they take possession, we'll return it
Please,
back to you.
Lord, in the same stage, my lord. In the same stage.
Preliminary hearing.
Please, oblige.
Sonu Suhel.
I am for petitioner, my lord.
Yes.
Writ of mandamus, my lord. Petitioner seeking direction to the respondent number 3 to consider the report of the respondent number 4, my lord. Wide annexure L. Respondent number L, annexure L, my lord. It is a land availability report, my lord. Petitioner is a original residence of the Sidrali village, my lord. They are refuse of Ghataprabha Dam backwater. The petitioner has lost his house and entire property, my lord. After they are shifted to Prabhunagar village of Kanapura Taluk, district Belgavi, my lord. It is submitted that, my lord, the authority has granted land to the petitioner in RS number 79 measuring 5 acres, 8 guntas of Katgalli village of Kanapur village, my lord. At the request of the petitioner, authority entered the name of the petitioners, my lord. After they entered the name of the petitioner, my lord, some unknown persons complaint regarding the complaint, authority challenge the MV number mutation entry, my lord. Respondent number 2 and 3 challenge the mutation entry, my lord. What RS number 79 measuring 5 acres in 8 gunta ide alla, my lord. Respondent number 2 and 3 ಅದನ್ನ MV number ನ ಎರಡು ಚಾಲೆಂಜ್ ಮಾಡಿ ಅಗೇನ್ಸ್ಟ್ ಪಿಟಿಷನರ್ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ, my lord. ಆಮೇಲೆ 2021 ನಲ್ಲಿ ಪಿಟಿಷನರ್ ರಿಟ್ ಅನ್ನ ಫೈಲ್ ಮಾಡ್ತಾರೆ, my lord. ರಿಟ್ ಅಲೋ ಆಗುತ್ತೆ, my lord. ಕೈಂಡ್ಲಿ ಪೇಜ್ ನಂಬರ್ 28 annexure C, my lord.
Yes, really.
My lord, sorry, kindly page number 17, my lord. 17. The writ petition is allowed. The order dated 2/8/2021 passed by the third respondent in so and so wide annexure C, and the order dated 29/5/2014 passed by the second respondent in so and so wide annexure D ad quashed, the matter is remanded to the Assistant Commissioner to the hold a fresh inquiry in accordance with law, taking into consideration the B report filed by the investing officer in crime number 19/2015, registered by the Khanapur police station, and also the documents relating to the land in question, which were summoned by the investing officer from the custody of the special land acquisition officer, Hidakal Dam, and thereafter passed the appropriate order ಅಂತ ಆರ್ಡರ್ ಆಗುತ್ತೆ ಮೇಡಮ್. ಆಫ್ಟರ್ ದಿಸ್ ಆರ್ಡರ್ ಮೇಲಾರ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3 ರಿಪೋರ್ಟ್ ಅನ್ನ ಫೈಲ್ ಮಾಡ್ತಾರೆ ಮೇಲಾರ್ಡ್. ಮೇಲಾರ್ಡ್ ಕೈಂಡ್ಲಿ ಪೇಜ್ ನಂಬರ್ 25 ಮೇಲಾರ್ಡ್.
Yes.
25 ಮೇಲಾರ್ಡ್ ಫಸ್ಟ್ ಪ್ಯಾರಾ. ಅದರ ಅರ್ಜಿದಾರರಾದ ಶ್ರೀ ರುದ್ರಪ್ಪ ಭೀಮಪ್ಪ ಕೊನ್ನೂರಿ ಮತ್ತು ಶ್ರೀ ಬಾಳಪ್ಪ ರಾಮಪ್ಪ ಕೊನ್ನೂರಿ ಇವರು ಮೂಲತಃ ಹುಕ್ಕೇರಿ ತಾಲೂಕಿನ ಶಿದ್ಲಿಹಾಳ ಗ್ರಾಮದ ರಹವಾಸಿಗಳಾಗಿದ್ದು, ಹಿಡಕಲ್ ಜಲಾಶಯ ಹಿನ್ನೀರಿನಿಂದಾಗಿ ಶಿದ್ಲಹಳ್ಳ ಪೂರ್ವ ಗ್ರಾಮವು ಮುಳುಗಡೆ ಆಗಿದ್ದು, ಅರ್ಜಿದಾರರು ತಾವು ಹೊಂದಿದ ಆಸ್ತಿಯನ್ನು ಕಳೆದುಕೊಂಡಿದ್ದು ನಿರಾಶ್ರಿತರಾಗಿರುತ್ತಾರೆ ಎಂಬುದನ್ನು ತಹಸೀಲ್ದಾರ್ ಖಾನಾಪುರ ಇವರಾಗಲಿ ಅಥವಾ ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನ ಅಧಿಕಾರಿಗಳು ಹಿಡಕಲ್ ಡ್ಯಾಂ ಇವರಾಗಲಿ ಸಲ್ಲಿಸಿದ ವರದಿಗಳಲ್ಲಿ ಅಲ್ಲಗಳೆಯುವುದಿರುವುದಿಲ್ಲ. ಅರ್ಜಿದಾರರು ನಿರಾಶ್ರಿತರಾಗಿದ್ದಲ್ಲಿ ಜಮೀನು ಅರ್ಹರಿದ್ದುದರ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿ ಭೂ ಸ್ವಾಧೀನಾಧಿಕಾರಿಯವರ ಪೂರ್ವವಸತಿ ಅಧಿಕಾರಿ ಹಿಡಕಲ್ ಡ್ಯಾಂ ಇವರ ನಿಯಮಾನುಸಾರ ಸಾಗಳಿ ಜಮೀನು ನೀಡಬೇಕಾಗಿರುವುದರಿಂದ ಪುನರ್ವಸತಿ ಅಧಿಕಾರಿ ಭೂ ಸ್ವಾಧೀನ ಅಧಿಕಾರ ಹಿಡಕಲ್ ಡ್ಯಾಂ ಹಾಗೂ ತಹಸೀಲ್ದಾರ್ ಖಾನಾಪುರ ಅವರಿಗೆ ಸೂಕ್ತ ಆದೇಶ ನೀಡಲು ಸೂಚಿಸಿದೆ. ಆಫ್ಟರ್ ದಿಸ್ ಆರ್ಡರ್ ಮೈ ಲಾರ್ಡ್,
you submitted a representation.
After this, my lord, no action taken, my lord. ಆಕ್ಷನ್ ತಗೊಳ್ಳಿಕ್ಕೆ ಮತ್ತೆ ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ ನ ಫೈಲ್ ಮಾಡ್ತಾರೆ ಮೇಲೆ 2023 ಅಲ್ಲಿ. ಅದರಲ್ಲೂ ಕೂಡ ಅಂದ್ರೆ ಪಿಟಿಷನರ್ದು ರಿಪ್ರೆಸೆಂಟೇಷನ್ ನ ಕನ್ಸಿಡರ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು, ಬಿಕಾಸ್ ದಿಸ್ ಅದು ಆರ್ಡರ್ ನಲ್ಲಿ ಮೈ ಲಾರ್ಡ್ ಅದು RS ನಂಬರ್ 79 ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಲ್ಯಾಂಡ್ ಅವೈಲಬಿಲಿಟಿ ಇಲ್ಲ. 48 ಎಕರ್ಸ್ ಲ್ಯಾಂಡ್ ಅವೈಲಬಿಲಿಟಿ ಇರುತ್ತೆ ಮೈ ಲಾರ್ಡ್. ಆಲ್ರೆಡಿ 47 ಎಕರ್ಸ್ ಏನಿದೆ ಅಲ್ಲ, ಆಲ್ರೆಡಿ ಯಾರ ಹಿಂಗ ನಿರಾಶ್ರಿತರು ಇರುತ್ತೆ ಅವ್ರಿಗೆ ಆಲ್ರೆಡಿ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡಿಬಿಟ್ಟಿರ್ತಾರೆ ಮೈ ಲಾರ್ಡ್. ಮತ್ತೆ ಅಲ್ಲಿ ಲ್ಯಾಂಡ್ 5 ಎಕರ್ಸ್ ಲ್ಯಾಂಡ್ ಅವೈಲಬಿಲಿಟಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದನ್ನ ಏನೋ ಆಕ್ಷನ್ ತಗೊಳ್ದಂಗ್ ಬಿಟ್ಟಿರ್ತಾರೆ ಮೇಡಮ್. ಆಮೇಲೆ 2023 ಅಲ್ಲಿ ಮತ್ತೊಂದು ರಿಟ್ ಅನ್ನ ನಾವು ಫೈಲ್ ಮಾಡ್ತೀವಿ ಮೇಡಮ್. ಅದ್ರಲ್ಲೂ ಕೂಡ ಆರ್ಡರ್ ಆಗುತ್ತೆ ಮೇಡಮ್, ಪಿಟಿಷನರ್ ರಿಪ್ರೆಸೆಂಟೇಷನ್ ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ. ಕೈಂಡ್ಲಿ ಪೇಜ್ ನಂಬರ್ 28 ಮೈ ಲಾರ್ಡ್. Para 6, my lord.
Yes.
Writ petition is disposed of with a direction to the respondent number 2, contempt authority to consider the representation at Annexure C dated 5/4/2023 filed by the petitioner and pass order on the same and expeditiously as possible but not later than the period of 4 months from the date of receipt of certified copy of this order, my lord. This order agilla, my lord. Till date, no action is taken, my lord.
ಆಮೇಲೆ they have recommended survey number 99 5 acres 8 ಗುಂಟೆ.
ಬೇರೆ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ ಮೇಲೋಡ್.
ಇವಾಗ ನಿಮ್ 79 ಅಲ್ಲೇ ಬೇಕಾ 99 ಅಲ್ಲಿ ಬೇಕಾ?
99 ಅಲ್ಲಿ
ಪರವಾಗಿಲ್ವಾ?
ಅಲ್ಲಿ ಲ್ಯಾಂಡ್ ಅವೈಲೇಬಲ್ ಇಲ್ಲ ಮೇಲೋಡ್, ಅದಕ್ಕೆ 99 ಅಲ್ಲಿ ನಡೆಯುತ್ತೆ.
Your lordship, as per the report annexure K, the land is available at survey number 99.
99 ಕೊಡಿ ಮತ್ತೆ.
Let them consider the
ಕನ್ಸಿಡರ್ ಏನ್ ಬಂತು?
After
2006-7 is when it was submerged.
Your lordship,
now you are 18-year majority to the litigation.
Annexure K, your lordship, the AC has written letter to the Tahsildar to consider, your lordship, regarding the
18 years.
Yes.
To allot alternate land.
Even AC, your lordship, in there in the month of November 2024 also has written letter to Tahsildar.
Ping pong with all the letters going around.
Yes.
More a writ petition now. Which officer is responsible for this delay of 18 years? Despite a recommendation in 2 orders of this court.
Annexure L also, your lordship, it is free from ante-li there.
We are not just going to issue a mandamus. You filed this one on Monday as to why it has not been delayed, who is the person responsible. And AGA accepts notice for respond number 1 to 4. The land of the petitioner in Shidlihalli village, Hukkeri Taluk, got submerged on account of the Ghataprabha construction of Ghataprabha Dam. In pursuance thereof, that the respondents had indicated alternate land would be granted to the petitioner. Despite which no action having been taken, The petitioner had earlier approached this court by filing a writ petition in WP number 102723 of 2020. And this court on 2nd September 21 had directed the consideration of the request. Again, no action having been taken, the petitioner once again approached this court in WP 103767 of 2023, which was again disposed on 28 June 2023 with a direction to the response to consider the representation submitted. Thereafter, there appears to be various correspondence between the authorities, finally contending that land is not available in the earlier identified RS number 79, but is now available in RS number 99 to an extent of 5 acres, 8 guntas. But however, no allotment has been made, no grant has been made till date. The land of the petitioner having been submerged way back in the year 2006-7, the petitioner has been awaiting allotment of grant of land for last nearly 19 years. The same does not speak well of the respondent authorities. In that view of the matter, yaar kodbeku, Deputy Commissioner?
AC and Tahsildar. 2 to 4 and type.
The second respondent, Deputy Commissioner, he is directed to file an affidavit by 24th February, indicating as to by when the grant would be made to the petitioner as indicated in the various correspondences. Released on 24th at 2:30 p.m. If affidavit is not filed by then, the Deputy Commissioner shall appear through video conferencing. Namure dina ide anta tellak nodbedu.
Team J. Shetty.
The petitioner Malad is challenging the order passed by the commissioner as well as the deputy commissioner, wherein Malad it is stated that
The petition dismiss.
Ah.
ಕೇಳ್ತಾ ಇದ್ದಾರಲ್ಲ
Sorry.
Sorry. Sir, shall I write?
In fact, the order passed by Malad annexure A may kindly be seen. What it says that there are two partners in the partnership firm for which license has been granted. Malad, the partnership firm, Malad, your lordship may kindly see the earlier partnership deed for which the license has been granted by the authorities, which says that in a case of death of one of the partner, the firm will continue by his legal representative. Page number 27 may kindly be seen. The partnership deed is page number 23. 27 is its typed copy.
That is part of the part.
Yes,
Now the partners
that
were
the business of partnership does not
Ram,
dissolve.
Kajal and Bharat Kala.
Yes. Well, earlier, Malad, two partners. One is Malad Tukaram, and another is Malad, his son Malad
Bharat Kala.
Bharat T. Patil, Kalal, his son.
Yes.
Malad, the partnership deed provides that, Malad, page number 27, Malad, typed copy, that business of partnership does not dissolve in a case of retirement, death or incapacity of paying partner, or same may be continued by admitting the legal heir of such partners into this partnership deed with the mutual consent of a remaining partner in this respect. Now, Malad, this Malad Tukaram Kalal died, and actually E Malad his death certificate. Malad, his legal representative, another son, Guru Prasad Tukaram Kalal. Malad, he has been inducted in the place of his father.
Yes.
Malad, share has not been Malad changed. It is same continued as Malad. The next partnership deed, Malad, is page number 40, and actually M. Only the Malad, the
endorsement.
now endorsement, what they are saying that though Malad it is coming within the purview of Rule
Change in
17A,
control and management of the
they say that Malad 17B.
Shankar Wines case.
Shankar Wines ante. Malad 17A, Malad is
There's notice for respondent
right, 17A may kindly be seen.
1 to 5. The
in fact, Malad, there
operation execution of the endorsement dated 31/20/25 at annexure A and the order dated 3/2/25 at annexure B are stayed till the next date of hearing. The needless to say that the petitioner can continue with the operation of the CL2 license
Yes.
granted to them till the next date of hearing.
Yes.
The respondents are called upon to file their objection as to how the devolution of the interest of a partner in a partnership firm would amount to change in the management of the partnership firm. Relist on 24th March.
I will file a memo, my lord, hand delivery. my lord.
Ian handle.
Otherwise,
Thick
they,
and hand.
they closed, my lord. Yesterday, my lord, they directed. to
Even
close.
Wednesday, no problem. Saturday, no.
16, PDCA.
Annexure E, my lords, is the order and the challenge passed on IN number 13, was wherein I have sought for reopening, my lords, and for leading further evidence.
You are the plaintiff.
Yes, my lords, suit is
Suit
one
for-
for specific performance of the registered agreement of sale.
Registered agreement.
Yes, my lords.
Yes.
I have let in the evidence.
Hmm.
Thereafter, my lords, it was posted for defendant's evidence. He has
Hmm.
put in, my lords, examination in chief.
For defendant's evidence.
For defendant's evidence. He
Hmm.
has filed examination in chief. Because at that juncture, my lords, I have filed IN number 13 to lead further evidence.
Issue notice to the respondent returnable by 27th March. The further proceedings. Invoice number 138 of 2021. Pending on the file of the first additional senior civil judge Bellary. He stayed till the next date of hearing. Process fees and copies to be furnished by end of day 21st February. Acknowledgement of service on the counsel for the respondent before the trial court to be filed on or before 28th February. Failing either of which, the interim order will stand automatically vacated.
17, Mahesh Badia.
Here for the petitioner. Lord, the petitioner is an applicant in IA number 2, filed under Order 1 Rule.
For suit for first.
Suit for, I'm sorry, suit for partition and separate possession.
Nevo.
My lord, he is a third party. On the basis of the registered power of attorney from the defendant number
Not a
2,
party, impleading applicant.
impleading applicant,
Yes.
IA number 2.
Hmm.
Page number 14, my lord, the reasons. The trial court, my lord, rejected, my lord, IA number 2, hold, recording a finding that, my lord, only on the basis of GPA, he cannot be impleaded as a defendant number 3.
Application.
My lord, application at page number, IA number, annex E, my lord, page number 38, your lordship.
Ian, what are the grounds?
Does the same property, my lord, is,
ನಾನು
yes.
ನಿಯೋಜಿತ ಪ್ರತಿವಾದಿ 3 ಇರುತ್ತೀನಿ ನನಗೆ ಯಾವ ಸಂಗತಿಗಳನ್ನು ಮಾಹಿತಿ
ಎರಡನೇ
ಇರುತ್ತದೆ.
ಪ್ರತಿವಾದಿ
ಈ
ಬರೆದುಕೊಟ್ಟು.
ದಾಖಲೆಯಲ್ಲಿ
ನನ್ನ ಹಕ್ಕು ಹಿತಾಸಕ್ತಿ ಇದ್ದು ಸದರಿ ದಾವಾಸ್ತು ಕ್ಷೇತ್ರ
ಏನು ಹಕ್ಕು ಇದೆ?
ಮಲಾಡ್ ಪೇಜ್ ನಂಬರ್ ಮಲಾಡ್ annex D ಮಲಾಡ್ ದಿ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ರಿಜಿಸ್ಟರ್ಡ್ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಮಲಾಡ್ at page number 35 internal ಮಲಾಡ್ 3 page ಮಲಾಡ್ ಫಸ್ಟ್ ಪ್ಯಾರಾ ಮಲಾಡ್ ಈ ಸದರಿ ಜಮೀನು ನಿನ್ನ ಹೆಸರಲ್ಲೇ ಖರೀದಿ ಪತ್ರ ನೋಂದು ಮಾಡಿಕೊಳ್ಳುವ ಪ್ರಸಂಗ ಬಂದಲ್ಲಿ ನೀವು ನಿಮ್ಮ ಹೆಸರಲ್ಲೇ ನೋಂದು ಮಾಡಿಕೊಳ್ಬೇಕು. ದೆನ್ ಮಲಾಡ್ last 3 lines, he has received the my lord the consideration. It amounts to my lord conveying his my lord rights in favor of the my lord the proposed defendant number 3. My lord his written statement I will take your lord's annex C. My lord at page number.
ಹಕ್ಕಿ ಇರೋದಿಲ್ಲ.
Yes.
ಅಗ್ರಿಮೆಂಟ್ ಆಫ್ ಸೇಲ್ ಮಾಡಲಿಲ್ಲ, ಬರೀ ಪವರ್ ಆಫ್ ಅಟರ್ನಿ ಮಾಡಿದ್ರಿ.
Page number 28 your lordship.
ರಿಜಿಸ್ಟರ್ ಮಾಡಿದೀರಾ?
Register ಆಗಿದೆ. Registered. Page number 28 my lord, why?
Issue notice to respond number. Suit for partition ಅಲ್ಲ?
Partition.
Issue notice to respond number 1 to 8, returnable by 27th March. The further proceedings in OS number 110 of 2016, pending on the file of the civil judge and JMLC Shiggaon, he stayed till the next date of hearing. Process fee, same order.
18, SP Happalli.
Yes.
My lord, in this case, petitioner are the joint owner of survey number 290/2 and 295/2, my lords. without paying, without initiating acquisition proceedings and paying compensation, the land was granted to under scheme Gramin Ashraya Yojana, Indra and so scheme, my lords. We have filed writ petition in 2012 directing to pay, seeking compensation, my lords. It was disposed saying that there was no initiation of proceedings. So we were given the liberty to make representation before the acquisition officer to initiate acquisition proceedings, my lords. But without considering that, they have passed the impugned order annexure E and G, my lords, declaring that they were unrecorded lands under 38A, my lords.
Unrecorded habitation in the year 24 after regularizing under the Ashraya scheme.
But your lordship, the annexure G, your lordship, it is the endorsement issued saying that your lordship, they are not produced any documents regarding the legal headship, your lordship.
My lords, we are.
Your lordship, in page 24, your lordship, last paragraph, your lordship.
RTC stands on our name, my lords.
Last paragraph, your lordship. Even in the present petition also, they are not produced any documents regarding that aspect.
We have produced RTC, my lords.
RTC is different, your lordship, the legal issues.
What documents have you produced here?
RTC, my lords.
RTC Allah. What other documents have you produced? Idu Jagan Nayaka.
Please, my lords.
You are Narayan Nayak, son of Ramchandra Nayak.
Please, my lord.
K. Bhima Nayak, son of B. Krishna Nayak.
Please, my lord.
How are you related to Jagan Nayak?
We are petition number 1 is son of Jagan Nayak, my lords, and 2 is grandson.
Son of
my lord.
Ramchandra Nayak.
Yes, my
Not Jagan Nayak. Ramchandra Nayak yaru, Krishna Nayak yaru, Jagan Nayak in connection illa.
My lords, petitioner number 1 is grandson of Jagan Nayak, my lords.
On what basis?
My lords,
ನೀವು ಗ್ರ್ಯಾಂಡ್ ಸನ್ ಅಂದ್ರಿ ಅವರು ಇಲ್ಲ ಗ್ರೇಟ್ ಗ್ರ್ಯಾಂಡ್ ಸನ್ ಅಂತಾರೆ ಡಾಕ್ಯುಮೆಂಟ್ ಬೇಕು ಇಲ್ಲ ಸನ್ನು
will produce.
ಅದಕ್ಕೆ ಯಾರು ಫಾದರ್ ಅನ್ನಲ್ಲ
Please,
ಅದಕ್ಕೆ ಅವ್ರ ಮುಂದೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ರಿಜೆಕ್ಟ್ ಆಗಿರೋದು ಇಲ್ಲೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ
will produce.
and AGA accepts notice for respond number 1 to 3 CEO Kudlgi Vijayanagara Shivraji Remat for respond number 4 and 5. Learned counsel for the petitioner seeks fund is granted a week's time to place on record any document evidencing relationship of the petitioner with Jagan Nayaka, whose name is shown in the RTCs produced at Annexure A. The said documents being public documents. Relist on 27th February na illa March.
2 weeks.
Relist on 21st March.
Please.
If no document, needless to say, if no documents are placed on record, the petition would be liable to be dismissed.
19, Hanuman Reddy Saukar.
Landowner or purchaser?
Purchaser of the land minutes.
And AGA accepts notice for respond number
1 to 3.
1 to 3. Issue notice to respond number 4 returnable by 16th April. The petitioner and respond number 4 are restrained from in any manner putting up any construction or in any manner alienating.
Construction ಏನಿಲ್ಲ.
ಆಗ್ತಾ ಇದೆ. Or in any manner alienating, encumbering dealing with the property subject matter of the above writ petition till the next date of hearing.
No, seeking for a stay of not the impugned order,
Yeah,
because I am in possession.
The implementation of the order bearing so and so is stayed till the next date of hearing.
Annexure E.
Process fee and copies to be furnished by end of day 21st, failing which the interim order will stand automatically vacated.
Please.
20, Omkar Desai. Omkar Desai.
Paso.
21, BV Somapur.
LR of
LR of, the present application is LR of petition number 3B, my lords.
3B.
3B.
During the pendency of the above matter, the petition number 3B expired on
24/4/2011.
hence IA 1, 2 and 3 of 2025 have been filed on
17/2/2025.
accepting the reason stated in the affidavit in support of IA 1 of 25. The delay of 5,000 days is condoned subject to payment of cost of rupees
Minimum cost last.
KLR 3,000 rupees to the advocate's clerk so and so. Accepting the reason stated in support of IA 2 of 25, the abatement in respect of petition number 3B.
3B. 3B.
3B is set aside. By accepting the reason stated in support of IA 3 of 25, the person named therein are brought on record as 3B1 to
3B A to 3B C.
3BA to 3BC. 3BB, ಎರಡೇನಾ?
In respect of 3BB, my lords, Vakalat is not given, my lords.
3B.
3B.
3BA and 3BB. ವಕಾಲತ್ತಿಲ್ವಾ BBಗೆ?
In I number 7, 8, 9, I number 7, 8 and 9, my lords, with respect to petition number 3 is pending, my lords. In that 3BB's name is shown, my lords. 3BB has not given Vakalat, my lords. Hence her name is not. Her name is not shown here. One LR has not given the Vakalat, my lords.
Earlier application is still pending.
7, 8, 9 with respect to petition number 3. 3. It is still pending, my lords.
So 3 ಗೆ ಯಾರ್ಯಾರು ಬಂದಿದ್ದಾರೆ?
Pending it.
You have filed for 3.
3. Petition number 3.
Then IA number. Three BB has not given you Vakalat.
Not given Vakalat.
Then how did you file?
In respect of that, on Vakalat, objection was raised, my lords. In spite of repeated requests, they did not come forward, my lords. Hence, petition against 3BB is post. Now, since
Allowed that. During the pendency of the above matter, petition number 3
died on,
expired on 10/6/2012.
please.
Hence, IA 7, 8 and 9 had been filed to bring the legal representatives on record. Noticing that petition number 3B, who was to be brought on record as the legal representative respondent petition number 3, had also expired and no application had been filed, as regards which office objection had been raised. Petitioner has filed IA 1, 2 and 3 of 2025. However, insofar as one of the legal representatives of respondent petition number 3B, that is 3BB, Vakalatnama had not been filed, as regards which also office objection had been raised. No Vakalat, the office objection not having been complied with. That counsel for the petitioner cannot appear for, is not authorized for appearance, authorized to appear on behalf of respondent petition number 3BB, nor file an application in IA 1, 2, and 3 of 2025. Hence, the said applications are restricted to one of the legal representative deceased, petition number 3B, shown as 3BA in IA number 3 of 2025.
Please.
Accepting the reasons stated in support of IA 1 of 2025, the delay of
5,000 days.
5,000 days is condoned by allowing IA 2 of 2025, the abatement in respect of petition number 3B in respect of IA number 7 to 9 is set aside. By allowing IA 3 of 2025, the person named therein is brought on record as petition number 3BA in IA number 9 of 2020. Another
9 of 2020.
9 of 2020. As afore observed, petition number 3 had expired on 10/6/2012, and as such, IS 7, 8, and 9 had been filed on 21/10/2020. Petition number 3, the proposed petition number 3B having expired, his legal representative has already been brought on record today by allowing IA 1, 2, and 3 of 2025. As such, by accepting the reasons stated in support of IA 8 of 2025, the abatement in respect of petition number 3 is set aside. The persons named therein are brought on record as petition number 3A, 3B, 3BA, 3C, and 3D.
Please.
By allowing IA 9 of 2025, subject to payment of cost of rupees 2,000 to the advocates clerks benevolent fund. So only 3,000 to 2,000, total 5,000. Counsel for the petitioner to carry out necessary amendment and file amended cost title. Released on 2010 matter. Then 3,000 munchenu
Cost is paid, my lords. It is paid.
The submission of the counsel for the petitioner that the earlier cost of rupees 3,000 has been paid is placed on record, registry to verify. Released on 24th March.
Please.
Permission. Seal number.
IA 1, 2, 3 ಗೆ 3,000, 7, 8, 9, 2,000. ಆಮೇಲೆ earlier cost of 3,000.
Kind submission.
Earlier cost paid. ಇವಾಗ
Seal number 20, my lord. It's password, my lord.
ಡಿಸ್ಮಿಸ್ ಆಗೋಗಿತ್ತು. ಇದರಲ್ಲಿ ಏನು ಅಂಡರ್ ಗ್ರಾಜುಯೇಟ್
In this matter, my lord, that approval of admission, my lord.
Approval of admission.
Admissions, my lord. They issued annexure H, my lord, communication
KE
letter.
ಆಗಿದೆಯಾ? ಯುಜಿನ ಪಿಜಿನ?
Yes, KEA through they admitted, my lord. KEA through.
ಯುಜಿನ ಪಿಜಿನ?
PG, UG. Under this BMS course.
KE ಆಗಿದೆಯಾ?
Yes, my lord.
ಕೌನ್ಸಿಲಿಂಗ್ ಆಗಿದೆ.
Council agreed, sir. They issued annexure F, my lord. They issued admission order, my lord. KEA.
KE ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲಲ್ಲಪ್ಪ ನೀವು. Should make KE party.
No, they have given the admission order was issued by the KEA, my lord.
Page?
Annexure F, my lord. Page number 59, my lord.
Where is Avinash Mankar?
Avinash Mankar.
And second thing, my lord, they issued a communication annexure H, my lord, stating that they are below the PCB marks, my lord. And the petitioner are claiming under the reservation quota, my lord, OBC quota. And the OBC quota, my lord, 40% they are mentioned, my lord. Annexure A, my lord.
Category open ಅಂತಿದೆ KE ಅದು.
No, my lord. Annexure A, PCB through they are taken admission, my lord. Annexure A kindly be payroll, my lord. Page number 14. Page number 14, 15, my lord. 15, regulation 5, my lord. That A, subclause A, my lord. The candidate shall have passed 10 plus 2, my lord. or its equivalent to examination for the any recognized board, the physics, chemistry and biology, my lord. And have to obtain minimum 50% marks in general quota, my lord, and 40% for SC, ST and other backward classes student, my lord. And they have claim more than that, my lord, in 40% and more, my lord. That marks card are enclosed, my lord.
Category ilwala nimma F and
That caste certificate is enclosed, my lord. Annexure C. Annex page number 4952, my lord. They are stating that you are belong to the different state, my lord. They belong to the state of Maharashtra, my lord. So they are not considering the caste certificate, my lord. Page number 4952, my lord.
issued by Muge Roy Santosh, son of in the state of Maharashtra.
Yes, my lord. They are discriminating that, my lord. So belong to other state, they are not considering under the OBC quota, my lord.
Where is Mr. Bandkar? Karkond bani ಅವ್ರು. Pass out.
Yes, ma'am.
22. Mallikarjun Swami.
For the petitioner, my lord, while filing the writ petition in the cause title, there is a typographical error has been. While filing the writ petition, my lord, in cause title, my lord, respondent number 1 has wrongly shown as, my lord, address of the respondent number 1 and 2, my lord.
One is state of Karnataka.
It has to be.
It has to be a Department of Panchayat Raj and Rural Development, my lord. Instead of it, it has been.
Amendment ಆಗಿದೆ ಅಲ್ಲ 31115 ಅಲ್ಲಿ amendment ಆಗಿದೆ.
Application amendment of cost title ಅಂತ ಬಂದಿದೆ application.
31115 is permitted to amend the cost title. You should amend your office copy also.
I'm sorry, my lord. It's a writ of mandamus, my lord.
311
ಅಲ್ಲ ಬಂದೇ ಇಲ್ಲ ಇದು 311 ಆದ್ಮೇಲೆ 9/3/2016 again today it is
4 13/8/29 ಏನ್ರಿ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ನೀವು ಲಿಸ್ಟ್ ಮಾಡ್ಸಲ್ಲ ಆಮೇಲೆ ಕೋರ್ಟ್ ಬಯಸ್ತೀರಾ ಅದು ಮ್ಯಾಂಡಮಸ್ ವೇದ ಅಕ್ವಿಸಿಷನ್ ನೋಟಿಫಿಕೇಶನ್ ಏನಾರು ಇದೆಯಾ
ಇಲ್ಲ
Why are you keeping quiet from 2015, Mr. Ramat?
No, it was, the endorsement was given saying that they require some more time for consideration of my representation. I produced it annexure. Page 40.
Is this land being acquired?
No, my lord, land has been taken over without initiating acquisition proceedings.
Once
My lord, neighboring land was also taken over. My writ petition was dismissed.
Instructions. This is
one submission with regarding to the same relief. Already the petitioners approached this honorable court, wherein this honorable court pleased to dismiss the writ petition. That was challenged in a writ appeal. That is also part of the statement of objections.
That is not relating to this property. That was filed by me only in respect of my other land. My writ petition was dismissed.
The same claim.
Confirmed by the.
How many lands of yours are being acquired?
They are Desai's, they had several land.
They have thousands of acres.
No, no, not those.
It has been yes.
The survey number therein and the present plate's property is different.
The relief claimed is same with regarding to.
If I am having 10 properties and if one property I am.
Is RS 106 says 107 187.
Yes.
ಅದು 225/4. ಅದು ಬೇರೆ ಅಲ್ವಾ?
ಅಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಬೇರೆ. The relief is with regarding to the claiming herein with the same relief. Where in this honorable court
7954 is grandfather owner of 106A 107 187. Page 16 of the statement of objection.
That has been confirmed in the division bench also.
So the
And the
endorsement
acquisition
dated,
was before independence.
How?
because the land was taken over pre-independence, so I am not entitled to is what the honorable court has held.
Yes.
Now there was an endorsement issued on 21/7/2014 in that matter, rejecting my claim, not in respect of this property. Your Lordships can put up those file blades.
Mr. Remart,
Yes.
please come to page 16 of their objections.
Yes, ma'am.
What is the survey number mentioned there?
That is 106A, 10. This is a contention that we are the owners of these survey numbers, but the endorsements related not to in respect of this property.
That petition was 106A, 107, 187. This present petition is for what survey number? 106A, 107, 187. Same survey numbers.
Listen, I'll just.
How can you maintain two but adike sumne
No, the present petition relates to now block number only 225, which has been renumbered.
out of?
There were 3 survey numbers. That endorsement did not relate to the subject petition. Your Lordship can put up that file. Your Lordship's.
Order illegally.
Allah, this is a contention taken in both the petitions that we are the owners of these 3 survey numbers.
You are claiming re-granted in 53.
Yes.
The court has held that the acquisition was prior to the independence, so
Yes.
re-granted munche. The same
Ah,
order
okay,
will
sir.
apply. Same order will apply for the same survey numbers. It is relating to the entire survey number. This is for one small block.
Yes.
One big block in that.
Yes.
51 acres.
How?
The same will apply. Division benches also
No,
consider it in
no, in this
detail.
case, what has happened is, after my representation was made,
Division bench has said land was used for construction of government guest house at Yaragatti in the year 1859, 1860. What are you doing coming after
no, this,
more than
no,
centuries?
so far as this petition is concerned, if you Lordship say page number 47 of the.
That is what para 14. There is absolutely no explanation for the delay, having regard to the fact that the huge delay of more than 150 years in raising the dispute and approaching the court is not explained. Learned single judge is fully justified in declaring to entertain writ petition on the ground of delay and laches.
No, because if your Lordship sees para number 4 of the writ petition order therein, because that land millet was taken in the year much before pre-independence, para 4 of the writ petition order. The representation made by the petition was rejected by the respondent number 2 by issuing an endorsement dated 21/7/2014, wide annexure G, by stating that the land must have been acquired between 1959 to 1960.
1859.
1859 to 1860.
Century difference.
Oh, correct. That was, even the order itself highlighted that it was pre-independence.
Yes.
I cannot dispute that fact. So let my endorsement, which was rejected, was upheld by this honorable court and confirmed by the division bench. The present property was given millets in the year 1961.
So 1961 in the you were, again you are coming in 2015
No, what they say is
after 40 years.
that was without initiation of any acquisition.
So
now the representation that was given by me to consider for the claim.
Issue a mandamus to revive a dead claim of 40 years. Your client seems to be making this into a speculative litigation. 150 years, 50 years, in 100 years, thrown money. What kind of speculative litigation is this?
If your Lordship sees their endorsement, it is not, my claim is not rejected. What they say is, we are not certain as to which portion of the property.
Your claim is of the year 1961. You want a representation to be considered of 1961 acquisition compensation to be given now. Para 3, your claim is 5/8/1961.
Yes.
And order of Assistant Commissioner of 25/6/1961. And your power of attorney holder submitted an application on 7/12/2013.
Yes.
Even a power of attorney holder.
No.
They're making a business out of
No,
this.
he is a aged person, so my lord.
Who is the
he's-
power of attorney holder?
He is Mr. Patil.
Is he his son?
No, he is from the same village.
They are making a business out of it.
No, since my lord, these two persons, my lords, could not come. Yes.
The petitioner is before this court seeking for the following reliefs. The petitioner contends that the land in RS number 106 capital A 107 187 and other lands were re-granted in favor of the petitioner's great-grandfather by an order dated 16/10/1953 under the provision of the Watan Abolition Act. It is contended that the three survey numbers were assigned a single block number in block number 225, totally measuring 51 acres, 36 guntas. The name, the Assistant Commissioner, by order dated 25/6/1961, had indicated that the land had been acquired. And in that background, the petitioner, represented by a power of attorney holder, had submitted a representation to the fourth respondent 7/12/2023, requesting for copy of the award. The endorsement having been issued on 17/1/2014 that no records were available, the petitioner caused a legal notice on 10/2/2014 for payment of suitable compensation. A writ petition, the same not having been considered, a writ petition WP number 104965 of 2014 had been filed when this court rejected the contention that a legal notice cannot be considered to be a representation, and as such the present writ petition has been filed. On that basis, the submission of Sri Mallikarjun Swamy Biremat, learned counsel for the petitioner, is that the land having been utilized by the Assistant Commissioner in the year 1961 without acquisition, without compensation, a mandamus is required to be issued to the respondents to consider the representation of the petitioner for awardal of compensation. Sri V.S. Kalsurmat, learned AGA, would submit that once earlier, another petition, writ petition had been filed by the very same petitioner, represented by the very same GPA holder in WP number 107954 of 2015, which came to be disposed by a coordinate bench of this court on 3rd November 2015. As regards the very same survey numbers in RS number 106A, 107 and 187, where again the petitioner had contended that the land had been re-granted on 16/10/1953 and the usage of the land without acquisition was not permissible. This court, taking into consideration the submission of the learned of the AGA and the endorsement issued therein rejecting the claim, held that the acquisition had occurred in the year 1859-60, and as such, the claim being hopelessly barred by delay and laches could not be considered. A writ appeal having been filed, the division bench of this court, by its judgment dated 14 July 2016 in writ appeal number 1000002 of 2016, dismissed the appeal
On the ground that there was inordinate delay of 150 years.
and held that the land having been utilized in the year 1859-60, there is an inordinate delay of more than 150 years in raising the dispute. And as such, he submits that the present petition has been filed again for the very same survey numbers, land covered under the very same survey numbers, and this claim is also required to be rejected on account of delay and laches. In reply, Sri Mallikarjun B. Remat, learned counsel for the petitioner, would submit that the land subject matter of that petition was different,
225 or 4.
was different from the present petition. In the present petition, it is block number 225.
Per 225A. Your Lordship,
25.
A minutes.
LA.
Page 47. Andre it has been merged and entire 51 acres is given one block now.
ಹೌದು 225 ಇದೆಯಪ್ಪ 220
225A million. Your lordships will get in the endorsement page 47. 225 at 12 acre 20 guntas. The earlier petition related to 225/4. In the order itself, your lordships will get it at division bench order. So, statement of objections page 23, your lordships will get.
24 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ನಂಬರು?
Page 23, interim page number 5 of the order. The extract of that endorsement, the letter also. ಭೂ ಸ್ವಾಧೀನ ನಡುವಳಿ ಕೈಗೊಳ್ಳದೆ ಸೌದತ್ತಿ ತಾಲೂಕಿನ ಯರಗಟ್ಟಿ ಗ್ರಾಮದ ರಿಸ ನಂಬರ್
The earlier round of litigation was in respect of block number 225/4, whereas the present dispute is as regards block number 225. A perusal of heard so-and-so peruse papers. A perusal of para 2 of the petition indicates that the three survey numbers in RS number 106A, 107 and 187 were assigned a single block number in block number 225. The details of when they were assigned such block number also has not been furnished.
No, I produced. Actually, it is
Earlier, stated to have been consolidated in the year 1953. The earlier litigation was in relation to block number 225/4, which had been filed seeking for compensation as regards land utilized in the year 1859-60. In the present litigation, the claim is that the land has been used on 25/6/1961 as per the order of the Assistant Commissioner. Thus, the earlier litigation was a 150-year-old dispute, a 150-year-old claim. The present litigation, even if accepted on face value, is
2050.
more than 50 years old. Comparatively, though speaking, the delay in the present petition is lesser. The fact remains that there's a delay of more than 50 years. The manner in which both the above petitions had been filed by a power of attorney holder also does not inspire any confidence. I am of the considered opinion that both the sets of litigation are completely speculative in nature and are an abuse of the process of the court. The petitioner's earlier claim having been rejected for the very same survey numbers, though as contended by, though the Sri Mallikarjun B. Hiremat submit that it's for a different portion, the fact remains that the present petition is also as regard the very same survey numbers in RS number 106 capital A, 107, 187, which were consolidated and assigned block number 225. Such speculative litigation cannot be permitted before this court, which in my considered opinion would also amount to an abuse of the process of court filed by power of attorneys, the validity of which has not been gone into. In that view of the matter, the petition, of course, being barred by principles of delay and laches, is also an abuse of the process of court and speculative litigation. He is dismissed by imposing cost of rupees 50,000, which can
Same
be
day they were filed.
collected by the Assistant Commissioner, which is directed to be paid within a period of 30 days from today, that is on or before 19th March 2025, failing which respondent number 4 is permitted to initiate necessary proceedings for recovery of the cost by way of land revenue and remitting the same to the Karnataka State Legal Services Authority.
Cost can be because if GP
Highly speculative.
Power of attorney doesn't pay, then owner shall.
Power of attorney, Allah, 50 years, what kind of litigation?
Please.
ಇದೇನಪ್ಪ ಆಯ್ತು ಅದು ಸೆಟಲ್ಮೆಂಟ್ ಆಯ್ತಾ ಅದು?
Yes, almost similar. They have come to certain terms because of the Shivratri. They are meeting in their Ankolam.
ಏನ್ ಹೇಳ್ತಾರೆ ಹೇಳಿ, ಇಲ್ಲ ಡಿಕ್ಟೇಟ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ.
No. After Shivratri, no, they are meeting on Shivratri because in Ankola.
4 ಗುಂಟಾಸ್ ತಾನೆ?
Yes.
ಹೇಳಿ.
The subject matter of suit itself is there. They have come to certain terms.
Let it remain in the family. You have
Yes,
taken everything.
No, the society is thinking of giving up that. That's why.
4 guntas or family.
I understand.
Though you might be entitled some parts of
Please.
it. It's another unnecessary litigation.
Yes. Good.
23, SP Happalli.
Appearing for petitioner, my lords. Writ petition abates against ARFA and RC.
Despite sufficient opportunity having been granted, no applications have been filed to bring the legal representative of deceased respond number 9, 11 and 12. They having expired long ago, the petition has stood abated. In view thereof, formal orders are passed dismissing the above petition in respect of respond number 9, 11 and 12 as abated. Uh, 9, 11 and 12 alla. Respond number 5 and 6 are also having expired long ago. No steps have been taken to bring the legal representative of deceased respond number 5 and 6 on record. Abate same order, 5 and 6 also. Twenty-seven, 125 ಏನಿದು? ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದ್ಯಾ?
First notice. What has up now is the law.
Learned AGA submit that records are yet to be received. And he seeks for 3 weeks' time to secure the same. If the records are not secured by 24th March, the Assistant Commissioner shall be personally present before this court.
May I make one submission? I appear for R14.
14.
Land now is acquired by the BTDA. The disputed land is acquired by the BTDA. Compensation is not lying with the land acquisition code. Lord, I prefer the reference to seeking enhancement of the compensation. They are not permitting us to withdraw the amount.
Withdraw, how can it be permitted until your rights are decided?
No, but Lord,
you ask for enhancement, succeed in enhancement. If you succeed in the petition, you will get that entire money. If you take it away, what will happen?
I am the purchaser. Writ is filed after 28 years.
Records have been sought for. Let it come. Let it be taken up.
At least, my lord.
Enhancement, you proceed with it.
Let that be recorded, my lord.
Srinivas Nayak, learned counsel for respond number 14, submit that the entire land having been acquired. Respond number 14 has preferred a reference for enhancement of compensation. He also seeks for withdrawal of the compensation amount already deposited. And the considered opinion that though the reference proceedings can go on by respond number 14 with or without the assistance of the petitioner and the other respondents, any enhancement would accrue to the party succeeding in this litigation. As such, the amounts cannot be disbursed until final orders passed in the present matters.
It may go against me also. It may go against me. That may be clarified only. This order may go against me. Therefore, it may be clarified that whatever it is there, it is as regard to outcome of the writ petition.
Outcome. So, no disbursement till then. no disbursement could be made until final orders passed in the present petition. However, the parties are, as observed above, the parties are free to progress with their claim for enhancement of compensation in the reference proceedings.
Lordship, in this case, respondent has expired, maybe seek the permission of the court to file LR's application. Day before yesterday, intimation is issued. Respondent has expired, Lordship.
Aitappa, OS3 has been dismissed and disposed on 7/3/2019.
How's?
Therefore, the petition has been dismissed as infructuous. OS3 tane idu.
No, execution, sir. Execution 3/14, Lordship.
ಮತ್ತೆ ಏನೋ submission ಮಾಡಿರೋದು OS3 ಅಂತ ಮಾಡಿದೀರಾ?
Execution, sir, that is. That is at page number 39, Lordship.
Registry note wrong.
Page number 39, execution nalli wrong property has been taken possession instead of the decreed property, Lordship.
39.
39, Lordship.
39. In EP number 3 of 2014. EP3 is pending, ivaga?
Lordship.
EP3 pending idya?
It is dismissed, Lordship, before the trial court. Because we have filed the array that is allowed in our favor, stating that the OS 271 suit for possession is wrong. And accordingly, we have filed produced the judgment copy of RA 12/18 and it is closed. But before closing, the petitioner's application for restitution of the property is not entertained, not considered. Even though we have filed.
EP was closed.
Yes.
Thereafter, you filed RA.
No, during the pendency of EP only, RA was allowed and filed and allowed.
Filed and allowed during the pendency.
During the pendency, Lordship. And thereafter, the petitioner has produced the RA judgment copy before the trial court in execution 3/14, and considering that the EP was closed, even in spite of pendency of 144 application, 144 CPC application of the petitioner.
For restitution.
Restitution.
You are the respondent is expired, huh?
Expired, Lordship. Day before yesterday, I got the intimation, Lordship.
Counsel for the petitioner submit that respondent has expired. He seeks for and is granted 3 weeks time.
Please.
To file necessary application to bring the legal representative deceased petitioner respondent on record. Since until they are brought on record, the application for recalling the order cannot be considered.
Please.
Shivashuru.
During the pendency of the above matter, petition number 1 expired on?
Not deaf.
Idle note
In fact, on last occasion, notice was already issued.
Petitioner notice in
Notice to the R1 Millard since
legal representative P1 are to be brought on record, allapa.
Four 3/2022.
Petition number 1 expired.
Please, ma'am. 4/3/2022.
4/3/2022.
Please, ma'am.
Hence, IA 1, 2, and 3 of 2024 were filed on
Millard, no. There is I have already filed, Millard. On these IAs, there is already issued a notice. On these IAs, there is already issued notice in favor of respondent.
Why should notice be issued to
Because
respondent on
since
petition?
respondent number 1, it was dismissed for non-prosecution long back, Millard. The counsel party has taken away from the file. Okay, it was at their request, Millard. It was notice was issued, and I have paid a process.
Sole petitioner.
Please.
Yes.
Yes, my lords. Last time notice was issued to respondent number 1, my lord.
I have paid the process, Millard.
It was issued. Now you are here.
No, my lords. Notice ಹೋಗೇ ಇಲ್ಲ, my lords. ಮುಟ್ಟಿಲ್ಲ ಅಂತ.
ನೀವು ಯಾರಿಗೆ?
Respondent number 1.
Respondent number 1. He is contesting.
Contesting party.
Appear ಆಗಲ್ವಾ ಇದರಲ್ಲಿ?
ಇಲ್ಲ.
No. party our file ತಗೊಂಡು ಹೋಗಿದ್ರು. Last time it was dismissed for non-prosecution.
It was abated.
Then my lords, the court notice was issued. Daily. The above petition had been dismissed for non-prosecution.
No, it was abated.
Abated. On account of it being abated due to the sole petition having expired. Notice ಏನಗಿದೆ IA 1 to 3.
Respondent number 1.
The earlier counsel appearing for respondent number 1 submits that he has no instruction for appearance. As such, registry is directed to delete the name of Sri Mutunjay Tata Bangi, SS Yalgar and Mantesh Mathad as that appearing for respondent number 1. Notice on IA, when petitioner had filed
I'm sorry.
IA 1 to 3 of 2024 to bring the legal representative of deceased petitioner on record. Notice having been issued, service is awaited. Relist on 4/12/24. Relist on 20th March. Registry to put up the postal track record by then.
26 Subendu Akalwadi. Please, for petition.
Lots, the office objection lots is that there are two office objections lots. One is to verify.
Objection is that there are no office.
No,
Very
there
nice.
are, there are two lots. Lots, one is respondent number 6 and 8 lots, they have died lots. The date has to be verified and that date has to be given lots. Insofar as office objection number 2 is concerned, the copies are to be served on the counsel for respondent, which is done lots on 13/9/2024.
Who is expired for whom 1 to 6 have been filed?
Lots, respondent number 6 and 8 lots have expired lots.
Stands dismissed agide.
It was abated lots and I filed the necessary applications lots. The date was not lots verified. So on what date they had died, there was some sort of miscommunication between the.
Your date has been put in?
Lots.
You have added the date?
No, I've already asked for the instructions for lots. There was some sort of miscommunication lots. That's why they were not able to verify it lots with the respondents.
As office objection number 2 on IA 1 to 6 of 2024 is concerned, counsel for the petitioner submit that the said application have been furnished to the counsel for respondent number 1, 2, 1, 3, 7 and 9. Acknowledged receipt thereof. As such, office objection number at CL number 2 is overruled. Insofar as the date of death is concerned, counsel for the petitioner seeks for 2 weeks time to obtain details and
Please.
make a submission. Issue notice on IA 1 to 6 of 2024 on the person named therein returnable by 28th April.
My lord, short date maybe.
Or notice, ನೀವು accept ಮಾಡ್ತೀರಾ notice?
Accept
ಮಾಡ್ತೀರಾ? Please, then it counsel for.
My lord, one submission, my lord. Since it is a partition before the trial court, issue involved before the trial court is consideration of IA number.
First, let us allow this.
Please, my lord.
That counsel for respondent number 1, 3, 7 and 9 accepts notice for respond on IA 1 to 6 of 2024. He submits that he has no objection for the said applications to be allowed. He seeks for a week's time to file his wakalatnama. Accepting his submissions, IA 1 to 6 of 1 of 24 is allowed. Delay of.
What's the days?
Delay gottilla. IA 1 to 6 are allowed.
More than 2 years.
The person named therein are brought on record as R6A2.
The date is not known. 6 and 8 date is not known.
R6A2.
Let's R6A2 let's A and B let's 6A 6B.
6A and B. Please. R8
ABC let's 8A
A to C.
Legal errors.
Counsel for the
Legal
petitioner to carry out necessary amendment and file amended cost title.
Please.
Suit stay ಆಗಿದೆಯಾ?
Stay agide some ಅದಕ್ಕೆ proceedings before the trial court have become stagnant water, my lord.
Yes. What is the matter?
Point involved is consideration.
You're ready?
Please.
Please.
Let's IA number 7 lots. That is file lots. Let's suit for partition and separate possession lots.
And you are?
I'm the,
Seven,
defendant
yes.
number 5, 6, and 7, Milords. Here is, we are petitioners. Milords, what has happened? The defendants, Milords, they file an amended petition, Milords, amended plaint, Milords, adding, Milords, suit schedule C properties. That is at page number 17. There are around 13 item numbers, Milords, that is filed.
Where is the order allowing that
Milords,
application?
it is at Annexure E, page number 24. The order is at page number 27, Milords.
Is the additional written statement? Where is the additional, when was the addition of that property made?
Milords, the amended plaint is at page number 13, Milords, Annexure A.
253/2020.
1317, my lord.
That was amended on 5/3/2020. Page 17.
13, my lord.
Please,
13, my lord.
13 Allah.
Amended plaint.
The amended plaint,
Amended plaint, Milords.
the when amendment was carried out is at page 17, amended as per orders on IA2 dated 5/3/2020.
Oh,
And you filed this application on 22,
yes, my lord. 17/10/22,
17,
after
10,
lapse
22.
of 2 years, my
2
lord.
years.
The two stage is for evidence, my lord. For
So what had
arguments,
happened?
my lord.
Amongst the 13 item numbers at Schedule C, some of the properties, Milords, were self-acquired, and some of them, Milords, as they claim, is maybe, Milords, it is subject to debatable, Milords, is.
But then why did you wait for 2 years? You
No,
keep on debating.
At that time, there were certain properties, Milords, that was still the transaction was going on, it seems. Milords, that's why, Milords, as soon as they got to know about this, Milords, they filed this additional written
You were
statement along with the
given
permission.
time, you did not file, it was taken as not filed. Witnesses have been cross-examined completely. Defendants have adduced evidence. Now it is final stage. You have filed this application for additional.
Very late.
Please, Milords, that is one,
Rightly rejected.
that is one point, Milords.
Petitioner is before this court seeking for the following reliefs. Respondent number 1 had filed a suit in OS number 170 of 2019 before the senior civil judge Bellary seeking for partition and separate possession. In the said suit, the plaintiff had filed an amendment application which came in IA number 2, which came to be allowed on 5/3/2020, by virtue of which C schedule property consisting of 13 items were inserted in the plaint schedule. Thereafter, the plaintiff led his evidence. Plaintiff was cross-examined, defendant led evidence, defendant was cross-examined, and at that stage, defendant number 5 to 7 filed an application under section 151 of the Code of Civil Procedure to seeking permission to file additional written statement. The said application in IA number 7 came to be rejected while order dated 3/1/2023. It is challenging the same, the petitioner is before this court. The submission of the petitioners is that the plaint having been amended by introducing 13 properties in Schedule C, adequate opportunity is required to be granted to the petitioner, to defend number 5 to 7 to file additional written statement. A perusal of the impugned order and the order sheet would indicate that once the amendment was carried out, the matter was posted for filing of additional written statement. The additional written statement not having been filed, the matter was taken as not filed and posted for evidence of the plaintiff. Evidence have been completed, cross-examination have been completed. The defendant also led evidence and was cross-examined. And it is at that stage after the evidence was closed and matter was posted for arguments on merits, that stage, the evidence being closed, matter being posted for arguments on merits. On 13/10/2022, the arguments of the plaintiff and defendant number 1 and 2 were also heard, and matter was posted for arguments of defendant number 5 to 7 on 17/10/2022, when the application for filing of additional written statement came to be filed. And as such, the trial court rejected the application by imposing cost of rupees 500. This being the sequence of events, the amendment having been carried out on 5/3/2020, it is at the stage when the matter was posted for final arguments that defendant number 5 to 7, final arguments of defendant number 5 to 7, that the said application came to be filed. I do not find any infirmity in the order passed by a trial court. The application was highly belated. The petitioners, having slept over their rights, cannot claim a right to file an additional written statement contending that they have a case on merits. There being no infirmity in the order passed by a trial court, the petition stands dismissed.
Yes, sorry.
27, Anandar Kolli, please.
My lords, right applications, my lords, instead of, my lords, respond number 3. the block
Disposed of
education-
matter, my lord.
Disposed of, my lords. Due to oversight, my lords, the block education officer coupled
IA 1 of 24.
in the last occasions, my lords,
1 of 24 for rectification.
Yes.
Yes.
Thereafter, my lord,
Oh, and
amendment.
amendment act.
yes, amendment.
IA 1 of 25 has been filed seeking for amendment of the cause title of the petition. The submission of Sri Anand Kolli, learned counsel for the petition, is that by inadvertence, the block education officer couples had been shown as respondent number 3 when it ought to have been the block education officer Elburga. Accepting his submission, IA 1 of 25 is allowed. Petitioner is permitted to carry out necessary amendment and file amended cause title. Consequently, registry is directed to issue a fresh certified copy in terms of the amendment carried out. IA 1 of 24 does not require any consideration or consideration, since IA 1 of 25 has been allowed, and as such IA 1 of 24 stands dismissed.
28, Prakash, Gurudin,
My lord, recalling application, my lord. Respect of that, needful has been done, not. Respect of that, needful has been done, not. Compliance.
Recall.
Please.
ಏನಕ್ಕೆ ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು?
For non-prosecution, my lord. For non-compliance of office objections.
ಯಾವಾಗ ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು?
On 19
Dismiss for non-
19 to 24, my lord.
19 to 24. Compliance ಮಾಡಿಲ್ಲ. Is permitted to comply. ಮಾಡಿದ್ದೀರಾ?
Please. I complain, my lord. Please.
Clearly the compliance has complied with all. The above petition had been dismissed for non-prosecution on account of non-compliance of office objection by order dated 19/2/24. Hence, IA 1 and 2 of 2024 have been filed for condemnation of delay of 184 days and for recalling the aforesaid order. Accepting the reasons stated in support of IA 1 of 2024, pending consideration of the said applications, the petitioner was permitted to comply with the office objection, being the cause for dismissal, non-compliance of which was the cause for dismissal. Registry has put up a report that all office objections have been complied with. Hence, IA 1 of 24 is allowed. The delay of 184 days is condoned, subject to payment of cost of rupees 2,000 to the advocate clerk so-and-so. By allowing IA 2 of 2024, the order dated 19/2/2024 is recalled. The petition is restored to file. Yes.
Please, suit is for, my lord, specific performance of contract and prohibitory injunction. Filed an application, I number 4 of under order 11 rule 14, my lord. And that application has been dismissed, my lord. That application has been dismissed. On the ground that, my lord, that page number, my lord, 49, my lord. Kindly page number 49. Para number 9, my lord. The said provision is not applicable, madam, when a party himself is to produce the documents. Merely on the
Ian,
technical,
what document do you want?
I am relying on the document of agreement of sale, my lord.
Where is the application.
Page number, my lord. 32, my lord, annexure C. Only based on the wrong provisions mentioned in the application, my lord, application has been dismissed.
11 rule 14. Issue notice to the respondents returnable by 17th April. Counsel for the petitioner is also permitted to serve the counsels for the respondent before the trial court.
I request, my lord, I'm seeking for a stay, my lord. He posted for evidence.
After 2 years, you are coming.
All right. Earlier counsel has given no objection, my lord. Appeared filed wakalat, my lord.
Serve Madi, move Madi. Liberty is reserved to the petitioner to move the matter after service is complete.
Please, please.
29.
Petitioner is also permitted to take out and summons to the defendants,
Please.
the respondents.
29. Party in person. Gokarneshwar Temple. D. Venkan Gowda.
Lord, they are seeking a writ of mandamus to the civil court to dispose of the petition which is pending for the last 2-3 years.
Last
2 years.
2 years.
South. No proceedings. It has been posted for orders. No orders have been passed for the last 2 years. From page 23, it starts. 22 in an application with regarding to maintainability of the suit. For that, my lord, the civil court has posted for orders and it is not commenced.
C has rejected his request. Form C has not been given.
That is the prayer which has been sought in the petition.
None appears for the petitioner. The party in person committee. The petitioner is not present in person. Petitioner alive temple. ಯಾರು ಅದು ಎಷ್ಟು ಕೇಸ್ ಇದೆ ಅವ್ರದ್ದು ಎಷ್ಟು ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ ಅವರು
ಅಲ್ಲ ಹಂಗೆ ಕೇಸ್
ಆಗ್ತಾನೆ ಇರ್ತಾರೆ ಇದ್ರದ್ದು ಏನೇನದು ಆಗ್ತಾ ಇರ್ತಾರೆ ಬಟ್ ಈಸ್ ಈ ಪರ್ಸನಲಿ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇನ್ ಎನಿ ಆಫ್ ದೆಮ್ ನೋ the representative of the petitioner who has sought for permission to appear as a party in person is not present before this court. The party in person committee has rejected his request to appear as a party in person. To enable the petitioner to appoint a counsel to be represented in the matter, released on 24th March. IA 1 of 2024 stands rejected.
30. DLR Khan.
Lord, last date of hearing, impleading applicant came to the application came to be allowed and amendment is carried out, my lord. If they have got any objections, that has to be filed. If the pleadings are
There are no objections.
there are no objection. Tomorrow itself, I'll argue the matter. my lord. Tomorrow itself.
Objections to allow your petition.
Need to file a statement of objections of the impleading. On the last date of hearing, you will apply please to allow the A for impleading. And I have been impleaded as a respondent number 10. I need to file my statement of objections.
When will you file?
File ಮಾಡಬೇಕು my lord.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡ್ತೀರಾ ಹೇಳಿ?
And two weeks.
Objection if any to be filed by 14.
ಹೌದು ತಾವು ಹೇಳಿದ್ರಿ ಪಟ್ನೆ ಏನಪ್ಪ ನನ್ನ ಪರ್ಸನಲ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಐ ಡಿಡ್ ನಾಟ್ ಗಿವ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಟು ದಿ
You are delaying the proceedings.
I need it next week, please.
The counsel for respondent number 10 seeks for and is granted 10 days time finally to file a statement.
Please,
of
my lord.
Objections if any to be filed on or before 4th March, failing which will be taken as not filed and matter proceeded with, relist on 10th March.
Please, oblige.
31. Vittal Tili.
But 31. There was a direction, my friend.
The last occasion, the Lordship has directed me to secure the records pursuant to the remand order having been. Yesterday evening, I have received. Pursuant to the remand, my lord, a land tribunal has passed an order in the year 1986 itself, rejecting the claim. But on going through the land tribunal order, the reference insofar as 757 form survey number is not forthcoming in that.
ಇದು 750.
ಈ 757 ಇದೆ.
I request short date, my lords. I could not.
ಅದು ಇಲ್ಲ ಇದರಲ್ಲಿ. And one more submission, my lord. And also on going through said, it has been noticed that
Anyway,
he has already,
ಅವ್ರು ನೋಡ್ಕೊಂಡು ಅವ್ರು
for every year he has collected the money in the year 19 up to 1980 ಮಟನು ದುಡ್ಡು ತಗೊಂಡಿದ್ದಾರೆ ಅವರು.
ಇವಾಗ we are not going to.
Yes.
Learned AGA submit that the records have been received. In that view of the matter, the appearance of the chairman of respondent number 1 is dispensed with.
Please.
Learned AGA submit that the said records would be made available for the counsel for the petitioner and respondent number 6 and 7.
Please.
To take inspection of in the Advocate General's office.
Please.
Counsel for the petitioner and respondent number 6 and 7 are permitted to take such inspection, get ready and to address their arguments. Relist on 21st March.
32, Pallavi Achapure.
Lords, I made an application seeking amendment, my lords, in the cause title. So far as respondent number 2 is concerned, my lords, by oversight, my lords, I have mentioned as CMC Kudligi. It has to be a town municipal council company, my lords.
IA 1 of 25 has been filed seeking for amendment of the cause title. Submission of learned counsel for the petitioner is that by inadvertence, respondent number 2 has been shown as City Municipal Council Kudlgi when it had to be Town Municipal Council Kampli. Accepting a submission, IA 1 of 25 is allowed. Petitioner is permitted to carry out necessary amendment and file amended clause title. And what is this?
So I will accept notice. So for as R2, my lords, if it is complete municipality.
Completing.
Sri B. Shanavasava.
ಇಲ್ಲ on the earlier occasion also notice was ordered, but it was Kudligi municipality.
File ಮಾಡಿ. 32.1 correct ಇದೆಯಾ?
32.1 correct. Correct ಆಗಿದೆ.
ಅದು correct.
ಮತ್ತೆ 6 years ಅಷ್ಟೇ ಅಲ್ಲ ನೀವು ಮಾಡಕ್ಕಾಗೋದು?
ಹೌದು 6 years ಅಷ್ಟೇ ಮಾಡಿರೋದು. As per the order of my lords, this honorable court.
12/13 ಇಂದ ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ದೀರಾ?
ಅದೇ 2017 for the first time we have issued notice asking my lords them to pay the property tax from the year 2005-6. The honorable court has held that my lords, you cannot go beyond 6 years, you can collect. Therefore, we have calculated from the period 11-12. And thereafter, my lords, in view of the pendency of the
Petition copy ಇದೆಯಾ?
ಇದೆ ಅದರಲ್ಲಿ ಇದೆ.
Page 25 ತಗೊಳ್ಳಿ.
Yes, ma'am.
2012-13 ರಿಂದ 24-25.
First case, I don't have the petition.
First case ಇಲ್ವಾ?
ಇಲ್ಲ petition
Second
ಇಲ್ಲ.
case correct ಆಗಿದೆಯಾ?
ಇಲ್ಲ second case ಅಲ್ಲಿ petition ಇದೆ. So I have the petition because I have not taken notice.
ನೋಡಿ ಅಷ್ಟೇ ಏನಿದೆ?
ಅಲ್ಲ ಇದ್ರ ಬಗ್ಗೆ ನಾನು I will get instructions. But insofar as this case is concerned, the second case.
Deal with both of them together.
Please.
ಯಾವಾಗ?
10 days time because I will have to file objections.
Seeks for and grant 10 days time to obtain instruction, make a submission. Released on 10th March, interim order earlier granted is extended till next date.
Please. In those cases, my lords, in the complete municipality case, I was told that, my lords, notices were issued to the petitioners.
So you
in their
directed
case.
them to pay for 6 years.
Yes, but
The
even
conditional
prior
order.
to that, my lords, notices were issued to them.
Show us that.
Yes, sir. I will file.
Demand ಮಾಡಿರ್ಬೇಕು within the time.
Please.
Demand ಮಾಡಿದ್ರೆ ಅದು ತೋರಿಸಿ.
Please.
Then we'll direct them to pay.
Please.
33, everybody back?
After notice were issued, some death is reported.
R1,
A. I'll just verify and my lords, sir.
R1A is.
And 2.
R2 are dead.
Yes.
CPC.
R1 had died, 1A to 1J are the LRs. I'll verify in my lords, sir. I'll file appropriate memo or if any LRs are there.
Petitioner seeks fund is granted 3 weeks' time to file necessary application to bring the legal representative proposed respond number 1 capital A and respond number 2 as also to make payment of process fee in respect of R1D and 5. Released on 17th March.
Oblige.
34, 3 are still open.
Interim order may be
Interim
extended.
order earlier granted is extended.
34, she has still open.
Counsel for the petitioner has filed a memo for deletion of respond number 14 and 15 from the array of parties. Accepting his submission, the petition, respond number 14 and 15 are deleted from the array of parties at the sole risk, cost and peril of the petitioner. Needless to say, respond number 14 and 15 will not be bound by any orders passed by this court. Memo for reporting. None appears. Delist on 24th March.
35, Sangram Kulkarni.
R3. ಏನಿದು?
In this case, my lord, R2 and 3 has to file. It has been direction by this honorable court, my lord. In spite of receipt of some notices, my lord, they have not appeared. My lord, because the Gram Panchayat of Jugul is now comes under my lord, Kagwad Taluk. Whereas the order has, impugned order has been passed by the earlier Taluk
ಸರ್ವಿಸ್ ಆಗಿತ್ತು.
Athani, service ಆಗಿದೆ ಸ್ವಾಮಿ.
ಯಾಕೆ ಬರ್ಲಿ?
ಇದರಿಂದ ಅವರು ಅದಕ್ಕೆ ಅಲ್ಲಿ ಫಾರ್ವರ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಅಥಣಿಯಿಂದ ಕಾಗವಾಡಿಗೆ. That's why.
Counsel for respond number 2 and 3 submits that Jugul Gram Panchayat was earlier coming
Now
within
earlier in the Athani Milan.
Athani jurisdiction. And as such, the service of summons was forwarded to Athani Gram Panchayat.
Kagwad, it has been now transferred to Kagwad Taluk Panchayat. It comes now under the
Jugul Gram Panchayat comes under Kagwad Taluk.
Now, presently.
As such, representation could not be made. Since the explanation appears to be plausible, it is accepted. Filing of affidavit on behalf of respond number 2 and 3 is dispensed with. Yes.
My lord, I have filed an application seeking amendment, my lord.
Amendment?
Amendment, my lord.
An amendment?
My lord, in the prayer column, my lord, instead of mentioning respondent number 3, it has been wrongly mentioned as respondent number 2, my lord. And annexure E is what is challenged, my lord.
What is the amendment you sought for?
My lord, to
instead of
correct date as 3/3/2020, it has been mentioned as 9/3/2020, and respondent number 2 is to be amended as respondent number 3.
Correct ಆಗಿ ಬರ್ದಿಲ್ಲಲ್ಲ ಸಂಗ್ರಾಮ್.
During COVID ಅವಾಗ ಇಲ್ಲಿ ಹೇಳಿ ಅದು
ಇಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ದಿಲ್ಲ ನಿಮ್ಮ
Yes, my lord, in amendment sought ಅಂತ ಇದರಲ್ಲಿ Roman 1.
You said it is kindly be corrected.
My lord, in
Permitted
para
to be
4.
amended ಅಲ್ಲ. Everywhere you are saying correct.
Seeking amendment, my lord. Seeking amendment.
ಅಲ್ಲ ಅದನ್ನು ಕರೆಕ್ಟ್ ಆಗಿ.
Yes.
And lordship order which has been impugned, my lord, that order itself has been not produced.
ಇಲ್ಲ produced, my lord.
Now by way of amendment, my lord,
Read petition will produce, my lord.
Taluk Panchayat has passed the order, my lord, appeal order.
Will allow it you file your objection.
Please.
IA 1 of 25 has been filed for amendment to the petition. The submission of Sri Sangram Kulkarni, Lion Counsel for the petitioner is that by inadvertence and typographic error, the dates and the array of parties has been wrongly mentioned. Accepting the reasons stated in support of said application, IA 1 of 25 is allowed. Counsel for the petitioner to carry out necessary amendment, file amended petition. Copy of the amended petition to be furnished to the respective counsels for the respondents by on or before 6th March, who are granted 2 weeks time thereafter to file their respective objection, which shall be filed on or before 20th March.
My lord, it may kindly be kept on Monday, my lord. The order that has been challenged is
All objection time.
delay application was not considered, my lord. in this.
Released on 24th March.
Please.
It's a 2020 matter.
Interim order.
Interim order idea.
ಇಲ್ಲ.
Interim order earlier granted is extended till next day. Yes, Mr. Saukar.
Seeking for a hand delivery of the notes. Serial number 19, SC/ST matter notes.
Hand delivery ಏನಕ್ಕೆ ಬೇಕು?
Now the, he is got a name entered and
Hand delivery.
disturbing the position.
Right. Yes.
Please, 19 preliminary.
Serial
Yes,
number
Vijay.
1. I'm sorry, but serial number 1. Lordship has
My
ordered to
personal-
post the matter on Friday 2:30. Since
Your lordship is pleased to post it on Friday. Fridays, I'm at Bangalore, but I request your lordship
He'll
kindly.
be here only.
Yes,
Mr.
May I
Patil.
request,
Ready,
sir,
counsel,
request
yes,
ಮಾಡ್ಕೊಡಿ.
Monday,
Tuesday ಆಗ್ಲಿ, 25th.
that's one time. Monday it may be posted.
Each other doubt.
Monday, it is posted at 2:30 on Friday, my lord. Monday 2:30 it may be taken.
Friday there is a slot. Monday, Tuesday, 86 matters are already listed. Plus
Wednesday
fresh
good
filing ಆಗಲ್ಲ.
Wednesday holiday.
One relist on 24th at 2:30.
My lord, serial number
24th.
91.
24th.
Monday.
Please.
ಏನು urgency ಏನು?
He has been retired. His salary has been brought to minimum basic. 10 lakhs rupees impact is there.
91 relist on Monday at 2:30 PM.
Let's
Serial number 37, my lord.
37.
But I had to take steps because after issuance of notice, I came to know that this one
37,
was.
counsel for the petitioner seeks for and is granted 3 weeks' time to file necessary application, bring the legal deceased respond number 4 on record. Relist on 24th March. Yes,
Let's
madam.
serial number 46, Mulats. The other
46.
council name may be deleted. 1 week time, Mulats, I'll do the needful. Hand summons was,
He is directed to delete the name of Shri T.M. Nadaf as that appearing for the petitioner. Counsel for the petitioner seeks for and is granted 2 weeks' time to comply with the office objection and to serve the hand summons. As also to serve the hand summons. Relist on 20th March.
grateful, Mulats. Interim order may kindly be.
Interim order earlier granted.
Let's serial number 52, Mulats. It seems like TM Nadav's name should be shown, Mulats, because he had filed wakalat. RM Nadav's name is shown. I undertake to file wakalat for
T.M.
the
Nadaf
petition.
ಇರೋದು ಇದು.
Costly staff.
ಅದಕ್ಕೆ delete ಆಯ್ತು.
I undertake to file wakalat for the petitioners.
ಗಾಯತ್ರಿ SR ಅಂತಾನು ಇದೆ.
Serial number 52 ಅಲ್ಲಿ.
46 ಅಂದ್ರಲ್ಲಮ್ಮ.
ಅದ್ ಮುಗೀತು. ಇನ್ನೊಂದು serial number 52 ಅಲ್ಲಿ RM
RM Nadaf ಅಂತಿದೆ.
the petition,
You have 46, what is, you are not making any submission.
that is the correct submission for
Your
46.
next submission.
Yes.
50, buy one, take one free. ಏನಿದು?
I undertake to file wakalat for the petitioners.
It should be TM Nadaf.
Mistakenly,
Gayatri SR submit that she would be filing wakalatnama for the petitioner and she seeks for 3 weeks' time to file necessary application to bring the legal representative deceased respond number 3 and 10 on record. Relist on 24th March. ನೀವು ಅದರಲ್ಲೇ ಇದ್ದೀರಾ.
74, my lord. Last occasion, this honorable court has directed me to produce certain documents. I informed them not about the
ಇನ್ನ ಎಷ್ಟು ದಿನ ಆಗುತ್ತೆ?
1 week, my lord.
Counsel for the petition seeks fund is granted 3 weeks' time to produce, to comply with the earlier order. Relist on 24th March.
52, my lord. Nadaf's name has to be deleted. TM Nadaf.
52.
TM
ಅವ್ರು ವಕಾಲತ್
Nadaf.
ಹಾಕಿದ್ಮೇಲೆ she has to file ವಕಾಲತ್ ಅಲ್ವಾ? ಡಿಲೀಟ್ ಮಾಡ್ಬಿಟ್ರೆ ಆಮೇಲೆ ಯಾರು ಸಿಗಲ್ಲ.
Number 71 on dismissal supply my
ಕೊಡ್ಲ. ಹನ್ನೊಂದ ಮಾಡಿದ್ರಲ್ಲ ಅವ್ರು ಇರ್ಲಿಲ್ಲ. ಹಾ ಕೂಡ ಇಲ್ಲ, ಯಾವ ಬಂದಿಲ್ಲ. ಸರಿ ಬಂದೆ ಕೊಟ್ಟಿರ್ತೀನಿ. ಅಲ್ಲ ವರ್ಷದಲ್ಲಿ ಕೊಟ್ಟಿರೋದಲ್ಲ ಒಂದು ಕೊಟ್ಟಿರಲ್ಲ ಅವಾಗ
ಒಂದು ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ
ಒಂದು
ಇನ್ನೊಂದು 4 ಮಾಡಿಸ್ಬಿಟ್ಟೆ 4 ಅಂತ ಹೇಳಿ 4
ನೀವು ಹೇಳ್ತೀನಿ ಮೇಡಮ್ ಅವ್ರು ಕಲ್ಲೂರ್ಗೆ ಹೇಳ್ಬಿಡ್ರಿ 19 ನಿಮಗೂ ಬರ್ಕೊಂಡ್ರಿ, ನಾ ಬರ್ಕೊಂಡಿಲ್ಲ, ನಾ ಬರ್ಕೊಂಡಿಲ್ಲ.
ಶ್ರೀರಾಮ 19 ಒಂದು ಡೇಟ್ ಹೇಳಿದ್ರಿ, ಯಾವ ಮಾರ್ಚ್ ಯಾವ ಒಂದು ಡೇಟ್ ಕೊಟ್ಟರು?
ಮಾರ್ಚ್ ಇಲ್ಲ ಸರ್, ಏಪ್ರಿಲ್ ಕೊಟ್ಟಿರ್ಬೇಕು.
ಸರ್ ಬೆಂಗಳೂರು 19
16th ಏಪ್ರಿಲ್
16th ಏಪ್ರಿಲ್ ಸರ್ ಬೆಂಗಳೂರು
24/3 28 ಮಾರ್ಚ್ 28 ಮಾರ್ಚ್ ಯಾವುದು ಬರ್ಕೊಳ್ಳಿ, ಲಾಸ್ಟಿಗೆ ಕೊಟ್ಟಿದ್ದೆ
24 3 ವೀಕ್ಸ್ ಅಂತ ಏನಂತ
3 ವೀಕ್ಸ್
ಅಂತ ಸರ್ ಬೆಂಗಳೂರು
24/3
ಸರ್ ಬೆಂಗಳೂರು ಅದು ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಇದೆ 19
ಕಲಬುರ್ಗಿ ಎರಡು ಇತ್ತು ಸರ್.
ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ
ಸರ್ ಅದೇ ಹೇಳಿನಿ ಮೇಡಮ್ಗೆ ಆಗಿದೆ, ಇವ್ರಿಗೆ ಆಗಿದೆ, ಇವ್ರಿಗೆ ಡಿಕ್ಟೇಷನ್ ಇವ್ರು ತೊಗೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಬೆಳಿಗ್ಗೆ
ಅದನ್ನ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ನಿಮಗೆ ಹೇಳಿದ್ದಾರೆ, ನೀವು ಅದನ್ನ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ಬೇಕು ಅಲ್ಲಿ ಅಂತ ಹೇಳ್ತಾ ಇರೋದು. ನಾವು ಒಂದು ಬಿಟ್ಟು ಇನ್ನೊಂದು ಹೇಳಿದ್ರೆ ಏನ್ ಮಾಡೋದು? ಅದಕ್ಕೆ
ನೀವು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಆಕ್ಚುಲಿ ಫೋನ್ ಮಾಡಿ ಹೇಳ್ಬಿಡ್ಬೇಕು ಅವರಿಗೆ. ಅಲ್ಲ ಕರೆಕ್ಟ್, ಯಾಕಂದ್ರೆ ಅಲ್ಲ ಜಾಸ್ತಿ ಲೆಂತ್ ಡಿಕ್ಟೇಷನ್ ಇದ್ರೆ ಯು ಕಾಂಟ್ ಸೇ ಇದೆಲ್ಲ ಆರ್ಡರ್ ಎಲ್ಲ ನನಗೆ ಹೇಳಕ್ಕಾಗಲ್ಲ, ಬರೀ ಅದರಲ್ಲಿ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ನೋಟ್ ನೀವು ಯಾರಾದ್ರೂ ಮಾಡ್ರಿ ಒಟ್ಟು ನಮಗ್ ಶ್ರೀರಾಮರ ಯಾರಾದ್ರೂ ಮಾಡಿ ನಮ್ಗೆ ಒಟ್ಟಾಗುತ್ತೆ, ಬಟ್ ಆರ್ಡರ್ ಬಂದ್ರೆ ಸಾಕು. ಅವರು ಮಾಡ್ತಾರೆ, ಅವರು ಜವಾಬ್ದಾರಿಯಿಂದ ಮಾಡ್ತಾರೆ, ನೀವು ಮಾಡ್ತಾರೆ, ಬಟ್ ಆದ್ರೆ ನಮ್ದೊಂದು ಲಾಸ್ಟ್ ಕೇಳೋದಿರ್ತಲ್ಲ. ಅದೇ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಆರ್ಡರ್ ಆಗಿದೆ ನೋಡಂದ್ರೆ ಅವ್ರು ಮಾಡಿ
Sir?
Kalburgi bench matter. 1. Arun Kumar, Amargundappa.
Dharwad ಗೆ join ಮಾಡ್ಬೋದು. Kalburgi. So continue.
Kalburgi bench matter. Arun Kumar, Amargundappa.
None appears for the state released on 6th.
Dharwad bench matter. 230 matter. 104. Prakash Jawalkar.
My lord, this is in respect of the layout permission which I had filed. And
Shilwant appears for them.
yes. And on the last occasion, he was making a submission that the amount which I had paid is refunded anta helta ida. And I have verified through my accounts. I am having the complete account statement with me, and no such refund has been made. Amount paid by me is almost around 30 lakhs.
Where is Mr. Shilwant? Asur.
This.
105 adjourn. 106. KL Patil.
This is on the last occasion, the Lordship has that the learned AJ pass on this memo along with it.
Now the deputy commissioner is consented from the 3 different sources. He will arrange the fund and he will.
Funds will be used only CST.
Please.
Yes, Mr. Patil.
Hello, senior counsel.
Yes, Mr. Chandrasekhar.
My lord, am I audible, my lord?
Yes, very much.
Yeah. My lord, certain things, my lord, I would like to place on record, my lord. Even the both the courts have considered this aspect, my lord.
Yes, please.
May I request your lordship kindly see, my lord. It is also placed on record, my lord, the order passed by the president of the municipal council, wherein, my lord, it was directed to stop the construction. My lord, he has exercised that power, my lord, under section 43. My lord. May I request your lordship kindly see, my lord, section 43.
43 of
Municipalities Act.
Municipalities Act.
Yes, my lords.
Municipalities Act. Sriram.
43(2), my lord.
Arshad aisa illa. Subsequently.
43.
Subclause 2, my lord.
Yes.
The president of a municipal council may, in exercise of emergency, direct the execution or stoppage of any work or doing any act which requires the sanction of the municipal council. In exercise of this power, my lord, he has directed
But
to
the
stoppage
council
of,
has said otherwise, Mr. Chandrasekhar.
yes, my
How
lord.
can he act against the council?
Lord, council has not taken any steps, my lord.
Council has approved it.
No, my lord, it is not been approved, my lord, by the council. Council is not at all there, my lord, as on this date.
Where's Mr. Desai? Mr. Desai has made a submission that it has been approved by the council.
With great respect, my lord, my instructions are, my lord, the president makes an order first. After few months, my lord, the commissioner, my lord, passes an order to continue. My lord, my respect.
I request my lord to kindly take the document which you have produced.
Page.
My lord, yesterday I placed some records, my lord. That is on 19/9/2022.
Page.
Page 8 of the compilation. At the instance of the president, it was interrupted. Page 8, my lord. Kindly mark the date also, my lord. At the instance of the president, ಅಧ್ಯಕ್ಷರು ನಗರಸಭೆ ದೂರವಾಣಿ ಮೂಲಕ ಸಂದೇಶ ನೀಡಿದ್ದು ಕಾರಣ ಸದರಿ ಕಾಮಗಾರಿಗಳನ್ನು ಸ್ಥಗಿತಗೊಳಿಸಲು ಈ ಮೂಲಕ ಕೋರಲಾಗಿದೆ. Is individually has given a direction. Subsequently, my lord, at page 5, on 7/10/2022, considering the release order from the KBGNL. So with
Is the order of the, where's the resolution of the council? The order on, not the commissioner. There's the order passed by the council is the submission made. So where is that? Council Delhi.
That is not available, my lord, as on today. This is the only order, my lord, which.
No, the commissioner is different. Then it is the commissioner versus the president. Agata.
An administrator, my lord.
There is no council.
As on that date, there was no, the body, elected body was not there.
ಇವತ್ತು ಕೌನ್ಸಿಲ್ ಇದೆಯಾ?
ಇವತ್ತಿದೆ, ಇವತ್ತಿಲ್ಲ.
ಇವತ್ತಿಲ್ಲ.
ಅವತ್ತಿತ್ತು, ಪ್ರೆಸಿಡೆಂಟ್ ಇದ್ದಾಗಿತ್ತು. When president gave an order, otherwise, my lord, it is not an order of a president. There is no requirement for the commissioner to act on the my lord, direction of the president. As on that day, president was in the office. In exercise of the power, my lord, under section 43 subclause, which is traceable to 43 clause 2, he gives a direction, stop it. And the construction was stopped. The commissioner, your lordships have now just seen, my lord, the commissioner writes a letter contrary to the order of the president.
Yes, now there is no president.
My lord, there is an order in existence unless the order is set aside in a manner known to law. My lord, that order is bound to be there, my lord, and it is required to be complied by the corporation commissioner also.
That argument cannot be made.
But this is one aspect of the matter, my lord.
Change in the executive order, if you are saying executive order cannot be changed.
My lord, there is an order, my lord, of the council directing them to stop.
Where is the order of the council?
There is no order of the council. It has not been placed before the council.
So it's an order by the president under subsection 2 of section 43
Yes,
as a president, which is an executive order, not of the council.
My lord, that is what, my lord,
There's a
I
council
wanted.
order, that's why we are asking. If there's a council order to stop or to permit, that's a different, the commissioner cannot do anything, nor then the president can do anything.
Lord, what I am trying to say, my lord, in exercise of the power conferred under section 43(2), the president has exercised that power and stopped the construction.
So that any order passed by the president cannot be changed for eternity unless it's set aside by a court. Is
Lord,
that your submission?
that would be my respectful submission, my lord.
Mr. Chandrasekhar, that will
There
go
is-
with
there
your
is-
name. That submission will
there
go
is-
with your name. We are only putting it
Yes,
across.
my lord, there is no reason for the commissioner to overrule the order of the president.
So it only has to be set aside by a court.
That
Is your
would be my submission, my lord.
Yes, please.
This is one aspect of the matter. Now kindly see, my lord, section 193.
Section 190.
193 of the Municipalities Act.
Let us see that
I'm sorry, my lord. What 203, my lords.
20. Let us see that President's order once again. Page.
Page 8, madam. President. Adhyaksha Nagara Sabhayavara ಮೇಲೆ
8 is not by the President.
ಅಲ್ಲಲ್ಲ. He has stopped.
My lord, stop. My lord, it is signed by the commissioner. He gives a direction, my lord, to the commissioner.
Now, where is the order of the President that you are speaking?
No,
it
no
is
order.
telephonic. There is
No
my
order.
lord, it is, the contents of the letter will indicate, my lord, it is a president's order.
No, you are relying on
Order,
subsection.
order in the sense, no, it
Mr.
is a
Chandrasekhar,
oral.
you are relying on subsection 2 of section 43
Yes,
and referring to the Commissioner's order.
yes.
Where is the President's order?
President has telephonically, my lord, instructed.
And according to a telephonic instruction of the President is an order under subsection 2 of section 43.
My lord, it cannot be termed anything else, my lord, other than the order passed under 43(2).
Yes, please.
Now, section 203, my lord.
203.
Yes.
Yes.
Subclass 2, my lord. No building shall be newly erected or rebuilt over any sewerage or drain, culvert, gutter, so and so. There is a total prohibition, my lord, to put up any construction over the drain.
So you want it to be pulled down now?
It is not yet constructed as far as we are concerned.
That entire drain will have to, that whatever has been constructed is the culvert.
Over the drain.
Over the drain is the slab.
Yes. Lord,
So
no
where is the
building
permission?
shall be newly
Where is the
erected or
permission for
rebuilt.
where is the permission for the slab?
My lord, the corporation itself has done it, my lord. My lord,
Where is
first, since my lords have asked me, my lord, we have taken permission, my lord, before the slab on the drain was constructed. My
We
lord,
and who are you? Who are,
my lord, the petitioners, that is plaintiffs. My lord, we have placed on record permission to put up a bridge across, my lord, the road over the bridge, over the sewerage, my lord, was granted. A written permission
where
was
is that?
granted. My
Where
lord,
is that?
your lordship will kindly see, my lord, we have produced along with the objection. Memo, my lord, my learned friend will be in a position to show. The bridge was constructed at the cost of the petitioners, I mean plaintiffs. Plaintiffs have constructed the bridge, my lord, about 30 years back. Around
page
some
number.
of them are 18 years, some of them are 20 years. We have produced, my lord, the permission given by the municipality to construct, my lord, the bridges over the existing sewage line. Thereafter, my lord, corporation took it and, my lord, modified and put a new slab over it. We have placed it on record.
Where is it? When did you produce it? Date, page number?
My lord, on 17/2/2025, I filed memo along with the permissions.
ನೀವು ಹಂಗ್ ತೋರಿಸಿದ್ರೆ ಹೆಂಗ್ರಿ ಗೊತ್ತಾಗುತ್ತೆ?
On 17/2.
ಡೇಟ್ ಹೇಳಿ.
17/2.
17/2 memo.
At the cost of the plaintiff, my lord, the bridges were constructed over the sewerage.
Mr. Chandrasekhar, please show us which document. You are repeating that 4 times. We don't expect us to tell you.
Lord, the
ಯಾವ
document.
ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ ನೋಡೋಣ. ಯಾವ್ದು ಈ ಮೆಮೋ ಅಲ್ಲಿ ಯಾವ ಪೇಜ್ ನಂಬರ್?
2, 3, my lord.
2.
2, 3, 4, 5, 6, 7, 8.
So you are permitted to put up this RCC slab.
Yes, my lord.
This is GL. Is plaintiff number? Plaintiff number?
No, my lord, he was not a party, my lord, some other person.
Then you are not representing that person.
Page number 8, my lord.
Page number 8.
8, yes. That is the plaintiff petition. It's not
8 yaar euro.
plaintiff.
Panchaksharaya. Jagdishwaraya. Their plaintiff number?
1.
Jagdishwaraya. Panchaksharaya illa.
There's
We are really surprised by these arguments. If you are relying on some permission given in your favor, you should be the plaintiff. If you are not plaintiff, you are relying on somebody else's permission.
No,
How can you do that?
ನಾವು ಅರ್ಜಿದಾರರು ಪಂಚಾಕ್ಷರ ಜಗದೀಶ್ವರಯ್ಯ ತಂದೆ ಅಡಿವಯ್ಯ ಹುಬ್ಬಳ್ಳಿ ಮಠ ಆಜಾದ್ ರೋಡ್ ಇನ್ ಪೇಜ್
ಜಗದೀಶ್ವರಯ್ಯ ಆಯ್ತು, ಒಬ್ಬರು ಆಯ್ತು.
Yes.
ಒಂದೇ ಪರ್ಮಿಷನ್.
ಒಬ್ಬರು.
ಬೇರೆ ಯಾವ ಪರ್ಮಿಷನ್ ಇಲ್ಲ, ಇದೆಲ್ಲ ಪರ್ಮಿಷನ್.
Other persons permissions page number 2 and 3 and
ಅದೇ ದ ಪ್ಲೇಂಟಿಫ್ಸ್ ಮಿಸ್ಟರ್ ಪಾಟೀಲ್. ಇಬ್ಬರಲ್ಲಿ ನಾವು ಹಿಂಗೆ ಅವ್ರಿಗೂ ಕೇಳಕ್ಕಾಗಲ್ಲ, ನಿಮಗೂ ಕೇಳಕ್ಕಾಗಲ್ಲ. You don't make it like this.
Except that plaintiff, no other plaintiff has.
My instructions are that this is the amount spent for the construction of the drainage under the Nagrottana scheme. Total cost of the scheme is.
ಯಾವುದು ಒಂದು ಇವಾಗ ಓದೋಣ ಏನು ಅಂತ.
So far as this is concerned, it is like this, across the drain.
So
when it was not covered.
Let me Chandrasekhar complete his arguments. MM Patil, our instructing counsel interrupt ಮಾಡ್ತೀನಿ, ನೀವು ಬೇಡ.
And not just one, not 10 of such ways are maintained.
Let him make it. Yes, Mr. Chandrasekhar, the page number 8.
Yes, my lord. This is only for a limited purpose to show, my lord, that the construction of the bridges over the drainage was undertaken, my lord, way back, my lord, and the people are using, my lord, those bridges to cross over to, my lord, their shops. Thereafter, my lord, the corporation has remodified the entire structure, pulled down, my lord, the bridges constructed by the plaintiff, and thereafter a new one is, my lord, put up by the corporation at their cost.
So what is the purpose of relying on this which is already been demolished?
Only for a limited purpose to show that they were using, my lord, to cross over from the road over the bridge over a in my lord, about 15 to 20 years, in some cases 30 years. It is only for that limited purpose.
Where is the location of this? Where is the location of this bridge, Mr. Chandrasekhar?
Just in front of the plaintiff shop.
ಅಲ್ಲ, ನೀವೆಲ್ಲ ಹಂಗೆ ಹೇಳಿದ್ರೆ you are not showing us any documents. You are not showing us any sketch. You are not showing us any photograph.
But it was all produced, my lord, in the trial court. The learned trial judge and, my lord, the lower appellate court, my lord, have considered these photographs and.
Then we'll do one thing. We'll set aside the trial court order and ask you to go and argue there. Or we'll say that you are not producing anything here. Please don't make this kind of submissions.
No, my intention is not that, my lord. I'm only trying to assist the honorable court, my lord, to arrive at a decision. Only to show, my lord, that this passage was used, my lord, by the plaintiffs over a period of time. Suddenly, my lord, putting a barricades, my lord, across our shops will prevent, my lord, people from coming to our shops, which will cause, my lord, great prejudice and hardship to us. My lord, is the simple submission, my lord. Even
That submission we understand, but your documents on which basis you are making that submission is absent. So in the absence of any document, we can't accept any submission.
My lord, these documents were produced, my lord, in the trial court, my lord. The learned trial judge has appreciated, looked into, and the photographs were also looked into, and thereafter passed, my lord, the impugned order.
Okay, we'll
Even
leave
in
it to
the
your
appellate
wisdom
court-
to make your arguments. We'll deal with your submission. Yes, next.
My lord, the drainage, my lord, is vested with the corporate, my lord, municipality, and the municipality is having the absolute right over the drainage. It is their decision, my lord, which is required to be taken into consideration.
Yes.
Not, my lord, any other agency, my lord, dealing with the is impermissible in law, my lord, is my respectful submission.
Yes.
Two not three deal with that, my lord, the right, my lord, vesting of the drainage, my lord, with the municipality. And now your lordship will kindly see, my lord, the petitioner before my lord, the defendant number 2, who is unconnected, my lord, with the affairs of the municipality, suddenly, my lord, make the proposal to construct, my lord, the park and play field. Therefore, my lord, the plaintiffs.
Defendant number 2 is the Commissioner Gadag Batigari City
Fourth
Municipal.
defendant, my lord, fourth defendant.
Fourth defendant is the project engineer.
Yes, my lord. He is the petitioner before my lords, my lord, now. He has come before this court.
He is the executing agency. Please.
Yes.
Yes.
Corporation has not come before the court. Deputy Commissioner has not come, my lord, challenging the order. It is only the fourth defendant, project engineer, my lord, has come before this court.
Yes. Yes.
If at all any improvement or, my lord, the modification or any additional has to be, my lord, expenditure has to be incurred, my lord, over the drain. It is only the business of the municipality, not belonging to any other person, my lord, is my respectful submission.
Yes. What is the stand of defendant number 1, 2, and 3?
My lord, 1, say, my lord, they are not concerned with it, my lord, they have filed a written statement. D3 has filed a written statement saying that they are not concerned with the project.
What about 1 and 2?
They have not filed any written statement, my lord.
Yes.
Nor they have filed any objection to the IA.
Yes.
It is only the third defendant and, my lord, the fourth defendant filed objection, my lord. On that basis, my lord, both the courts have considered, my lord, the request for grant of injunction, my lord.
It was contested only by the fourth defendant.
Yes, my lords.
Yes.
The municipality has not joined, my lord, with the fourth defendant. They only gave those 2 letters, my lord, to the court.
Yes.
One by the communication indicating the president's order, and the other letter, my lord, by the commissioner himself allowing them to continue with the construction. These are the only 2 letters, my lord, by the corporation.
Yes.
Municipality.
Yes.
May I request your lordship kindly see, my lord, the finding recorded by the trial court, my lord.
Yes, para number.
Yes, my lord. Page 78, my lords.
Yes.
The learned trial judge, my lord, refers to the pleadings. And page 17, paragraph 17, my lord, at page 80.
Yes.
In the middle of the paragraph, my lord, at page 80, my lord, internal page 9. The photo produced by the plaintiff under a memo dated so and so shows the existence of the road over the Rajkalway, even when it was open drain, to approach the plaintiff's property. In such a circumstance, this court is of the opinion that it is just necessary to protect the subject matter of the suit till the disposal of the suit. Then your lordship will kindly see, my lord, the order passed by the appellate court, my lord. It starts, my lord, from page 94, my lord. The relevant paragraphs, my lord, I would like to place on record, my lord, for consideration of this court, my lord, paragraph 8, my lord. The relevant portion, my lord, I would like to draw the attention of the court, my lord, is 126, my lord, internal page 33.
Yes.
The drainage water is flowing under the same, and nearby area there is a fish market. Under such circumstances, how a swimming pool, kids park, playground, and a rest place for senior citizens can be made over such gutter area? It itself shows that the project is neither benefit the public nor it will helpful to the healthy atmosphere in that area. My lord, this is one of the important consideration, my lord, which has weighed in the mind of the learned judge, my lord, of the court. Further,
What is this letter
nothing is
dated 19/9/2020?
my lord, those are the two letters, my lord, that just now your lordships have seen it. Signed by the commissioner, both the letters signed by the commissioner.
Yes, stop, madam.
Lord, this is the answer, my lord, the trial court gives, my lord. I find there is nothing wrong in, my lord, the finding recorded by the court. Further, nothing is placed on record by the appellant to show about the approval of the project by the competent authority. As such, the same is illegal, unwarranted. It further argued that CMC authority, Gadag, have issued an endorsement stating that no approval has been issued to the defendant number 4, and the letter was issued on 19/9/2020. The defendant number to the defendant number 4 to stop the project work. In spite of that, the defendant is in a hurry to proceed with the project work. Considering all this aspect, the material placed by the parties, the learned trial judge has come to a right conclusion and rightly allowed the application filed by the source.
ಇಲ್ಲಿವರೆಗೂ shows that he is giving certain entry points to suggest that the public
Yes.
With this concurrent finding, my lord, of the courts, the petitioner is not in a position to demonstrate before this honorable court the error committed, my lord, by the both the courts below, which calls for interference at the hands of this honorable court.
Yes.
My respectful submission is, my lord, the courts below have weighed the material on record, prima facie satisfied that the construction of a play area over a sewerage, my lord, is without authority of law. My lord, it is only at the stage of trial, my lord, the evidence will come forward to demonstrate, my lord, the entire act of the fourth defendant, my lord, and putting up the construction over a the sewage line
124
is without authority of law.
Yes.
ಅವ್ರ ಪರವಾಗಿ ಏನು ಹೇಳಾರ
Anything else?
My lord, apart from that, my lord, I brought to my lord's notice, my lord, it is not pleaded, my lord, nor it is, but now we have stated in our objection statement, it's only noticed now. The Karnataka Parks and Playfield Open Space Preservation and Regulation Act 1985.
Karnataka Parks and Playfields. Karnataka Parks and Play. Yes.
Yes, my lord.
Section.
My lord, this is an act, my lord, which regulates, my lord, the parks, playfield, and open space, my lord, in any municipality, corporation, whatever the nature of the body that is required to maintain. Your Lordship will kindly see, my lord, I would like to draw only 2 or 3 sections, my lord, from this. My lord, kindly see, my lord, definition clause, chief controlling authority. As far as corporation is concerned, my lord, they are different. As far as municipality is concerned, my lord, the commissioner means a divisional commissioner of a revenue division. As far as Gadag is concerned, my lord, the concerned person, my lord, to regulate the park, my lord, is a divisional commissioner. The executive authority, my lord, of course, my lord, will be the corporation.
Yes.
My lord, section 3, 4, my lord, they are all deal with the, my lord, the notified, the parks and playfield, my lord. Whenever, my lord, a private layout or my lord, layout formed by the authorities concerned, they are required to provide these 3 aspects. The park, playfield and open space, that is called lung space. Now, if they want to, my lord, apart from notified park, if there is a proposal to include some more parks, my lord, in the existing local area, section 5 deals with that, my lord. The government, may I read, my lord?
Yes.
Section 5, my lord. The government may.
Yes.
I'm sorry. Government may at any time, either suo moto or at the instance of the local authority concerned, or of any person interested, to include a new land in the list. Before including such new land, the government shall publish in the prescribed manner a draft notification proposing such inclusion, together with a notice specifying a date on or after which such draft will be taken into consideration, and shall consider any objection or suggestion which may be received in respect of such draft from such local authority concerned or the person interested before the date so specified.
Now, according to you, what is this, park, open space or playfield?
Lord, now they want to make it a Lord, play area, my lord. Play field.
Playfield.
Play field.
So you will rely on 2H.
2H.
Playfield means a piece of land adopted for play, game or sport used by schools or colleges. What is the purpose of preparation of this list? Approval by the government?
Lord, it is to maintain these park, playfield and open space, my lord. They will have to regulate, my lord, the maintenance of these parks and playfield.
So basically, once a particular
It is notified park or playfield, there is
open
a total
space
prohibition.
park or playfield is notified, then the act will apply to that.
Yes.
If it is not notified, it won't apply to it.
It won't apply.
So
My
according
respondent
to
submission is, if you want to include some more property as a playfield, they are required to, my lord, act in accordance with Rule 5, Section 5. In the absence of Section 5 action, my lord, by the authorities, there cannot be any park and playfield, my lord, is my respondent submission.
So if any particular land is not notified under this act,
Yes.
it is not a park, playfield or open space.
Yes.
So anything which is used as a park now without being notified,
Lord,
will have to be closed.
I will get an opportunity, my lord, if any authority wants to make a park or playfield in front of my house, I can object for it.
Is there, where is that provision?
Lord, that is what, my lord, has been stated, Section 5, subclause 2. They will have to notify it first, call for objections, and thereafter include it.
So where is that is if they want to include it in the list.
No, straight away they want to do it. Now
But
they want to have a play field without, my lord, including it as a play field.
this act will
My
apply.
respectful submission is, my lord, if they have adopted this procedure, I would have had an opportunity of objecting it. Now I have no opportunity of objecting it now, because straight away they want to make a play field.
Has it been included in any list, Mr. Chandrasekhar, for this act to be applicable?
My respectful submission is, it is not a park as on this day. It is not a notified park or a play field as on this day. If any authority wants to make any place as a park or play field, they will have to notify.
Otherwise, it can't be a park.
Yes. If they
Without
had
a
notified,
notification under the
they
Act of
cannot
19, without the notification under the Act of 1985, there cannot be a park, open space or play field in the state of Karnataka, according to you.
Yes, my lord.
Many of these arguments are very, very high. You are placing it, Mr. Chandrasekhar. It becomes a little difficult.
My lord, this is how, my lord, it is regulating.
Yes.
All parks, play field in the state are to be regulated in accordance with this act. Lord, I have dealt with in 2-3 matters, my lord. That is the reason, my lord, I
We
am
have
aware of
dealt
it.
with
My
many
lordship
matters
may
as your
find-
past orders. It's only applicable to the notified
Yes.
and not to others. The
Yes.
division bench has also held that it applies only to notified.
Yes.
The act will not apply to non-notified.
Yes.
There are so many parks in Bangalore allu nodi, illu nim Dharwad allu irutte, that 4 road madhyadalli one park irutte, but that is not notified. Because that notification brings with it certain connotations. So
Yes.
only those notified areas, there's a prohibition.
Yes.
You can't say that without notification there cannot be a park. That means you are making it mandatory.
My
You are
lord,
placing it
your
very high.
lordship will may I read once again, my lord, section 5.2, my lord, so that your lordship would appreciate my contention. If there is a new park going to come, I will have an opportunity of objecting it. May I read once again, my lord, for the kind
That you have to read with section 3 and 4.
Yes, my lord.
3 is a list to be prepared, 4 is a list to be approved. And
Yes.
to that list, if something is to be added, 5 will come.
Yes.
That is to be added.
Yeah, that is to be added.
Not that any park has to be only added for it to be in existence.
My lord, to regulate, my lord.
Yes.
Every park by an authority to be regulated, my lord, should come within the purview of this Park and Playfield Act.
Yes.
First, they should include it and thereafter, my lord, regulate it. They cannot put it first and thereafter, my lord, put it in the list. The right given to a citizen, my lord, to object for any park, open field coming, my lord, in the area. They may have several reasons, my lord, for objecting, my lord, for a park. Before including such new land, the government shall publish in the prescribed manner a draft notification proposing such inclusion together with a notice specifying the date and for which such draft will be taken into consideration, and shall consider any object or suggestion which may be received in respect of such draft from the local authority concerned or any person interested before the date so specified. Therefore, my lord, if they had notified this, that they are going to have a play field over the sewerage line, I would have had an opportunity of objecting and bringing to the notice of the government, this is not a right place for a park. You can go to some other place. It is not hygienic. It is not safe. It is not proper. It is not in the interest of public to have a park, to have a play field over a sewerage line.
Yes.
Lord, if this is the mandate, my lord, under this enactment, putting straight away park, my lord, over a sewerage line, my respectful submission is, my lord, it is without authority of law. My lord, this is not been taken ground, my lord, in the plaint. It is only at this stage, my lord, we have taken up this ground, my lord. I must be very frank with your lordship, my lord. This is not the ground which has taken, my lord, in the pleadings before the trial court.
Yes.
This is one of the aspects, my lord, my lords will consider, my lord. the impact of straight away, my lord, going for putting up a play field, my lord, in a area which is not notified? What is the effect of such steps being taken by, my lord, the government?
Yes.
Another aspect your lordship will kindly see, my lord. The irrigation department coming over with this project, my lord, they must answer your lordship, my lord, what prompted them, what made them to go for this, which is beyond their purpose of establishment.
That
And
they
they may
answered
be-
yesterday. The Additional Advocate General addressed his arguments yesterday on that.
Well, that's the, my lord, that requires to be considered whether it is within the object for which, my lord, the department is established.
Yes.
Construction of a play field, my lord, over a sewerage line, my lord, definitely, my lord, it cannot be the object of a irrigation department. Irrigation department may take out, my lord, the construction of a garden play field within the catchment area, or, my lord, the just like a Brundavan garden, or, my lord, some other place where the water is made use of, definitely not on a sewerage line. And the lower appellate court, my lord, has rightly, my lord, how can a play field come over a sewerage line which is not hygienic, my lord? It is perfectly, my lord, justified by the learned judge, my lord, noting this and confirming the order of the trial court. I do not find any reason, my lord, for the petitioner to knock the doors of this honorable court, my lord, set it not. The well-reasoned order, my lord, of the trial court, my lord, is my responsible submission.
Yes. Yes, Ms. Desai. Please. You are a party before the court.
Second defendant.
You did not file your written statement.
Written statement is filed after the injunction order was passed. It is filed. Andre, adu first immediately agilla. It is filed in the month of September 2022. It is filed, my lord. That is not in dispute now. But when the injunction order was passed, it was not filed.
Was that taken into consideration by the first appellate court?
Avagittu.
First appellate court.
Avaga, the written statement was filed before the trial court. My lord, may I pass on a copy, my lord, if it is required?
Yes. Did you bring it to the notice, your stand to the notice of the first appellate court?
First appellate court, the arguments were addressed, my lord, but my lord, may I state the facts, my lord, in very simple terms? My lord, this drainage, my lord, was a Raja Kaluve. My lord, it is a very big drainage, my lord, in this city of Gadag. It was uncovered. My lord, this process of covering with concrete slabs started, my lord, quite long back, but it was completed, my lord, only in 2017 by the municipality. 2017. Thereafter, my lord, the residents in front of that Kaluve, they started encroaching that concrete slab, started using it for all other purposes other than what it was meant for. My lord, there were some small shops which were coming up unauthorized, parking, go down, my lord, they started storing material there. So to, my lord, and to clean up the city also, some funds were, my lord, were coming from the Niravari Nigam. It is from the government. And the elected representative, my lord, said that this has to be used for this Raja Kaluve to be beautified. My lord, if they have used any other terms, my lord, it is all false. They bring in some play equipment which are meant for children and for some adults also, my lord, which this is called some exercise equipment, my lord, which are fit in all the parks. Only 4 bolts, my lord, are fit into the equipment to the concrete slab. My lord, it is a concrete slab. There can be no garden. Nothing will grow on it. And it is not it is, my lord, it is just about 4 meters wide. It cannot be a field. It is just one narrow passage of, it's not a passage, my lord, it is a narrow 4 meter wide concrete slab. On that, my lord, there can be no growth. This, my lord, now the earlier what happened was the Karnataka Niravari Nigam, my lord, my learned friend has.
Not a park where trees can be grown.
Yes. So no plants, no trees. Only, my lord, few temporary structures, the play equipments which are fit by 4 bolts and screws. They can be removed anytime, my lord, if it is required to be done so. Now it is only to prevent, my lord, any other use of this Raja Kaluwe. Otherwise, my lord, what happens is people start using it, then now they have already claimed easements. Easement in the sense, right of parking. It is not for passage. My lord, passage, 10 passages are maintained, not just one, my lord, for which the first plaintiff has claimed a right. That also, my lord, in the order which my learned friend has relied upon, it is mentioned that it shall be surrendered to the municipality without any equities. So these pathways are not blocked. My lord, pathways are from from north to south. This is from east to west. The concrete slab.
Pathways which were they constructed by the
ones, my lord,
number 1 permission.
One such was for by the first plaintiff. And yes, my lord, under 2011. But there is, my lord, under the Municipalities Act, such permissions can be given, but it has to be maintained by the municipality. My lord, earlier the Raja Kaluwe was open, so people wanted to cross from north to south. They, my lord, requested for, they were using some temporary plywoods or steel structures. Instead of that, my lord, 1 or 2 of them offered to construct a concrete pathway. My lord, that is.
This is a Raja Kaluwe in terms of the stormwater drain or a sewage drain?
Sewage drain.
Sewage. So it's not a Raja Kaluwe per se.
My lord, in the documents, my lord, which my learned additional government advocate has filed, in that only, my lord, may I point out? Your lordships may kindly come to, my lord, document number 3, page number 3.
Document number?
3, page number 3, my lord.
Page
3.
3.
Lord, this is an order by the Niravari Nigam 15/7/2021. Your lordships may kindly come to the second paragraph. ಮುಂದುವರೆದು ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಪತ್ರದಲ್ಲಿ ಮಾನ ಶಾಸಕರು ಗದಗ್ ವಿಧಾನಸಭಾ ಕ್ಷೇತ್ರ ಇವರು 21-22ನೇ TSP ಯೋಜನೆ ಅಡಿ ಹಂಚಿಕೆ ಮಾಡಿರುವ ಅನುದಾನದಲ್ಲಿ ಗದಗಿನ ಜವಳಿಯಲ್ಲಿ ವಾರ್ಡ್ ನಂಬರ್ 17 ಮತ್ತು 18 ನಲ್ಲಿರುವ ರಾಜ ಕಾಲುವೆ ಮೇಲೆ ಹಾಗೂ ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ SPC ಯೋಜನೆಯ ಅನುದಾನದಿಂದ ಸಮುದಾಯ ಕಟ್ಟಡ, ಗೌರವ ಘಟಕ ಕಟ್ಟಡ, ಮಕ್ಕಳಿಗೆ ಕ್ರೀಡಾ ಸೌಲಭ್ಯ ಹಾಗೂ ಇತರೆ ಉದ್ಯಾನವನ ನಿರ್ಮಾಣ ಕಾಮಗಾರಿಯನ್ನು ಸುಮಾರು 1 ಕೋಟಿ ವೆಚ್ಚದಲ್ಲಿ ತುರ್ತಾಗಿ ಆಗಬೇಕಾಗಿದ್ದರಿಂದ ನಿರ್ಮಿತಿ ಕೇಂದ್ರದವರಿಗೆ ಈ ಕೆಲಸಗಳನ್ನು ವಹಿಸಿ ಬೇಗ ಕೆಲಸಗಳನ್ನು ಪೂರ್ಣಗೊಳಿಸಲು ಕ್ರಮ ವಹಿಸುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. Then your lordships may skip the next paragraph and go to the first paragraph on page 4, my lord. ಮೇಲೆ ವಿವರಿಸಿದಂತೆ SPP ಯೋಜನೆಯಡಿ 1 ಕೋಟಿ ಯೋಜನೆ ಮೊತ್ತದಲ್ಲಿ ಗದಗಿರಿ ವಾರ್ಡ್ ನಂಬರ್ 17 and 18 ನಲ್ಲಿರುವ ರಾಜಕಾಲುವೆ ಮೇಲೆ ಹಾಗೂ document, my lord, is on page number.
This is by KNNL.
Yes, ma'am.
What have you done?
Then thereafter, my lord, and the KNNL, my lord, prepared an estimation, page number 9.
Submission of Mr. Chandrasekhar is.
Yes, ma'am.
The only authority who could sanction this under section 203 is this CMC. Without the CMC doing anything, it is the KNNL and the petitioner who are doing something.
No, these documents are also there, my lord. I'm coming in the chain of event.
Yes.
This 28/12/2022, my lord, it is again page number 9 by the Karnataka Niravari Nigam. This is after the estimation was approved. After that, my lord, document number, page number 6.
Page number 6.
Page number 6. the Niravari Nigam, my lord, wrote it to the municipality. This is addressed to the municipality, my lord. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ 21-22 ಸಾಲಿನಲ್ಲಿ ವಿಷಯ ಘಟಕ ಮತ್ತು ಗಿರಿಜನ ಉಪಯೋಜನೆ ಅಡಿ ಉಲ್ಲೇಖಿತ ಪತ್ರದ ಅನ್ವಯ ಗದಗ್ ಬೆಟಗೇರಿ ಮಹಾನಗರ ಪಾಲಿಕೆ ವಾರ್ಡ್ ನಂಬರ್ 17 and 18 ಮಧ್ಯದಲ್ಲಿ ಹರಿಯುವ ರಾಜಾ ಕಾಲುವೆ ಮೇಲೆ ಉದ್ಯಾನವನ ನಿರ್ಮಾಣ ಹಾಗೂ ಕ್ರೀಡಾ ಸೌಲಭ್ಯ ಒಳಗೊಂಡು ಕಾಮಗಾರಿಯನ್ನು ನಿರ್ವಹಿಸಲು ಸೂಚಿಸಿದ್ದು, ಕಾಮಗಾರಿಯನ್ನು ನಿರ್ಮಿತಿ ಕೇಂದ್ರ ಗದಗ್ ವತಿಯಿಂದ ಅನುಷ್ಠಾನಗೊಳಿಸುತ್ತಿದ್ದು, ಕಾರಣ ಕಾಮಗಾರಿಯನ್ನು ತುರ್ತಾಗಿ ಕೈಗೆತ್ತಿಕೊಳ್ಳಬೇಕೆಂದರಿಂದ ಕಾಮಗಾರಿ ಯಾವುದೇ ಅಡೆತಡೆ ಇಲ್ಲದೆ ಪ್ರಾರಂಭಿಸಲು ತಮಗೆ ಕಚೇರಿಯಿಂದ ಸಹಕಾರ ನೀಡಬೇಕೆಂದು ಕೋರಲಾಗಿದೆ. My lord, this request was made by the Niravari Nigam. However, my lord, the municipality, when it saw that the Nirviti Kendra, that is the writ petitioner, has come up and trying to execute some work, page number 8, my lord. An objection was raised by the municipality stating this is addressed to the Nirviti Kendra, that is the writ petitioner, not to the Niravari Nigam.
Yes.
This is, my lord, ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಇಲಾಖೆಯಿಂದ ವಾರ್ಡ್ 17-18 ಮಧ್ಯಭಾಗದಲ್ಲಿರುವ ಗೌರಿಶಂಕರ ಲಾಡ್ಜ್ ನಿಂದ ಡಿಸಿ ಮಿಲ್ ರಸ್ತೆವರೆಗೆ ಜವಳದ ದೊಡ್ಡ ಚರಂಡಿ ಮೇಲೆ ಉದ್ಯಾನವನ ನಿರ್ಮಾಣ ಮಾಡುತ್ತಿದ್ದು, ಆದರೆ ತಾವು ನಗರಸಭೆಯಿಂದ ಪೂರ್ವ ಅನುಮತಿ ಪತ್ರ ಪಡೆಯದೆ ಕಾಮಗಾರಿ ಪ್ರಾರಂಭಿಸಿದ್ದು, ಸದರಿ ಕಾಮಗಾರಿ ಸ್ಥಗಿತಗೊಳಿಸಲು ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರು ನಗರಸಭೆ ಇವರಿಗೆ ದೂರವಾಣಿ ಸಂದೇಶ. So this is what is the objection, my lord, which because the Nirmiti Kendra came up. So the Nirmiti Kendra, my lord, the writ petitioner, kindly come back to page number 7, my lord. The writ petitioner wrote a letter to the municipal council. This is, my lord, page number 7, dated 28/9/2022. This is addressed to the commissioner. ಮೇಲ್ಕಂಡ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖಿತ ಸಂಬಂಧಿಸಿದಂತೆ ವಾರ್ಡ್ ನಂಬರ್ 17-18 ಮಧ್ಯ ಬರುವ ಗೌರಿಶಂಕರ ಲಾಡ್ಜ್ ನಿಂದ ಡಿಸಿ ಮಿಲ್ ವರೆಗೆ ದೊಡ್ಡ ಚರಂಡಿ ಮೇಲೆ ಉದ್ಯಾನ ಸೋ ಸಾಗಿಸುತ್ತಿದ್ದು, ಈ ಪತ್ರದಲ್ಲಿ ಸೂಚಿಸಿದಂತೆ ಸ್ಥಗಿತಗೊಳಿಸಲಾಗಿರುತ್ತದೆ. ಮುಂದುವರೆದು ಮಕ್ಕಳ ಕ್ರೀಡಾ ಸೌಲಭ್ಯ, ಉದ್ಯಾನವನ ಹಾಗೂ ಇತರೆ ಆಸನಗಳ ವ್ಯವಸ್ಥೆ ಕಲ್ಪಿಸಲು ಸಾರ್ವಜನಿಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ಸೌಲಭ್ಯ ಕಲ್ಪಿಸಲು ಕಾಮಗಾರಿ ಅವಶ್ಯಕತೆ ಇದ್ದರಿಂದ ಸದರಿ ಕಾಮಗಾರಿಯನ್ನು ದೊಡ್ಡ ಗಟಾರಕ್ಕೆ ಯಾವುದೇ ಧಕ್ಕೆ ಆಗದಂತೆ. This was what was required by the municipality to be ensured that nothing would happen to the drainage and the concrete slabs which are laid over it. ಧಕ್ಕೆ ಆಗದಂತೆ ಹಾಗೂ ಅತಿಕ್ರಮಣ ಆಗದಂತೆ ಕ್ರಮ ವಹಿಸಲಾಗುವುದು. ತಮ್ಮ ಗಮನಕ್ಕೆ ತಂದು ಸದರಿ ಕಾಮಗಾರಿ ಕೈಗೊಳ್ಳಲು ಮಾನ್ಯರು ಅನುಮತಿ ನೀಡಬೇಕೆಂದು ಈ ಪತ್ರದ ಮೂಲಕ ವಿನಂತಿಸಲಾಗಿದೆ. After this, my lord,
were all these documents placed before the trial court and the first appellate court?
My lord, first appellate court munde, my lord, they were placed, but not in along with an application. They were all produced.
And how can we consider all these
no,
things
but
now?
this document, my lord, the next document, the page number 5. This is the permission. Now this is said that the commissioner has overreached. This was placed 7/10. This has come, my lord, after Nirviti Kendra sought our permission, assuring that the drainage and the slabs laid over it will not be disturbed. So this is, my lord, is addressed to the writ petitioner, Nirviti Kendra. The earlier one, rejection or objection, was against the KNLL.
Yes, but why were all these not placed before the trial court and the first appellate court?
My lord, this 7/10/2022
yes
was placed. It is interpreted in such a way that the president had earlier objected. The commissioner has overreached.
Where is that interpretation? This was placed.
Page
Yes,
79.
Where is the interpretation for that?
Page 79. Even
99 ಇದೆ. Where is 7/10? 710 was not placed, it's not been considered.
ಟ್ರಯಲ್ ಕೋರ್ಟ್
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಾ? You cannot rely on documents which are not produced.
This first appellate court.
Page 123,
Page 134.
letter dated 7/10/2022. There is a reference in so far as that.
Para 26.
The issued direction, permission, you should have contended it as. Yes. Where is the appreciation of that letter?
Para page 134. Para 135, it said that all these aspects created some confusions.
Very 99 reference iradu.
Para 26 ಅಲ್ಲಿ
Para first appellate court, page 135.
435.
Lord, in fact, this is the argument addressed by the plaintiffs also even in this writ petition. Even in this writ petition, my lord, the plaintiffs addressed the arguments on this point, saying that the precedent has surpassed something in this. My lord, now, if my lord, this.
So your contention is,
if
but
this is
did
not.
you address arguments at all before the first appellate court?
My lord, it is taken that it is between the plaintiff and the writ petitioner. So the authorities.
That is why Mr. Chandrasekhar is right as
Authorities,
to
Lord.
how can Nirmiti Kendra be defending this when it was the deputy commissioner and the CMC who was required to defend it? A contractor is being made to defend it virtually.
Because, my lord, funds are released to him and he is required to execute the work. Anta, so, Alpa, they have taken it, my lord, in such a way that.
Manenu KNNL ade aitala. Contractor ಕೊಟ್ಬಿಟ್ಟು clause on power to negotiate with the, that is not the way.
My petition.
Your petition only. You have to defend this. You have not defended it.
Lord, we have only made available the documents and tried to, my lord, leave it to him that he will, because
Like
he's.
how you are contending here, you should have told the trial court and the first appellate court that this is my project. I have approved it.
It is
Then
only,
they would have
it is
considered
only
it.
to prevent, my lord. Otherwise, these very plaintiffs will misuse it, my lord, and they will claim equities later.
So you should have said that.
And this argument, my lord, that it no, nothing can be permitted there. Parks andre notify madbeku, all that. If I don't do it, they will use it. For that also, my lord, if for them to use it also, my lord, they require my permission. They cannot, my lord, high-handedly use it for some other purpose.
From what we read of the order, both the trial court and the first appellate court, because it's a contractor appearing, and all of you, the authorities have kept quiet.
There is some laxity, my lord, by the state as well as the municipality. But,
Mr. Chandrasekhar
my lord,
clients
my,
have also taken advantage of it.
my submission is, my lord, since it is some development activity which will lead to beautification of the city.
But how do we in a writ petition after two concurrent findings consider these aspects newly?
My lord, it can be made subject to result of the suit. My lord, we are not blocking their right of way. Only, my lord, we are stopping them from using it for other purposes. For right of way, they have 10 passages, my lord, which in fact now made even sturdier than earlier. Right of way is maintained. They can take their
See, once you place it, they should also be given an opportunity to reply to it. So is it better to remand it to the civil court for a time-bound disposal with all of you placing your
My lord, with these
on record.
observations, my lord, your lordships, whatever deems fit, my lord, in the interest of justice, because this is, my lord, there's nothing personal in this. I am only trying to protect, my lord, the drainage which is covered by a concrete slab. If anything heavy, my lord, my lord, I was told that even goods vehicles were coming and being parked there. My lord, if it gives in, if it caves in, my lord, then it will lead to.
See, right, like Mr. Chandrasekhar rightly said, that argument on the Parks Act was not put across before the trial court, but he said if it can be considered, otherwise it's
Yes,
optional.
yes.
But in your case, you have not argued anything.
No, only
How do
because,
you
my
argue
lord,
all these things before us now?
my lord, that is why past 2 days, my lord, I was sitting quietly. Today, my lord, your lordships asked me yesterday that I have to argue today. So I came prepared with whatever instructions, my lord, I could get from the
So
municipality.
now you'll have to go to Gadag to argue.
If it is to be remanded, my lord, that is also, my lord, it's a very fair.
And the state also has not said, done anything. Deputy Commissioner has kept quiet.
No, yeah,
Supported the cause of the petitioner, my lord, in the argument kindly take.
There is anything in the order, Mr.
para 25,
Is anything in the order?
para 25
17,
of the
my lord, I
first
request
appellate
my lord
court
to
order.
kindly-
Page 133.
ಏನಿದೆ?
Page 124, my lord.
133.
124. 124, internal page 31. Learned DGP appeared for the respondent number 1 as
Ashta-
submitted that.
Is for beautification.
All the documents have produced, madam. My instructions are the documents have produced before the.
ಇಲ್ಲಿ
first
ಆರ್ಗ್ಯುಮೆಂಟ್
appellate
ಮಾಡಿದ್ದು ಅಲ್ಲಿ ಮಾಡಿಲ್ಲಲ್ಲಪ್ಪ.
court. First appellate court, we have produced the documents.
ಅಲ್ಲ para 25 ದಲ್ಲಿ ಅದನ್ನ ಅಬ್ಸರ್ವ್ ಮಾಡಿ that is required to be considered the full fledged trial ಅಂತ. Para 25 lots of people to see.
And entire
Yes.
object,
That is why the trial court has said, first appellate court has said it will be considered during trial.
So, all those things, because they are getting confused by themselves, they say that it is required to be considered at the time of trial.
My lord, at the cost of repetition, my lord, this is only for maintaining the drainage. Passage, my lord, 10 passages are maintained, that is admitted by the plaintiffs themselves. ಅವ್ರಿಗೆ ingress egress ಏನು disturbance ಇಲ್ಲ. Subject to result of the suit, my lord, your lordships may, if they look at their prayers, my lord, you kindly look at their prayers.
they wanted this area for the parking. The
What is the prayer?
Entire object is, my lord,
Their prayer,
Prayer page number 19, 18, 19. I'm sorry, my lord, page number
44.
40, 42, 43.
Easementary right.
Easementary right. And your lordships on day one, my lord, have pointed out that if it is from 2019, it cannot be an easementary right. It is neither a necessity nor there is a prescription, my lord. And right of way, 10 such roads are maintained. Now, my lord, they are even made into solid structures.
Yes, anything else?
And the memo which the plaintiffs have now filed, one document, my lord, permission to construct the bridge ಅಂತ ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು, ಅದರಲ್ಲಿ ಸದರಿ RCC ಸ್ಲ್ಯಾಬ್ ಅನ್ನು ಹಾಕಿದ ನಂತರ ನಗರಸಭೆಗೆ ಯಾವುದೇ ಪರಿಹಾರ ಕೇಳದೆ ನಗರಸಭೆಗೆ ಹಸ್ತಾಂತರಿಸಬೇಕು. ದಟ್ ಇಸ್ ಒನ್ ಕಂಡೀಷನ್. ಸದರಿ RCC ಸ್ಲ್ಯಾಬಿನ ಮೇಲೆ ತಮ್ಮ ಮಾಲ್ಕಿ ಹಕ್ಕು ಕೇಳತಕ್ಕದ್ದಲ್ಲ. On these two conditions, right of that passage was created. When earlier, my lord, they were using only plywood and steel boards.
Who had constructed? You had constructed it?
My lord, permission was given to the first plaintiff. Similarly, my lord, some other citizens also had constructed. Now those constructions were removed and solid constructions are put up. 10 such roads, my lord, are reflected. Avattu video dallu tavu nodirbodu.
kindly take the document which you have produced.
Or mugsli. Let him finish.
No, that is it, my lord. My only submission is this, my lord, that it may not be used by the plaintiffs for any other purpose. And if it is maintained, my lord, as a children's play area where only temporary structures, play equipment is put up, and some benches, my lord, are put up for senior citizens. My lord, it will lead to protection as well as beautification of the city. And my lord, it may be made subject to the result of the suit. And in case the plaintiffs succeed in their right of easements, my lord, which they have pleaded, without any equities, my lord, the writ petitioner would be directed to remove those screws and take back the
Clearly
play
writ
equipment.
petition. What about you?
But, my lord, so far as municipality is concerned, it is not going to allow any other activity. If it can be used, my lord, by the temporary structure, children can play, senior citizens can sit there, and that's it. But no, if it is going to be used as a godown or a parking area, goods vehicle parked on Raja Kaluwe, and if it caves in, my lord, again the municipality will be held responsible for all such activities.
It is not a thoroughfare. It is not built like a road.
It is not a road. It is only a concrete slab which is laid over Raja Kaluwe. Roads, my lord, are on either side are intact, and over the Raja Kaluwe there are 10 passages.
Yes.
Only two submissions. Till 2019, it is open drainage. After the construction of the drainage in the fund of the state under the Nagrottana scheme 2, it has been done by the exchequer of the state. And there it is admitted case that there the plaintiffs are using this for the purpose of parking of the vehicle. And that also the experience of the municipalities and the other officers, they are unauthorizedly using this for the storage of the cement bags and other materials on this drainage. Therefore, my lord, this plan was being done. It is a temporary in nature, my lord. It is a temporary in nature. Only the first purpose is to prevent the misuse of this drainage. Second purpose is by putting these equipments that the misuse can be prevented. Therefore, the valid purpose, it has been done. No other intention. So the drainage and the passage is 10 passage, which was either constructed by the plaintiff before 2011 was maintained till today. Their approach has not been blocked. So whatever there it was been maintained. Only in these area which has not been used, which is to prevent the illegal use of that, this plan was been done. And
Do you also not address any arguments properly before the trial court?
In paragraph 70, it was
Where is your
but
written
not been
statement? Where is the
fully,
pleadings
not
for
fully. I request Malad to kindly see, take the paragraph 17, Malad, page 124. It is please, Malad. 124 paragraph, page internal page 31, Malad. Learned DGP appeared for the respondent number 1, as submitted that till 2021 Raj Kaluwe it was open drain. Thereafter, in the interest for the convenience of general public, concrete bed was put over the open drain, and now it is being used by the general public for the parking and other purpose. Kindly mark this. The present project work is beautification said area, and it is a temporary arrangement for the benefit of the use and public. Even if it will be removed easily, it is a further argument that already used amount has been invested for the project. Now it is stopped due to the temporary injunction. Hence, the prayer court allow the appeal set aside the order so and so. So all the materials have been placed before the court, and it has been contended, Malad. The only two purpose, Malad, to prevent the unauthorized use of this drain, Malad. Because behind that, Malad, the plaintiffs are running the shops, commercial shops. Their materials they are placing before this bed, Malad. Till 2019, no objection, no easement right was violated. And if the lorries have been parked, Malad, every lorries carrying the goods to the shops are parked there, Malad. So entire object of the plaintiff is to prevent that no beautification should be done, because that should be made exclusively used for them, which they have not used till 2019. Only after 2019, when we facilitated that, they started using that drainage for other purpose. And we cannot prevent them also. Every day we cannot put a police on that and prevent those persons. It is very difficult. So that is why with a double purpose, it has been done. No other intention. And it's already work has been done. So neither in this side nor this side. The photos have indicated that already some instruments have been put also. But if ultimately, if this court finds that trial court has no rights, it can be removed and we can use it somewhere else.
Yes, Mr. Patel.
Counsel referred to that act, Karnataka Parks and Playgrounds Acts.
Michael ಮಾತಾಡ್ಬೇಕು ಅವ್ರು ಕೇಳಿಸ್ಬೇಕು.
The statement of objections and reasons please be seen of that act, my lord, which reads, in view of the increasing demand for residential and commercial sites in the urban areas, a number of parks, play fields, and open spaces are being converted into sites and for other such uses. In order to provide necessary space for recreation to the residents of each locality, it is necessary to preserve parks, play fields, and open spaces and put an end to the practice of converting such lands into other uses. For this purpose, this act is prepared. This is not applicable to this present case.
Section is only if it is in the list. That's what we are telling, Mr.
Yes. And then, if your lordship is pleased to see, the main prayer of the suit itself is claiming easement. Whether easement.
Argument to ಮಾಡಿ. Reply only remain. Anything else?
Yes.
Heard. Shri is S.M. Chandrasekhar, learned senior counsel, appearing for respondents. For respondent. 1 to 8, 12 to 42. Shri Harsh Desai, learned counsel, appearing for respondent number 10 CMC. Shri Gangadhar, learned additional advocate general for respondent number 9. Mr. Dayanand Bandi. ಇವ್ರು ಯಾರಿಗೆ
ವಾಟರ್ ಬೋರ್ಡ್
ಅವ್ರು ನಂದೇನಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ರಲ್ಲ. Shri Dayanand M. Bandi for respondent number 11. And Shri K.L. Patil, learned counsel for the petitioner in reply. Reserved.
Not 7.
Yes, President. Sir, the petitioner could not attend the exam during 2019 and 20 due to COVID-19 pandemic, suffering from husband and mother-in-law. Then after petitioner attended the next ensuing examination, September 2021.
Yes.
The petitioner has requested to respondent university to allow the internal assessment marks at annexure G, J, K. The request of the petitioner is rejected by the respondent annexure L. The government of Karnataka has issued modalities to all colleges and as well as universities. Annexure B.
You appear for the college also.
Please, affiliated college.
Affiliated college. So you are deciding in your own.
My lords, in this
litigation, is college did not conduct the internal assessment, did not send it to the registrar. Registrar says we have not received the internal assessment, therefore we are failing you.
No, my lords. The register has, my lords, statement of objection annexure R1 may be seen, my lords, wherein the petitioner herein has not appeared for the examination, my lords. R1 is the attendance sheet, my lords. My lords, the register number, my lords, 18123, third serial number, my lords. It is for of the petitioners, my lords. 18V10106. It is of the petitioners herein, my lords. He has not appeared for the exam, my lords. Internal assessment, internal IM exams, my lords, which was conducted by the college.
What do you have to show that the internal assessment was done and you appeared and or it was not done?
My lords.
My lord, annexure E, page number 27, due to COVID-19 of husband and mother-in-law, she couldn't get that examination.
What was the date of this examination?
September 2000. September 2000. 20, page 27, annexure E.
October 2020.
September 2020, all paper have been absented due to COVID-19.
Annexure?
COVID-19 ಇರುವುದರಿಂದ ಎಲ್ಲ ಪೇಪರ್ ಹಾಜರಾಗಲಿಲ್ಲ ಸರ್ ಅವರು. ಸೆಪ್ಟೆಂಬರ್
ನೀವು ಒಬ್ಬರೇ ಹಾಜರಿಲ್ಲದೆ ಬೇರೆ ಎಲ್ಲರೂ ಹಾಜರಿದ್ರೆ
ಇಲ್ಲ ಬೇರೆಯವ್ರ ಬಗ್ಗೆ ನಾವು ತಕರಾರಿಲ್ಲ.
ಅವ್ರು ಹಾಜರಿದ್ದು ನೀವು ಒಬ್ಬರೇ ಬರ್ಲಿಲ್ಲ
ಇಲ್ಲ ಕೋವಿಡ್-19 ಸರ್.
ಕೋವಿಡ್-19 ನಿಮ್ಮ ಒಬ್ಬರಿಗೆನಾ?
ಕೋವಿಡ್-19
ಇಲ್ವಾ?
ಕೋವಿಡ್ ಅವ್ರ ಹಸ್ಬೆಂಡು ಮತ್ತು ಅವರು ಮದರ್ ಇಲ್ಲ ಕೋವಿಡ್ ಎಂದು ಬಳಲ್ತಿದ್ದಕ್ಕ ಇಡೀ ಎಂಟೈರ್ ಹೋಮ್ ಕ್ವಾರಂಟೈನ್ ಇತ್ತು ಸರ್ ಅವ್ರ ಮನೇನ.
ಅವ್ರಿಗೆ ಕೋವಿಡ್ ಆಗಿತ್ತ?
ಅವ್ರಿಗಲ್ಲ, ಅವ್ರ ಹಸ್ಬೆಂಡ್ಗ ಮತ್ತು ಅವರು ಮದರ್ ಇಲ್ಲಾಗ ಕೋವಿಡ್ ಆಗಿದ್ದಕ್ಕೆ ಅವ್ರು ಎಕ್ಸಾಮ್ ಕೊಡ್ಲಿಲ್ಲ.
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ?
ಅಲ್ಲಿ ಇದು ಅನೆಕ್ಸರ್ ಡಿ CND. Annexure C and D. Discharge summary of husband and mother-in-law.
COVID-19 illness, SARI and DM. Yes, this was in September. ಇಬ್ಬರಿಗೂ ಒಟ್ಟಿಗೆ ಆಗಿದೆ.
Then ಅವರು ಸೆಪ್ಟೆಂಬರ್ 2021 ಎಕ್ಸಾಮಿನೇಷನ್ ಕೂತ್ರು ಸರ್. ಎಲ್ಲ ಪೇಪರ್ ಅಟೆಂಡ್ ಆದ್ರು. ಫಸ್ಟ್ ಪೇಪರ್ ಕ್ರಿಯೇಟಿವ್ ಪೇಂಟಿಂಗ್ ದೊಳಗೆ ಥಿಯರಿ ಪೇಪರ್ಗೆ ಮಾರ್ಕ್ಸ್ ಕೊಟ್ಟರು. IMRಸ್ಗೆ 0 ಇಟ್ಟರು. IMRs 160 ಫಸ್ಟ್ ಪೇಪರ್ ಕ್ರಿಯೇಟಿಂಗ್ ಪೇಂಟಿಂಗ್. Then sculpture second paper 80 marks. This practical oriented course, my lord. 240 marks ದಿಂದ ವಂಚಿತ ಆಗಿದ್ದಾರೆ ಸ್ಟೂಡೆಂಟ್. ಮತ್ತು ಗೌರ್ಮೆಂಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಮಾಡೆಲಿಟೀಸ್ ಇಶ್ಯೂ ಮಾಡೈತೆ. Annexure B, page number 20, for first semester examination ABC, page number 20, for final semester year UG and PG examination 2019 and 20, page number 20. C, in case of student of terminal final year is unable to appear in the examination conducted by the university for whatsoever the reasons, she may be given opportunity to appear in the next examination for such a courses papers which may be conducted by the university and as and when feasible, so that the student is not put any inconvenience or disadvantages. Statement of objection, page number 24, sir. Statement of objection filed by the respondent, page number 24, sir.
ನಿಮ್ಮ ಫೈನಲ್ ಇಯರ್ 1920 ನಾ? You're in the final year. 1920 ಯಾವ ಇಯರ್ ಅಲ್ಲಿ ಇದ್ರಿ ಪೆಟಿಷನರ್?
Final year.
Final year ಇದ್ರಿ. Final year.
Final
Fourth semester.
They should make this applicable.
My lords, petitioner here in the COVID time, he has not appeared, my lords. After that, he appeared for the next continuity, next year, my lords, 21, he has given the examination only for the theory, my lords. He had not requested the university or not the principal, my lords, for consideration of his writing examination for the.
Now permit him to take practical.
My lords, there is no provision, my lords. May I seek, my lords.
My lord, page statement of objection, page number 24.
Final year ಆಯ್ತಪ್ಪ, ಒಂದು ಪ್ರಾಕ್ಟಿಕಲ್ ಒಂದು ಉಳಿದಿದೆ.
Page number 22, my lords.
Internal assessment was.
ಏನ್ ಮಾಡಿದೆಲ್ಲ ನೀವು ಹಿಂಗೆ ಲಾಸ್ಟ್ 2 years ಇಂದ ಲಿಟಿಗೇಷನ್ ಎಲ್ಲ ಕಳೀತಾ ಇದ್ದೀರಾ. ಇಷ್ಟೊಳಗೆ ಮುಗಿದು the person would have got employed or been earning something. You are making a educated person unemployed because of this.
My lord, my lords, one submission, my lords. In her representation also, my lord, she has requested to give the marks, my lord. She never ever.
We will direct it now.
My lords, the
petitioner is before this court seeking for the following reliefs. The petitioner, as a student of third respondent college,
fourth respondent,
third respondent college, having taken up a course in Masters of Visual Art, the third respondent is affiliated to the second respondent, Karnataka University. The petitioner, being in the final year in the year 2019-20, did not take up the theory or practical examination and had subsequently taken up the theory examination in the year 2021, but not the practical examination.
Internal assessment marks, IA marks, internal assessment marks.
Practical ಅಲ್ಲ ಅದು.
ಇಲ್ಲ ಸರ್, practical ಅನ್ನಂಗಿಲ್ಲ ಸರ್. Practical ಅನ್ನಂಗಿಲ್ಲ.
Only IA, my lords.
Only IA marks.
He has appeared for
Appeared
practical.
for the theory examination. Though the petitioner has passed in the theory examination, the internal assessment marks were not issued to the petitioner on the ground that the petitioner had not attended the classes and or the internal assessment, or when the internal assessment was conducted. The petitioner had therefore submitted a representation for allotment of internal assessment mark, taking into consideration that the absence of the petitioner was on account of COVID-19 pandemic, more particularly due to her husband and mother-in-law, both having been afflicted with COVID-19 and undergone treatment in the month of September 2020. And in that regard, she had produced the discharge summary of the mother-in-law and the husband. This request made by the petitioner on 23/2024 came to be rejected by the respondent number 2 on
21/3/2024.
21/3/2024 on the ground that there is no provision for grant of internal assessment marks or seeking for improvement thereof. It is in that background that the petitioner is before this court, seeking for the aforesaid relief. The submission of learned counsel for the petitioner by relying upon the government order dated 10/7/2020 is that if a final year student is unable to appear for the examination, the university was required to give an opportunity to appear in the next examination or for such course of papers which may be conducted by the university as and when feasible, so that the student is not put to any inconvenience or disadvantage. If at all, the respondent could have called upon the petitioner to be present for an internal assessment, which the petitioner would have participated in, and as such the assessment marks could have been granted, could have been awarded, instead of rejecting the request of the petitioner in toto. His submission is that the examination having been held in September-October 2020, the mother-in-law and the husband of the petitioner having been afflicted with COVID-19, having undergone treatment as inpatients, the discharge summary having been produced ought to have been taken into consideration by the respondent university. Learned counsel for Sri Ramchandra Malli, learned counsel for respondent 1 to 3, seeks to support the stand of the university by contending that there is no particular provision which would enable the assessment of the petitioner to award internal assessment marks, and as such the petitioner cannot seek for that, but would have to redo the entire course since the period has also expired.
Please.
Heard so and so various papers.
Time limit, sir. Time limit.
Time limit. Time has expired.
My lords, one submission, my lords. In the government notification, my lords, it is exam conducted by the university. My lords, this IAR.
We'll deal with it. There's a strange case where the university, instead of encouraging students in completing the course, has come in the way of the student completing the course. and that too on the basis of technicalities. The petitioner had taken up the theory examination and has cleared, having achieved high marks in the theory examination. It is only on account of the internal assessment not being completed that the petitioner has been declared failed and has been directed now to take up the entire course once again, since the time period has lapsed, though the age limit has not lapsed. Para. Admittedly, the internal assessment was made in the month of October 2020. There is no dispute about the petitioner being absent for the internal assessment. But the reason provided by the petitioner, as indicated above, is the affliction of COVID-19 of the mother-in-law and the husband being afflicted by COVID-19 and the petitioner being under home quarantine due to the immediate relatives being afflicted with COVID-19. The discharge summary which has been produced indicates that the date of discharge is 18/9/2020. The petitioner, being an immediate family member in contact with the said mother-in-law and husband, is the date in October end date idu practical
Practical date.
So direction ಕೊಟ್ರೆ ಅವ್ರು ಕಂಡಕ್ಟ್ ಮಾಡ್ತಾರೆ.
ಇದು ಯಾವಾಗ R1 ಯಾವತ್ತಾಗಿದ್ದು ಡೇಟ್ ಹಾಕಿಲ್ಲ, ಬರೀ ಅಕ್ಟೋಬರ್ ಅಂತ ಹಾಕಿದ್ದೀರಾ. The practical stroke internal assessment has been conducted in the month of October 2020.
October 20.
Is in close proximity. Date illa. Close date is correct agi helbodu.
October 20.
In close proximity with the discharge of the mother-in-law and husband from their hospitalization. I am of the considered opinion, and a quarantine of 14 days having been directed by the hospital authorities, I am of the considered opinion that the said quarantine would have gone on to the first week of October 2020 as per the records. In such a situation where two of the family members have been afflicted by COVID-19 and there's a quarantine for last nearly 1.5 months, it is rather sad that the university was expecting the student to appear for the internal assessment and for not having attended has imposed a harsh punishment of failing the petitioner and thereafter not even considering the request and representation made. It was expected of the university to be more humane towards its students and consider these reasons which had been given, which ought to have been accepted by any right-minded person in the university. The action on part of the respondent university and its officers leave much to be desired. In that view of the matter, I have the considered opinion that the interest of the student in the circumstances as indicated above have to be peculiarly considered and suitable orders passed to protect the interest of the student. And as such, I pass the following order. Certiorari has issued the endorsement dated so-and-so, dated 21/3/24 at Annexure L, issued by a second respondent is quashed. A mandamus is issued directing the second respondent to conduct the internal assessment of the petitioner on by fixing a date in a week commencing from 3rd March to 7th March.
Yes.
And complete the assessment and submit the internal assessment marks. Respond number 3 to conduct and submit the internal assessment mark to respond number 2 to enable the respond number 2 to issue necessary certificate on the basis of the marks secured. This court hopes and believes that this time at least both the college and the university would act in a human manner. ರಾಮಚಂದ್ರ ಮಲ್ಲಿ ಇದ್ದಿದ್ರೆ ನಿಮ್ಮ ಮೇಲೆ ಕಾಸ್ಟ್ ಆಗಿರೋದು, ನೀವಿಲ್ಲ ಅಂತ ನೀವಿದ್ದೀರಾ ಅಂತ ಕಾಸ್ಟ್ ಆಗ್ತಾ ಇದೆ.
Our documents are produced here, my lords.
That to be human.
Not 8. Surbhi Kulkarni.
Lords, in this matter, on the last occasion, your lordships were pleased to call for records in LAC and the miscellaneous proceedings. Lords, I inquired in the branch, my lords, entire records have not been received.
You've seen this and.
I have seen that, my lords. That is in miscellaneous. LAC records have not been received. It's
Only the records in miscellaneous number 21 of 92 have been received. The records
LAC 153 of 1982.
in LAC 153 of 1982 are yet to be received. In that view of the matter, the above petition is released from parted. Release the matter on receipt of the records in LAC 153 of 1982.
109.
Please.
Shivraj Bellaki.
Lord, on the last occasion, the Lordship has directed me to place the 28. Please. Nigama on it.
In the Nigama.
From the date of establishment itself. Communication is sent to me and it is placed on record. And I have placed also applications.
Relevant application and the entries.
Howದು.
Page number ಮಾಡಿದೀರಾ?
ಅಲ್ಲ, prepared a list by case wise and WP numbers.
Inward 29/2010.
My lord, serial number 2, no inward. It has not, no application is no received, not received.
Date ಇದೆ but number ಇಲ್ಲ.
ಇಲ್ಲ, ಅದು ಇನ್ವರ್ಡ್ ಎಂಟ್ರಿನೇ ಇಲ್ಲ. ಅದು ಅಪ್ಲಿಕೇಶನ್ ರಿಸೀವ್ ಮಾಡಿದ್ದೀವಿ ಬಟ್ ಇನ್ವರ್ಡ್ ನಲ್ಲಿ ಎಂಟ್ರಿ ಇಲ್ಲ. ಸೀರಿಯಲ್ ನಂಬರ್ 6, ಸೀರಿಯಲ್ ನಂಬರ್ 7 ಅಂಡ್ ಸೀರಿಯಲ್ ನಂಬರ್ 9 and 11. ಇನ್ವರ್ಡ್ದಲ್ಲಿ ಎಂಟ್ರಿ ಇಲ್ಲ. ಅಪ್ಲಿಕೇಶನ್ಸ್ ಹ್ಯಾವ್ ಬಿನ್ ರಿಸೀವ್ಡ್.
ಯಾವಾಗ ರಿಸೀವ್ಡ್ ಆಯ್ತು ಅಂತ?
Please.
When was it received?
My lord, it was received. Date hakide 6/5/2000. Dates have been mentioned, and I have produced the certified copies of all the applications, and also the register which has been mentioned by the inward register, along with that documents.
This is all relating to KNNL.
Yes, my lord. Insofar as railway is concerned, my lord, I could not secure the records from the Karwar. These entire cases pertains to Niravar Nigam.
Where you stated that the office of
My lord, in the first communication letter which has been sent at page number 2, at the bottom, last 2 lines. ಅರ್ಜಿಗಳನ್ನು ಈ ಕಾರ್ಯಾಲಯದ ದಾಖಲಾದ ಕುರಿತು ನಿಗದಿತ ಸಮಯದಲ್ಲಿ ಮಾಹಿತಿಯನ್ನು ಭರ್ತಿ ಮಾಡಿ ಹಾಗೂ ಈ ಕಚೇರಿಯು ಕರ್ನಾಟಕ ನೀರಾವರಿ ನಿಗಮದ ಅಧೀನೆಯಲ್ಲೇ ಇರುತ್ತದೆ ಎಂದು ಮಾನ್ಯರಲ್ಲಿ ಗೌರವಪೂರ್ವಕ ಸಲ್ಲಿಸಿದೆ.
ಅಧೀನದಲ್ಲಿ ಅಂದ್ರೆ ಅರ್ಥ ಗೊತ್ತಾ ಅವ್ರಿಗೆ?
ಅಲ್ಲ, I have told that since from the date of establishment they are working in their office itself.
ಅಲ್ಲ, ಇದು ಅಧೀನದಲ್ಲಿ ಅಂದ್ರೆ
ಎಲ್ಲ ಅದು.
Yes, Mr. Bellaki, Mr. Ravi.
Yes, my lord. Sir, these out of 15 cases, 5 cases, my lord, there is no acknowledgement of seal, there is no entry register, nothing. It's all, my lord, got up documents. I don't know how
The rest of them are fine, only 5 of them are not okay.
Yes, ma'am. Yes, ma'am.
According to you. No.
Yes, ma'am.
Yes. And what do you say about the SLO sitting in your own office? And they going on to say that they work under you, Adhinadalli.
No, my lord. So we don't have any administrative or supervisory control over them. That's the instruction I have received, my lord. He is belonging to revenue department, and we don't exercise any administrative or supervisory control over him.
ಬಟ್ ಅವ್ರು ಹೇಳ್ತಾರೆ ನೀರಾವರಿ ನಿಗಮ ಅಧೀನದಲ್ಲಿ ಇರುತ್ತದೆ ಎಂದು ಮಾನ್ಯರಲ್ಲಿ ಗೌರವ ಪೂರ್ವಕವಾಗಿ ಸಲ್ಲಿಸಿದೆ. They are saying that work under you. The SLO is saying that.
But my instruction, they don't exercise any administrative or supervisory control over him. He is independently working.
We'll deal with that. Konkan Railway files ಅಲ್ಲಿ
ಅದು ನೋಡು.
My lord, they are on the file of this court. It has come long back.
109.12, 15, 16
And 16.
16.
Have you made
Only
a note of what are the things wrong and how can it be rectified, Mr. Ravi, Mr. Moon?
Yes, my lord, I have prepared a small note, Mr. Chick. It's with Mr. Chiknargun. Suggestion, my lord.
You always say Mr. Chiknargun, who is not here. Do 15/1/2013. Six, 2013. Filed it. Yes, Mr. Onkar. Mr. Chiknargund is not here, Mr. Murthy.
My lord, my
You
colleague,
have no right of audience without your instructing counsel.
Yes,
Yes.
my lords, a note has been prepared.
Michael Matadi,
A note has been prepared, but may I seek some indulgence to give pass?
You want to polish it more.
This has come from the client. I had to vet it once, so my only request is
Let us
that
see if it is in the right line.
suggestions have been made on the next page, my lord. If the
Yes, you can expand on it if you want.
My lord?
You can expand on it and it is more or less in. ಇಲ್ಲಿ ಚಿಕ್ಕನರ್ಗುಂದ್ ಅವ್ರು ಬಂದಿಲ್ಲ. You can also leave that note with the court officer.
please, my lord, he's there. From Kotol 5, he's coming.
Yes. Learned AG has filed a memo enclosing a letter of the SLAO dated 17/2/2025 and a statement as regards the 28A applications filed by the respondents in the above matters. The same is taken on record. Learned counsel appearing for
the appellant in the respondent.
to Onkar Kambi, learned counsel appearing for the petitioner in WP 105586 of 2023, seeks for a short week, submit that in a week's time, his notes could be filed.
Yes.
So also is submission of the Murthy Nayak, learned senior counsel appearing for the petitioner in WP number 103322 of 23. They are so permitted to file.
Yes.
I have already filed, my lord. Notes is already on record.
You are saying Mr. Chiknargund is getting something?
My lord, that is, your lordship had directed me to give certain suggestions.
That also is a note, Mr.
My lords,
We are reserving the
convenience
right.
note is already filed.
I only sought a small indulgence for making a reply, my lord, on the last.
Really, reply.
Yes, I have.
Illa, he's not gone.
My lords, on behalf of the claimants, 5 submissions were made, my lords. I will just briefly mention.
Reply only.
Yes, my lord.
An idiot.
Yes, my lords. It was stated that the award is not, the first submission was that the award is not in dispute. And the contention was that when an award is not in dispute, the contention that execution will have to be taken is baseless, and they cannot argue writ petition is not maintainable. They do not dispute the award. They are saying that the Konkan Railway does not dispute the award. Insofar as this submission is concerned, my lords, The writ petition is filed questioning the award dated 1/7/2022 and the revised award which was notified on 12/7/2023, though it is dated as 1/7/2022. We've also sought for a declaration that the proceedings are vitiated and non-est on account of the invalidity of the Section 28A application. And the prayer, one other prayer is to quash the entire proceedings on the file of the respondent SLAO as illegal, my lords. And secondly, my lords, on 25/7/2022, the award was communicated by the respondent number 2, SLAO, to the respondent number 3, Deputy Commissioner, for approval by the Regional Commissioner, my lord. The respondent number 3, Deputy Commissioner, writes back to the respondent number 2 to verify various aspects in respect of the date of 4/1 notification and date of the 28A application itself.
Yes.
So the authorities themselves were engaged in correspondence as regards the award passed by the.
It is only a verification. Only verification, cross-check Madi before.
Yes, my
it
lords.
is-
Approval had not been communicated. Incidentally, that communication by the Deputy Commissioner to the SLA was on 10th of April 2023. That on the same day, the writ petition came to be filed seeking for a prayer for making payment in terms of that award. On 15/5/2023, the SLAO communicates to the Deputy Commissioner for the approval in respect of the enhanced amount. So in the first occasion, it was for the lesser amount. The petitioners are not aware of any further correspondence. To say that the award is not in dispute when we have raised substantive grounds to question the award and the authorities themselves, because on 15/5/2023, SLAO makes the communication giving various clarifications in respect of the date of 4/1 notification as well as the application being accompanied by a certificate. Yes.
Award is not in dispute, and the SLU has passed the award is not in dispute. You had made your contentions. ಇವಾಗ ನಮ್ಮ ಮುಂದೆನೂ ಕಂಟೆನ್ಷನ್ ಮಾಡ್ತೀರಾ?
Yes.
ನಾಳೆ ಏನೋ ನಿಮ್ಮ ಆರ್ಡರ್ ನಿಮ್ಮ ಅಗೇನ್ಸ್ಟ್ ಹೋದ್ರೆ,
yes,
the order is not in dispute. Your contention can be taken up elsewhere.
Yes.
So the award has been passed by the SLU.
My lords, it may be a situation where the reference was made to an order passed by this honorable court in WP 2542 of 2022, page 110 of the compilation which was filed, and they say that similar directions ought to be issued. In that case, the award was made in 2016 under 28A, and no action had been taken until 2020, and those petitioners had approached the court seeking for reliefs for
amendments.
Yes, my lord. But here, after the award came to be made, thereafter the authorities seek for approval. When the copy is given furnished to us, we request for the details as to the background in which the revision has been made, and thereafter we question the award itself. So that contention that it is not in dispute.
That may not be correct, Mr. Kam. You are not agreeable with the award is different.
Yes.
But the passing of the award by itself cannot be disputed.
Yes.
The contents of the award you may dispute.
Yes.
Passing of the award you cannot dispute.
Yes.
You may not like a judgment that we write, but the judgment cannot be disputed.
Yes. Yes.
When you don't like it, you can go on appeal. But the award is passed, judgment is passed.
Yes. To say there is finality,
that is what you are urging before this court.
If it is in the sense that there is finality to the award, that would not be, yes. The second.
As long as it is not set aside, it is final. Now we are considering whether to set it aside or not.
Yes.
If we confirm it, then it becomes final.
Yes.
Then when you go to writ appeal court, it again becomes questionable.
Yes.
Then if writ appeal court dismisses it,
yes,
again,
that is
only
the
stage
process.
by stage. That is the different thing. Anything else?
Yes, my lord. Insofar as the second submission was, there is no suo motu review of the award, my lords.
Calculation error.
It was submitted that the award furnished to the KRCL juxtaposed with the award furnished to the claimants, both are the same, and the only difference is in the tree values. The values, tree values and structures were added, and when it was queried by this court as to whether which is the correct amount, it was stated that the state government will have to clarify as to which is the correct amount, my lords. So according to them, there is no review. In our submission, it amounts to review for these reasons, my lord. Based on the submission, based on the observations of the deputy commissioner, the SLO undertakes a revision of the calculation sheet at serial number 6 of the, if both the awards are seen, my lords, at serial number 6, the date of 4-1 notification itself has been reviewed and changed from 30/3/1994
But
to
the second
16
calculation is lesser than the first calculation. The second calculation
is higher, my lords.
is lesser. 154 and 147.
The first one was 144.
First one was 154. Next one is
No,
147.
the second
No,
one.
it's 144, my lord.
What they seek enforcement is 1,44,00,000. What has been revised is 1,50,00,000.
First was that, because there are two issues. One is the trees. Second one is the earlier payment made was not taken into. We will deal with it. We have seen. We have made our notes on it.
It's actually,
We'll check the dates.
yes, my lord. The exercise undertaken is in violation of the principles of natural justice, and the calculation has undergone modifications without notice to the party. That is our submission, my lords. And going by the contents of the letter dated 15/5/2023 addressed by the SLAO to the deputy commissioner, it would be from the contents they have explained what they have sought to do with in respect of the award which was submitted for approval the second time. So that would be a review. And in case there is a downward revision of the amount to the prejudice of the claimant, could it then be said that the award, could it not then be said that the award has been reviewed to their disadvantage, my lords? Here, since it is not to their detriment, it may be stated that there is no such review, my lord. Be it the claimant or the beneficiary, the same standards would have to be applied. And viewed in that context, the action of the respondent number 2 amounts to a review of the award and would not fall within the scope of correction of arithmetical errors by slip or inadvertence.
Yes.
And the calculation sheet, it is our submission that the calculation sheet appended to the award forms an integral part of the award, and except for arithmetical calculations, mistakes which do not have any financial consequences, there cannot be modifications to the parameters considered. Here the 4-1 notification itself has been revised, my lord. To hold otherwise would result in giving scope for the authorities to engage in unending exercise of modification even after the amounts have been satisfied.
Yes.
And the authority cannot, in substitution of the contents, adopt a different set of calculations, and any exercise in revising not adhering to the procedural requirements would not only cause prejudice to the authorities but to also to the claimants. Hence, procedural safeguards would have to be applied. Here, in this case, everything is unilateral. And for the KRCL, again, the KRCL is a public body, and the officials discharging our public servants are accountable for their actions, my lords. Without an element of certainty and finality being attached to the award or the calculation, to expect the authorities to act upon such awards would expose them to serious risk. It can't be that the SLO.
Yes, but what were your officers doing for 10 years when the matter did not proceed with the SLO? You should have come before us, asked for mandamus.
My lords, there can be two situations, my lord. Presently, a set of applications are pending with the authorities without notice even being issued.
That's what we saw in the note. What are you doing
Yes,
about that?
yes, my lords. If a notice is issued, it may be one scenario. If where notice is not issued, it is the claimant's right which is defeated. If at all such a claim merits acceptance, ultimately it is the claimant's right which gets defeated. And
who is going to finally bear the cost of the interest?
My lords, that interest part is a question which it is a vexed question according to me, my lord.
See, you sit quiet, keeping the money. Ivat beda nade nodana ದುಡ್ಡು ಕೊಡೋದು ಅವಾಗ ಅಂತ. So you are holding on to the money, so you have to pay the interest.
My lords, if at all,
Had to pay earlier.
my lords, in these two petitions at least, if it turns on the question of the validity of the applications themselves, then the further issue of interest may not arise, subject to what my lords considers on the question of the.
We are now on the second. First one, the argument. Reply. Second one, if interest is what you are seeking of a procedural safeguard,
Yes,
that it has to be certain and finality has to be there.
Yes, my lord.
Is as regards that. That is the second leg of argument.
That is in respect of this review question.
Yes.
Yes, my lord. So, if limitation is held in our favor, then we may not go. We may not really have to be
worried about other
the interest part of it. But then, if at all, ultimately, in respect of other claims, since my learned friends have made submissions in respect of the other beneficiary, and that interest question has also been heard by your lordships. So our submission would be where there is inordinate delay in adjudication, my lords, saddling of the interest, if at all, saddling of the interest, my lords, on the beneficiary. The judgment of this honorable court had been referred to in our note of submissions, my lords. That aspect may have to be considered, and also from as to what date the interest.
You tell us, what were you doing? You
My
kept quiet. Finally, finally, in your matter, it was Mr. Murthy Nayak who wrote a letter.
He was obliged to write it, according to me, my lord. He was obliged to write it much earlier.
What were you? You are not obliged to do anything.
My lords, we have appeared before the authorities as and when notice was issued. We have filed our submissions within time. We have.
You continue to want it to be languished. The matter was languishing, let it languish. Interest akadmele, no, I have a problem.
My lords, the difficulty in so far as section 28A is concerned, the provision does not specifically provide for payment of interest, my lords. It is by certain decisions of this court, an understanding has been placed that if at all section 28A3 is resorted to by the claimant, then in which event 18 to 28 will apply, and therefore by that reasoning section 34 should be applied. But strictly in terms of the language of section 28A, the payment.
That is all decided. You up to the Supreme Court that you can't re-agitate. That interest is not applicable for 28A is not available to you as an argument now. Interest, solatium, everything is applicable on that.
That may I just point out, my lords, I had certain.
What's our judgment, sir?
This only reiterates the position. My lords may permit me to
reply a Losa judgments. You will reopen everything.
My lords, I have.
Well, you can't give a new judgment. Yes, let us see it. Now, Mr. Murthy Nayak will say, I want to see.
I have shared the copy of that, man.
Yes. Mark the para numbers which you want to rely upon. Is which one do you want to?
My lords, the first judgment is a 3-judge decision on the question of limitation being applicable, my lords. May I page 4, my lords?
Yes.
Page 4, last but 4 lines of the first paragraph. The plain language of section 28A therefore prescribes the 3 months period of limitation to be reckoned from the date of the award by the court disposing of the reference under 18 and not the appellate court dealing with the appeal against the award of the reference court. In this case, the High Court had held that the applications were belated. Para 4, they refer to what Baburam and this judgment in Karnal Singh dealt with. So they those judgments took a view that once an award has been made under 18, the section 28A application will have to be based on that award alone. So that judgment was differed in Pradeep Kumari, which was a 3-bench decision, and that judgment said that if at all a fresh reference court passes a fresh award, then a fresh cause of action will accrue to the claimant, my lords. That was the point which was under consideration in Pradeep Kumari, apart from the section, the applicability of the interest part, my lord. Bottom of para 4, my lords. There is, however, no doubt that the period of limitation has to be construed from the date of the court's award under section 18 on the basis of on the basis whereof redetermination is sought. Admittedly, in both the cases and the applications for redetermination of compensation under 28A were made long after the expiry of the 3 months from the date of the award. We are therefore of the opinion that the High Court was right in taking a view that both the applications were time barred. My learned senior for the claimants, he refers to Hansoli Devi. Hansoli Devi decided only one question, whether an application under 18, which had been rejected for the on the question of limitation, whether such an applicant would be entitled to maintain a 28A application. The Constitution bench holds that notwithstanding the 18 application being rejected solely on the question of limitation, that would not preclude. And in that context, certain observations had been made, stating that the plain language of section 28A must be looked into. So that those observations are being pressed into service to say that the application under 28A, if it is beyond the 3 months period, is not required to be accompanied by a certified copy of the award. The provisions of the proviso to section 28A1 will have to be read in the context of section 28A1 itself. The proviso, it says that provided that in computing the period of 3 months within which an application to the collector shall be made under this section, the date on which the award was pronounced and the time requisite for obtaining a copy of the award shall be excluded. There cannot be any other construction but to say that it must be accompanied by a certified copy. For otherwise, the period requisite for obtaining a copy can have a reference only to a copy made available by the concerned court, my lord. Otherwise, the claimant can very well contend that it took me 5 years or it took me 6 years to obtain a Xerox copy of the award. It will have to be read in the context in which section 28A1 is worded, my lord.
Yes.
And that also finds support, my lord, in this judgment in State of Karnataka versus Lakshman, that is at page 37, my lords.
Yes.
This is again a 3-judge decision, my lord. Yes. Para 19, may I take your lordship? Here the question was, when section 18 application is made, reference is sought by the claimant and the deputy commissioner does not act on it, whether beyond the period of 3 years, when the section 18 applicant can approach the court for seeking a reference, whether the deputy commissioner can make a reference beyond 3 years. In that context, para 19, may I read, my lord?
Yes.
Extinguishment of a right can be expressly provided for, or it can arise by implication from the statute. Section 18 of the Act, as in Karnataka, sets out a scheme. Having made an application for reference within time before the deputy commissioner, the claimant may lose his right by not enforcing the right available to him within the time prescribed by law. Section 18(3)(a) and Section 18(3)(b) read in harmony cast an obligation on the claimant to enforce his claim within the period available for it. The scheme brings about a repose. It is based on public policy that a right should not be allowed to remain a right indefinitely to be used against another at the will and pleasure of the holder of the right by approaching the court whenever he chooses to do so. When the right of the deputy commissioner to make a reference on the application of the claimant under 18(1) stands extinguished on the expiry of 3 years and 90 days from the date of application for reference, and the right of the claimant to move the court for a compelling reference also stands extinguished. The right itself loses enforceability and comes to an end as a result.
Why are you relying on this, Judge?
This is the scheme of 18 as adopted. The High Court is therefore not correct in searching for a specific provision bringing about an extinguishment of right to have a reference, and on finding it postulating that the right would survive forever.
What is the purpose of this? We are not dealing with the 18 reference.
Yes, we are not dealing with 18, my lords. But if the thresholds which are applied to an 18 applicant who seeks reference, my lord, those thresholds are much higher, my lords, in comparison to a 28A applicant.
Yes.
If at all parity is what is sought to be.
You are seeking to contend much higher. 28A order, whether he knows it or not.
Yes,
he has to file
yes, my
28A1 within 30 days.
Within 3 months.
Within 3 months.
Yes.
Is what your contention is.
Yes.
18 has 90 days plus 3 years.
Yes. Yes.
That is 3 years, 90 days.
Yes.
Your contention is for 28A.
Yes.
It is only 90 days. So you're imposing a higher
yes
degree of
diligence on the part.
Not diligence. Diligence, higher degree of not even imaginary. It is something that clairvoyance on part of the person to understand and know that there is an award which has been passed.
But
date of knowledge is what limitation always.
Yes, my lords. But unfortunately, the Supreme Court has in judgment.
It was not an argument advanced before them. On knowledge was not an argument.
Where, sir? Where, my lord?
In Jose Antonio Cruz, which you relied on.
Yes. But in Popat Bayeru, it has been considered, my lord.
Yes.
And at page 45, my lords, they also make a reference before para number 12, my lords, in the same judgment. 5 lines from the top. If we construe the provision, my lords have it, ma'am. If we construe the provision as conferring a right, conferring on the litigant a further right to approach the court for getting the matter referred, in a case Deputy Commissioner fails to make reference within 90 days, we have prima facie to say that on his failure to approach the court and get the reference made, he would lose his right to have a reference for enhancement of compensation. Obviously, the mischief that was sought to be averted by the legislature was the causing of undue delay by the deputy commissioners in making references and making of highly belated references, sometimes based on applications clandestinely received long after the award itself has been made. If we keep this object in view, the conclusion possible is that if a claimant does not get a claim referred to the court within 3 years of his making the application before the deputy commissioner within the period fixed and the accrual of the cause of action, his right to claim enhancement of the compensation would get extinguished. This part, my lord, in the context of 28A of the Act, there will be no irreparable prejudice caused to the claimant, since he can always make a claim for more based on any enhancement of the award of the court in any other reference arising out of the acquisition under the same notification. The difference may be only in the matter of interest and the like.
Yes.
The court says that the difference may be in the matter of interest, my lords. Here we are in a situation where if at all the interest component is to be accounted for, that will be higher than what is awarded to a section 18 claimant, my lords.
100 times higher in your case.
Yes. And only one other paragraph, my lord, page 50, para 21.
Yes.
the object of bringing in section 18 of the amended form in Karnataka has been violated by the decision. The object was to ensure that the so-and-so did not take place in the office of the deputy commissioner and to prevent belated applications and predated applications being received and references made years after the acquisition. The object was also to ensure that all matters in connection with an acquisition were completed within a reasonable time and claims for enhancement did not hang like a Damocles sword over the government or the company for the benefit of which acquisition is undertaken. Therefore, any interpretation based on which the deputy commissioner is given power to revive a claim which has become unenforceable would defeat the very purpose for which section 18 in the form in which it is was enacted by the state of Karnataka. The majority so and so was therefore in error in thinking that the deputy commissioner could make a reference at any time that the deputy commissioner could make a reference so and so at his notwithstanding the fact that the right to move the court in that behalf had been lost. And para 25 they make a reference to 28A and once again that it should be within the time limit. The view that we have taken after all does not deprive a claimant who had protested of his right to enhance compensation in view of the introduction of 28A. He could seek an enhancement based on any award that might have been made within the time prescribed, therefore, in respect of any land covered by the same notification. My lords, the provisions of constitutional validity of 28A and section 18 came up for consideration before the division bench of the Himachal Pradesh High Court. Yes. And my lords may kindly take page 78 for a minute. My lords, I'm only emphasizing because this 28A question, the multiple views have been taken and therefore to assist my lords. Yes. May only kindly see page 85, my lords. The judgment begins at page 53, page 85. I'll read from 4 lines from the top, my lord. The procedure prescribed in 28A was also held to be not violative of Article 21 of the Constitution. It was held that the bare reading of 28.1 along with proviso would indicate that the making of the award by the civil court, which becomes the judgment and decree, is the starting point for which limitation, which period of limitation is allowed for making the application. The legislature prescribed the 3 months limitation to quicken diligence like caveat emptor and provided to a non-protester right to redetermination provided the application in writing is made to the collector within 3 months from the date of the award of the court of the civil court of original jurisdiction, excluding the requisite time taken to obtain a copy of the award. In other words, the right and remedy under 28A stand extinguished with the expiry of 3 months from the date of award under section 26. In a given set of facts, there could be more than one reference under 18 at the behest of different claimants of the land covered under 4-1 notification, as the court may make successive awards at a time. The compensation given in respective awards may vary and may be higher than the one given in the earlier award. In the teeth of the express language of subsection 1 of section 28A, limitation of 3 months once expires in respect of the earlier award by efflux of time, none of the later awards could provide any assistance to revive the lapsed time under 28A, nor provide a fresh cause of action or successive cause of action when multiple awards are made on different times or different dates. This may not be in keeping with Hansoli Devi, which says the successive award will provide a fresh cause of action. Page 87, my lord, Popat Bahiru is referred. Pradeep Kumari is also referred, and Pradeep Kumari lays down the conditions which are required to be satisfied. Page 87 at the top. A person would be entitled to seek redetermination of the amount of compensation payable to him, provided the following conditions are satisfied. Serial number 5. The application is moved within 3 months from the date of award on the basis of which the redetermination of amount is sought. That is one of the conditions in the judgment in Pradeep Kumari itself, my lord. And in Popat Bahiru so and so, while discussing section 28A of the Land Acquisition Act, the Honorable Supreme Court has observed that the statute provides limitation of 3 months from the date of award, excluding the time for obtaining a copy of the award. it has no relevance so far as date of acquisition of knowledge is concerned. The plea of the applicant that limitation of 3 months would begin from the date of knowledge was not accepted and held unsustainable. This court held that it is settled proposition of the law that the law of limitation may harshly affect a particular party, but it has to be applied with all its rigor, etc. This is there in Popat Bahiru. Popat Bahiru, my lords, has been referred to in the Constitution Bench judgment in Indore Development Authority, as well as in another Constitution Bench judgment in New India Assurance, where they have applied the law laid down in Popat Bahiru, my lord, with reference to limitation. And my lords, also a judgment of the division bench of the Karnataka High Court, my lord, serial number 9, page 164. Whenever a question of interpretation arises of a central legislation, a view taken by one High Court, page 164 is the relevant portion, my lord.
Kusum ingots.
With reference to Kusum ingots, here it was the provisions of the Succession Act, Indian Divorce Act 1869, page 164, para number 7, last 7 lines, my lord, last 4 lines. This, the Kerala High Court pronounced on the constitutionality of a provision of a central act would be applicable throughout India. This is made clear by the Honorable Supreme Court in Kusum ingots, where it has been stated that an order passed on a writ petition questioning the constitutionality of a parliamentary enactment, whether interim or final, keeping in view the provisions contained in clause 2 of Article 226 of the Constitution, would have effect throughout the territory of India, subject, of course, to the applicability of the Act. In that view of the matter, this writ petition would not call for any specific orders with regard to the holding constitutionality or otherwise, keeping in mind the pronouncement of the division bench of so and so. In the context of Kusum ingots, the position of law in regard to subsection 1 of 10A of the Act is now made clear, particularly insofar as the state of Karnataka is concerned. For the 28A question, my lords, and there was one judgment which regarding this parity question, my lords. My lords, if at all ultimately 28A does not require anything else except to find out whether the application is made within the prescribed period and to apply whatever award has been passed, then it should not take the statutory authority a long period of time for deciding the claim, my lords. In that, my learned friends have addressed that the same amount of compensation need not be paid. My lords, this honorable court, my lords,
yes.
My lord, the cost title is lengthy, so I have judgment starts at page 100, my lords, and the relevant portion, para 6 at page 125, my lords.
Yes.
The vehement submission of the claimants that in view of Nagpur Improvement Trust and Union of India versus so and so, that the market value of a land in a particular village would be the market value for all other lands in the said village that are comprised in the same acquisition notification appears to be too far-fetched a proposition. Even in respect of lands in the same village, differences in their valuation may galore regard being had to a host of factors such as conversion potential, fertility levels, nature, so on. So therefore treating them all as equal, ignoring the demonstrable differences, would offend the rule of equality constitutionally enshrined in Article 14. And equality enjoins treating equals as equals and not unequals as equals, a view in variance falls also E.V. Rayappa. While discerning the ratio of a decision, one has to keep in mind a set of primary principles possessing higher normative. Otherwise, the system which is expected to function as a body of coherent principles would have norms that may compete, if not conflict with one another, each diminishing the value of the other and thereby creating a chaotic market of so and so. This would not augur well. A perusal of para 5 and 15 in Harinder Supra, that lands in 5 different villages were substantially similar in all respects, and therefore the apex court directed equal treatment for the purpose of determining the compensation. All those lands were comprised in the same notification, figured only as one of the factors at most. That is not the case here. The difference in nature, conversion potentiality, nearness, so and so being apparent. A decision is an authority for the proposition that is laid down in the fact matrix.
What according to you are the difference? You are not made out any difference either before the SLU or.
My lords, we had taken a contention. This is based, the section 18 award is in respect of survey number 189, and section the 28A claimants, if at all the validity question, is in respect of 218, my lords. And those survey numbers are not, they don't have any proximity, and the features which apply for 189 do not apply for section
You are only acquiring 20 feet in length, in width by a large length.
Yes.
What difference would that
This
make?
railway track example has been given here, my lords.
What difference would that make?
Kindly see this, my lord. 6.3, the vehement submission of the senior advocate appearing for the claimants that on the principle enacted in 28A, all lands comprised in one notification should be treated as being equal in all respects, and therefore the owner should be handed same recompense is a bit difficult to countenance. If lands from so and so are notified for acquisition for laying a railway track, going by the assertion of the claimants, same compensation has to be given to all lands, notwithstanding the fact that the piece of land comprised in the notification is situated in the heart of the city, whereas another lies in a remote village.
Why they are not entitled? You are not shown anything.
My lord,
you are not led any evidence to show that it is not the same, it is not situated in the same.
We
manner.
have
They made
taken a
assertion.
contention. It may be a bare contention, my lord.
They have made assertion. It is, the burden is on you to prove otherwise.
Yes.
See, and 28A,
Yes.
there's already an award. Why that award is not applicable is for you to show, not for the claimant.
My lords, here the SLAO proceeds on the basis that the same amount of compensation is to be paid.
Correct. But what did you do? You were sitting quite all through for everything. Now you blame the SLO, you blame the claimant, you blame everybody. What were you doing? You did not lead any evidence on this. You are also public officials. Public money you are saying, but what did your officials do with the public money sitting on it for last 12 years? They did not do anything.
My lords, we have taken our contentions in
and left it at that. So you also take a contention and leave it at that now also. There is nothing which has been produced to show contrary to the claim or the award that is not this property is dissimilarly situated.
my lord, this submission is in the alternate, my lord. Only in continuation of the
each item we'll have to deal with all of your contentions.
No,
we'll be
this was
dealing with everything.
only in continuation of the submissions made on behalf of Niravari Nigam with respect to this same amount of compensation. This is a view expressed by the court, my lords. And yes, my lords, my learned senior has also referred for the judgment in MSA, my lords. The MSA, but that judgment is in the context, my lords have referred to a Supreme Court decision which arose under a section 18 issue, my lords. The landowners had not been awarded the same amount of compensation. The judgment in Narendra's case, which is referred to in the MFA, that was in a situation where on account of the inability of the landowners, so under section 18, to pay the court fee, the High Court had restricted, and the Supreme Court had analogized section 28A to say, my lords. But then the consistent a 3-judge bench decision we have produced in our first compilation, that judgment also takes a view that section 28A would be applicable in respect of the same notification, but then when there are comparable differences, those differences will have to be taken note of, and the The parity, my lord, the parity that if at all, if it has been awarded, then the landowners or should, without making a reference to an application for redetermination, should be paid the same amount of compensation may not accord with the judgments of the Supreme Court. That is my humble submission.
Yes, Mr. Naik.
Please, my lord. Short reply. Your lordship will kindly take 105586. Regarding limitation, I will point out, my lord, from the section 28A application. It will answer both the points argued by my learned friend Omkar. That is regarding limitation.
Date of the application to date of receipt to date of filing.
Yes, not only that, my lord, regarding the similarly placed, that both the lands have the similar plus factors. May I for a moment, my lord? 105586, that is KRCL versus Deepaji Lipna.
Yes, page number?
Page number 114.
Yes.
This is the, my lord, 28A application filed by us before the SLAO. Now, my lord, kindly come to page 118.
Yes.
Paragraph 10. The instant petition under 28A of LA Act is filed today and is well within the period of limitation after excluding the time taken for obtaining the certified copy of the judgment in LAC 174 of 96 as per proviso to section 28A1. That is, the judgment came to be passed on 31/7/2008. Time taken for supplying the certified copy is 46 days. In normal course, the application ought to have been filed on 31st October 2008. Adding 46 days, the period of limitation would end on 16/12/2008. Now, my lord, come to page 119 for a moment. That is the next page. Signed and verified at Karwar this 17th day of November 2008.
Yes.
Now, my lord, on the next page, that is page 120. 17th.
Taken us through all these things, Mr. Naik. Don't repeat it.
No, my lord, for the fun. No, I have not. That's the reason. This is, in fact, presented by me. This is my by my handwriting. 17th November 2008, presented so and so. Because, my lord, on page 134, Mr. Madhusudan Naik referred to the register. 134, he referred to the register and he said there are two dates. 134 at serial number 7.
Yes.
At serial number 7 on page 134, Lord, 19109 is the date when it was officially entered. Kindly see 17/11/08. That is the date of presentation.
That would be explicitly barred.
1 minute, Mr. Omkar. I didn't interfere. Have some patience. Now, next one, my lord, as far as Vitoba Shankar Faide, that is 5/11/08. So 17/11/08, my lord, I have presented. Now, I have also produced the title sheet, which I didn't refer to, along with my statement of objection. The lordship would take page 8.
In statement of objections to what?
To their writ petition. My statement of objection. This is their writ petition, my lord, which I referred to. Now, I have filed my statement of objections to their writ petition.
Yes. Yes.
The title sheet, my lord, SLAO, Karwar, etc. Kindly see on the left-hand side, my lord, of the margin portion.
7/11/08.
17/11/08, Jilladhikari Kacheri, Karwar, date 17/11/08, advocate for petitioner Murtina.
Yes.
So, my lord, this would make it abundantly clear. And in fact, in my notice also I have mentioned, and the SLO in a reward, my lord, at page 37, recorded a finding. On page 37 of the writ petition, has verified all this, which is at annexure A. Page 37. In the preamble column, just above the tabular chart below, where the villages are specified, the application under section 28A is received by the SLO Konkan Railway Office on 17/11/2008 through Advocate Shri so and Shri so with following particulars.
Yes.
And again on the same page, last line, she reasserts, my lord, or rather reiterates, the application so and so was received on 17/11/2008. Even in the reference, my lord, on that very same page, even in the reference column, the learned SLO refers to application by advocate so and so dated 17/11/2008.
Yes.
Likewise, my lord, in fact, on page 38, your lordship may kindly turn to page 38, next page, around 30 lines from top, my lord. After verifying the documents, around 13 lines from top, after verifying the documents, it is observed that the above said 28A application has been received within a stipulated period out of total so and so.
Yes.
Now, my lord, this is with regard to limitation. Now, as I would request your lordship to kindly turn to page 118, my lord.
Yes.
118 para 11. Petitioner further affirms that her land contained in survey number so and so, area 3 acres 7 guntas so and so enas, village being adjoining to the lands acquired belonging to Sri Ramdas Vishram Netarkar in LAC 174 of 96 and having similar plus factors and nature, etc., deserves to be considered for redetermination of the amount of compensation to the compensation awarded by the reference court, and that may be awarded by the Honorable High Court of Karnataka in MFA so and so with 6916 of 2008. So,
yes.
we have asserted, my lord, we have filed our affidavit also.
Yes.
For sake of clarification, my lord, originally the reference court had awarded only 11,500. When this 28A application was filed, the appeal was pending before this honorable court. The honorable court, my lord, enhanced it to 18,000 and odd. That was assailed by Konkan Railway before the honorable Supreme Court, which came to be dismissed. Those orders are also produced, my lord. Konkan Railway, they are there. So it has been confirmed by the Supreme Court. So this 18,250, which has been taken into consideration by the is the amount fixed by this honorable court. And it is well settled, my lord, that has been finally determined by the court. This is my respectful survey. As far as, my lord, the judgment which my friend referred to, the answer lies on page 95 of my compilation.
Your compilation filed in?
Filed in 103322 of 2023 on 1/8/2023. Firstly, my lord, with regard to the contention of the learned counsel for Konkan Railway, that the writ is not maintainable and a mandamus cannot be issued, the lordship may kindly turn to page 11 of my compilation.
You want us to see 95 or 11?
First 11, my lord, because one contention which Mr. Omkar canvassed today with regard to writ not maintainable, I'll answer that first. Page 11. This is before the learned single judge of our honorable court, my lord. Putlingaya, etc. Kindly come to page 14.
Yes.
Para 2, the petitioner submits that an order came to be passed under section 28A1 of so and so, so and so. The names of petitioners are found in table at so and so. It is further submitted that despite the order under section 28A of the Act being passed on 12/1/2016, compensation has not been disbursed till date. 4. In light of the said admitted facts and from records insofar as petitioners so and so are found are beneficiaries under the order at Annexure B, necessary steps to be taken for dispersal of the compensation by respondent 3. In the light of disputed facts and taking note of the order being passed in the year 2016, steps by respondent number 3 to be expedited. Learned additional government advocate so and so, so and so. So here a mandamus was issued, and in para 7, Lord, they had already submitted a representation in that case saying that the present market value will have to be given. So as for the petitioner submitted representation in Annexure A has also been made to consider other requests as regards to the entitlement of petitioners in the light of delay in payment of compensation. As is stated, that representation contains higher reliefs than the directions as contained in paragraph 4 above. The representation at Annexure A to be considered by respondent number 2 or redirected to appropriate respondent to be considered in an appropriate manner in light of the other directions made in paragraph 4 above. Accordingly, the said writ petition is disposed of. Contention of petitions as regards entitlement for higher compensation in accordance with law is kept open. Now, page 17, my lord. Respondent take steps for dispersal within a period of 10 weeks from the date of release of this order. Needless to state that the statute of entitlement of interest for delayed payment in terms of section 34 of LA Act to be also extended. Now, this regarding higher compensation, the representation was not considered. Hence, my lord, either writ petition which was decided by your lordship, and that I have taken your lordships through the other day with regard to representation.
Yes.
Now, my lord, with regard to the fact that they are not similarly placed at all, your lordship may kindly turn to page 70. 70.
Yes.
Learned single judge of this honorable court, my lord. Relevant paragraph is paragraph 35 on page 95. 95.
Yes.
Paragraph 35 and 36. I will skip para 35, my lord. Para 36. In the present case, I'm sorry, paragraph 35 only is relevant, my lord. First 5 lines I will skip. Paragraph 35. The section 28 of the Act specifies that if the court allows to the applicant any amount of compensation in excess of compensation awarded by the LAO, the persons interested in all other lands covered under the same notification and who have not made an application under section 18 of the Act before reference court by written application to SLAO within 3 months from date of award of the court require that the amount of compensation payable to them may be read on the basis of amount of compensation awarded by the court. Hence, it can be implied that the object of the Act was to award uniform compensation for acquired lands covered under the same notification. Para 36. In the present case, All the subject lands are small tracts of land and similar in nature, except that land bearing RS number so and so, so and so. The owners of these lands, which are small tracts of lands, cannot be deprived of uniform compensation when their lands are acquired for the same purpose covered under the notification, and their entire extent of acquired lands is utilized for the purpose of construction of canal, and there is no scope for further development. It would be discriminatory if the land losers of small tracts of land who are farmers are deprived of uniform compensation when their lands are compulsorily acquired, and any amount of enhanced compensation with interest will be inadequate for them to purchase an alternative land, since by passage of time the market value of agricultural land would have increased manifold. The enhanced compensation with interest will be paid to land losers after knocking the doors of the courts of law, and the enhanced compensation is paid to the land losers after several years, though they are legally entitled to receive just and proper compensation immediately after passing of the award by the LAO. Further, it would be impractical to adopt belting method for determining the market value of these lands. So to avoid discrimination in the matter of fixing market value of these lands, and also having regard to the fact that these lands are small tracts, etc., etc. In our case, my lord, area involved in Mr. Netalkar's land is around 3 acres and odd. The present petitioners have lost, the landowners have also lost around 3 acres. They are adjoining lands. So not the same compensation.
Anything else?
That's, and as far as Jose Antonio Cruz and everything, that has been considered. Pradeep Kumari and Hansoli Devi is my respectful sir. Grateful, my lord.
My lords, that note of suggestions, I will modulate it and hand it over to the court, my lord.
Yes, Mr. Chikkanakund has come, my lord, my note of suggestion.
Heard reply arguments of Sri Omkar Kambi on part of Konkan Railways and Sri Murthy Nayak, senior advocate on behalf of the respondents in the said matter. Reserved for judgment.
Lordship permission.
Nimdenapa.
The mistake in para number 9. But I've filed a IA for amendment to delete those. In 6 matters I've filed.
Mistake.
By oversight, my lord, some lines were inserted saying that, my lord, applications were not forthcoming in the records. Lordship, that deletion.
Last argument ಮಾಡ್ಬಿಟ್ಟು ಇವಾಗ delete ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Filed amendment. That was pointed out last time. It's not argued like that.
It was argued.
Lordship,
an application for amendment has been filed in 109.2.2,
109.3,
109.9, 109.11,
9 also,
109.9,
109.14,
109.14.
6 matters. That first matter also.
Accepting the reasons stated therein, the amendment application is allowed. Counsel for the petitioner to carry out necessary amendment and file amended petition within 10 days from now. Relist on reserved alla ivaga adu haki first. Relist on 28th ಒಳಗೆ ಮಾಡ್ತೀರಾ?
Please.
28th February.
With your lordships kindly. Yes. I've got only 2 submissions for you.
ನೀವು ಇದ್ದೀರಾ ಹೇಳಿ.
So over there, by way of Lord, may I request you, lordship, your lordship's judgment. One, please. In MSA 200186 of 2019, Lord, I request your lordship, Lord, para 13, page, Lord, 39, para 1321, your lordship's Lord, direction.
Yes.
My Lord will kindly, Lord, the state being a custodian of all the documents, information and the data pertaining to the land in question, enhanced compensation awarded as regards the land, I am a considered opinion that it would be the duty of the state to invite all the land losers of the persons from whom the land is acquired for enhancement of compensation, which has been made by the court of the reference or the court of appeal or this court or apex court from time to time, and call upon the land losers to come forward and collect the compensation amount from the acquiring authority. Lord, in this Lord paragraph, Lord, satisfies two aspects, Lord. So far the state of Karnataka is concerned, if it is strictly implemented, Lord, the compensation, here is our case.
It's only a suggestion, Mr.
No, Lord, this can't be. Lord, what I respect the submission, Lord, 300A, Lord, this aspect of the matter has been, Lord, in fact, Lord, incorporated in the judgment, taking into account, Lord, Lord, Article 300A, plus, Lord, your Lordship, Lord, to save the public money. Lord, your Lordship, it is our money, Lord, what I respectfully submit. That is taxpayers' money, Lord, which is this. Lord, so far the state of Karnataka is concerned, Lord, this aspect of the matter, if it is the Lord, crores of rupees of the Lord, taxpayers can be saved.
Yes.
Therefore, Lord, on this point, Lord, it can't be, Lord, considered, it can't be, Lord, interpreted as a suggestion, but it is to be, Lord, a financial affairs of the state and, Lord, the payment of
ಪಕ್ಕದಲ್ಲಿದ್ದಾರಲ್ಲ ಅವ್ರ
ಆಯ್ತು ಹೌದು ಇರ್ಲಿ
ಹಿಂದೆನೂ ಇದ್ದಾರೆ ಪಕ್ಕದಲ್ಲಿದ್ದಾರೆ ಸರೌಂಡೆಡ್
ಅದಕ್ಕೆ ವಾಟ್ ಐ ರಿಕ್ವೆಸ್ಟ್ Lord, this Lord, what I think, and so far as the other arguments are concerned, Lord, all these questions have been considered by your Lord, in this case, and all this pedantic approach of Lord.
FB Patil for losers.
This judgment relating to the interest component being saddled on the state.
ಆಯ್ತಾ ಎಲ್ಲರದು?
Milord, may I make one request?
Yes.
Can our matters be, Milord, de-tagged instead of posting
We are
it?
dealing with everything together, we'll deal with it.
Please, oblige.
ಏನ್ ಮಾಡೋದು? ಉತ್ತರಕ್ಕೆ ಹೋಗ್ಬೇಕಾ ದಕ್ಷಿಣಕ್ಕೆ ಹೋಗ್ಬೇಕಾ? It won't happen. ಹಿಂಗ್ ಹೇಳ್ತಾ ಇದೀವಿ, ನೀವು ಎವ್ರಿ ಡೇ ಚಾನ್ಸ್ ತಗೊಳ್ಳಿ ಚಾನ್ಸ್. ಮಂಡೇ.
Let's,
ಯಾವ serial number?
112.
112.
I'm appearing for the petition. I'm appearing for the petitioner
In
in this
112.
matter.
In 112?
Yes.
Yes.
There's a change of counsel in the matter, madam.
So what do we do?
Let's, I have a memo also to file.
You practice in the Bangalore High Court?
No, I'm practicing in Delhi.
Delhi. That is why this memo has been filed.
Yes.
So this memo will be rejected.
That's up to Millards.
Yes. You can't be doing these kind of things, Mr. Counsel.
Millards, may see it completely. I don't want to read it. Otherwise, I would have read it.
Readings are not complete in this matter?
Pleadings are not complete, I believe.
Readings are not complete?
Not complete. Pleadings are not complete.
Then how did it come for final hearing?
Readings are completed. Statement I gave. Tell statement.
Let's,
But pleadings are not completed. In state has not.
pleadings are not
Final
complete.
hearing ಹೆಂಗ್ ಬರುತ್ತೆ?
Because of the
Come for final hearing.
The rule not issued also.
Who is to file the pleadings?
the government has not filed the affidavit.
For hearing. You are the petitioner in both the matters.
Yes, I am the petitioner in both matters.
Respondent number 1 has filed objections.
Yes.
State?
No objections.
No, objection is not yet filed.
You want to file, don't want to file?
We want to file objections.
When will you file?
10 days time.
He is being listed and you are
My
now
lord,
saying you want
since,
10 days.
since my lord in this matter learned AAG appears, for that reason on his behalf I am requesting us.
Second matter, no, Ashton.
Ashte same.
112. Who is appearing for respond number 1 in 112?
My lords, I appear for my friend.
Pramod
On
Katavi. Who
I
is the
appear.
counsel?
So Satish Raichur is the advocate on record.
I'm on record.
That's what he is asking.
Sri Satish S. Raichur has appeared for respond number 1. Registry is direct delete the name of Sri Amit Kumar Deshpande, Subramanya R. and Pramod Katavi as that appearing for respond number 1. 112.1 again Satish Raichur is for respondent. Anil Kembavi, Amit Kumar, Jaivital Rao, Pramod Katavi delete. You are?
I'm Aljo K. Joseph.
Sri Alcor K. Joseph submit that he has filed Vakalatnama
Please, my lord.
for the petitioner. Registry is direct print his name as such and delete the name of Sri Paniraj Kashyap as that appearing for the the petitioner in both the matters. A memo has been filed seeking for recusal.
Let's, in one sentence, I'm making one submission.
Yes.
Because the decision and a subsequent contempt which was in file before the Supreme Court, the entire issues which has happened on deciding IA number 1 of 2025 has been discussed. Lords, in that context only, I have in the last paragraph I have categorically mentioned.
Mr. Counsel, our conscience is very clear in what we do.
But the apprehension
We are
of
not-
my client, it's
we
my
are not
responsibility to
concerned-
bring the
We are
apprehension.
not concerned or whether we are, this is the first time that something like this has been said in the last 6 years.
Let's,
But we take it with a pinch of salt that it deserves to be.
I apologize
Or
for
with
this,
a
my lord,
pinch of
but it is
salt.
my duty to bring it to my lord's notice that the apprehension in my client's mind, it's very serious. So it is my
Your
responsibility.
client may win some matters, may lose some
Absolutely.
matters. You as
I
a
don't-
lawyer may win some matters, may lose some matters.
I'm doing my job, my lord.
That
As I am
is-
discharging my duty as a
Please
counsel.
understand, you're not doing your duty as a counsel. You may be doing as a counsel, but you're not doing it as an officer of the court. There's
That's
a-
the reason, my lord, all they have waited.
You
I
are
waited for
still-
my turn.
You are still very young.
20
It's
years.
very easy to be persuaded
20 years
by
have been
your
put in my
client.
mind.
20 years is nothing.
Nothing.
Is nothing. Ask Mr. Javalkar who is behind you.
Yes, no. They are quite seniors to me.
Mr. Javalkar also succeeds in some matters, he loses in some matters. There's nothing personal in any
Nothing
of it.
personal, absolutely nothing.
So if you are going to be caught out by your client in doing these kind of things, you are bringing the institution to disrepute. That is something which you need to think about.
Well, I bow down to that, but the way the facts which has been told to me, it was my
It
responsibility
is
to
for
bring it to
you
my lord's
to,
notice.
it is for you to verify the facts, not just parrot it out. Which
To the
we-
extent, my lord, it has been told, it has been written in the memo. It's for my lords to take a decision on this.
When you don't have the ability to understand things, there's no point in us telling you. So you won't still be able to understand.
To some extent, my lord, I understand.
So-
Abundant caution, my lord, we have drafted the contempt petition with abundant caution.
A memo for recusal has been filed by the counsel for the petitioner. Certain allegations have been made as regards the manner in which orders had been passed in another matter. Either
In IA number 1 of 2020.
both
Same
the
matter.
matters are connected here.
Both the
100. No, this is some other matter. 1000029.
Yeah.
That is not here. That is writ appeal, sorry.
100.
In which matter orders have been passed?
In the very same matter. In the very same matter, IA number 1 of 2025.
IA number 1 of 25 in the above matter.
Writ petition number 1004256.
If at all the petitioner were aggrieved by any of the orders, it is for the petitioner to take up the matter in challenge before the appropriate authorities. It does not augur well for the petitioner to have failed in a matter and then make allegations in the manner which it's been done. Be that as it may, less said about it, the better, since this court need not be pulled down to the level of the petitioner and or its counsel who has made the submissions. Since though the matter is listed for final hearing, the pleadings not having been completed, relist on learned AGA seeks for
10 days.
10 days time to file his statement of objections. Just on 7th March.
Lords, I'm deeply obliged and I'm apologizing for the embarrassment which has been caused, but it is my duty to bring it my Lord's attention.
All
What
this
is
was not required. The matter was not anyway going to reach. You unnecessarily go for the issue.
it was mentioned, my Lord? I'm sorry.
Any
Deeply obliged.
judge before this court will decide it in accordance with law. If you think Delhi decides it otherwise, then it is your choice. Please don't bring those kind of practices to our court.
No, not at all. You're not inclined to bring it actually.
Our court is much different.
I'm also from South, I'm from Kerala. I'm quite aware about all this.
We don't know where you are from and not where we
I'm mentioning
concerned.
that I'm quite aware about the South Indian procedure.
Nor we are concerned. Please don't bring those kind of practices to this court.
Very well, Mal. We'll
Don't
try.
do that.
That's why I said I've been very, very cautious while drafting the contempt petition.
That is why we said that though it has been signed by, because you said it's drafted by you.
So deeply obliged.
Serial number 88. A year ago, there was a direction by your
Huh?
Lordship. A year ago, my Lord, exactly. There was a direction by your Lordship for conducting an inquiry, my Lord. Serial number 88.
Yes.
Till now, the report is not been filed. Within 90 days was the stipulation. There was a stipulation for it.
Who was to conduct the inquiry?
My Lord, in the town municipality, the husband was acting as a super president.
ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದು. You are for the petitioner.
Please.
They have issued an endorsement is what they have submitted.
Endorsement is different, my Lord. I'll argue with my Lord. Kindly have it at 2:30 tomorrow, my Lord.
ಎಲ್ಲ 2:30 ಅಂತ ಹೇಳಿದ್ರೆ ಆಗಲ್ಲ. ಎಲ್ಲ ಡೇಟ್.
My Lord, serial number 89, my Lord. 89, my Lord.
ಏನಪ್ಪ ಅರ್ಜೆಂಟ್?
My Lord, in this matter, my Lordship has directed the ARJ to submit a report regarding the commercial court establishment, my Lord. And in the year 2024 itself, in February 5th, my Lord, ARJ has submitted his report, my Lord. My Lord, kindly tomorrow, my Lord.
What is to be done in this?
My Lord,
what is the urgency?
My Lord, respondent has filed this suit, my Lord,
Mr. Counsel,
which is
tomorrow
commercial in nature, my Lord.
ಎಷ್ಟು matters ಇದಾವೆ?
89.
There are more than 100 matters listed tomorrow. So simply listing and not reaching is of no purpose. Mondayನೂ ಅಷ್ಟೇ ಇದೆ. ಅರ್ಜೆನ್ಸಿ ಏನಾದ್ರು ಇದೆ, ಡೆಮಾಲಿಷನ್ ಇದೆಯಾ, ಏನಾದ್ರು ಎಜುಕೇಶನ್ ಇದೆಯಾ ಹೇಳಿ. ಅದು ವಿಲ್ ಕನ್ಸಿಡರ್. ಅನ್ನೆಸರ್ಲಿ ಡೋಂಟ್ ಪ್ರೆಷರೈಸ್.
ಪ್ಲೀಸ್.
ಇಟ್ ಡೋಂಟ್ ರೀಚ್ ಅಂಡ್ ನೀವೆಲ್ಲ ಮಧ್ಯೆ ಸೇರ್ಕೊಂತೀರಾ, ಯಾವ್ದು ಬೇಕೋ ಅದು ಕೆಳಗೆ ಹೋಗ್ಬಿಡುತ್ತೆ.
Serial number 20, my Lord.
Dismissal has been done, and I am telling you that LRs are already on record.
ಯಾವುದು?
Serial number 68.
68. And counsel for the petitioner has filed a memo that the legal representative of deceased respondent number 6 is already on record as respondent number?
LRs of the respondent number 6.
As respondent number 7 to 12. Are in note, hence the said memo is accepted. Respondent number 7 to 10 and 12 are treated as legal representatives. Issue fresh notice to respondent number 7 to 10 and 12.
Process has been read.
In order to enable them to make their submissions on them are treated. Issue fresh notice to respondent number 7 to 10 and 12 to hear their say on the memo filed by the petitioner. Returnable by 29th April.
Serial number 69.
69.
I filed the memo stating that the respondent number 2 expired and they are 3 to 5 are the LRs of the respondent number 2, my lord.
3 to 5 respondent.
Yes, my lord.
ಮತ್ತೆ ಅವ್ರ notice ಹೋಗ್ಬೇಕು. Counsel for the petitioner has filed a memo seeking for treating respondent number 3 to 5 as the legal representative of deceased respondent number 2. Issue fresh notice to respondent number 3 to 5 on the said memo returnable by 29th April.
Oh, bless.
104 asked over matters. 104. Just where is Shilvan?
Lordship, serial number 87.
One ನಿಮಿಷ.
Serial number 50, my lord. 50.
ಒಂದು ನಿಮಿಷ ಇರಿ.
Just a moment. Shilvan ತರ್ಮಾ. ಏನ್ ಹೇಳಪ್ಪ?
PM ಶೀಲ್ವಂತ್.
Serial number 50, my lord. ನಾಳೆ ಆಕ್ಷನ್ ಇದೆ ಅದರಲ್ಲಿ.
Serial number
50.
15.
ಹೌದು.
15 ಯಾಕೆ ಇರ್ಲಿಲ್ಲ ನೀವು ಅವಾಗ?
50 ಇಲ್ಲ ಕರೆದೇ ಇಲ್ಲ ಬಂದಿಲ್ಲ ರೀಚ್ ಆಗಲಿಲ್ಲ.
50.
50. Tomorrow there is the auction, my lord. Partial auction is there.
ಕೊಡಿ 50.
Annexure F, my lord. Annexure F is the auction notice. ಅದರಲ್ಲಿ page number 38 ಅಲ್ಲಿ there are only 19 shops. Actually in total there are 33 shops, my lord.
This is auction for the shop.
How
you participate in the auction?
ಇಲ್ಲ my lord. ಅದರಲ್ಲಿ there is the partial part auction ಇದೆ. In total there are 33 shops.
You want to participate if your shop is under auction, you want to participate.
It is in the coordinate bench, my lord. ಅದರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ partial auction is
Partial partition ಅಲ್ಲ.
partial auction
You
ಇದೆ.
want to participate, you participate.
partial auction ಇದೆ.
We are not going to stay this.
ಅಲ್ಲ partial auction ಇದೆ ಅದರಲ್ಲಿ ಉಳಿದ 14 shops ಅಲ್ಲಿ unilaterally
Notice for respondent number 1 and 2. ಕಲ್ಗಟ್ಟಿಗೆ ಯಾರಪ್ಪ?
PN Pujar, MN Pujar, MB Pujar.
MB Pujar is directed to accept notice for respondent number 3, counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said counsel. The petitioner is reserved the liberty to participate in the auction of his shop if he so resides in terms of this circular. Kalsur Math.
2019 and 2022.
Kalsur Math ಇದರಲ್ಲಿ notification in terms of so
My lord, right of first refusal may kindly be.
or to exercise right of first refusal in terms of terms. Yes.
Petitioners of the farmers, my lord, before the deputy commissioner for seeking the land grant, and the same is rejected, my lord.
Rejected.
Fresh matter, my lord. Notice will be issued.
Just a moment, where is Mr. Shilvan?
My lord, 56, my lord, it was listed.
Serial 41, my lord. The petitioners of the farmers, my lord, seeking for the land grant before the deputy commissioner. Earlier they made.
It's been rejected, let them file their objections.
56. Serial number 20.
Don't interrupt in between.
Serial number 56, my lord, it was listed for dismissal, my lord. My lord, no. Today, the advocate for respondent filed another memo stating that 2 other respondents have died, my lord. We'll file the necessary 2 weeks time maybe.
Everything 2 weeks.
Please.
Serial number 70, my lord. Respondent number 1, my lord, is removed. I have filed an application to bring you on records.
Notice ಹೋಗ್ಬೇಕಾ?
I am ready to take the notice on behalf of the.
Serial number 70.
Yes, 70. They have filed the application.
ಇವತ್ತು ಫೈಲ್ ಮಾಡಿದೀರಾ? Counsel. ಮತ್ತೆ how can we pass any orders until it is numbered? ಬೆಳಗ್ಗೆ ಹೇಳಿದ್ರೆ ನಂಬರ್ ತರಿಸಬಹುದಾಗಿತ್ತು.
63 my lords listed in dismissal. I have to, my lords, file applications to bring.
We're not dismissing, we'll give 2 weeks.
Sir, Lordship, serial number 87.
ಇವಾಗ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಆಮೇಲೆ ನೀವು ಏನು ಕಾಲ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
87, day after tomorrow, please.
ಏನ್ ಅರ್ಜೆನ್ಸಿ?
Your Lordship, that respondent is an employee of the petitioner institution. She is terminated. That order is nullified by the labor court, and they have prepared a WP. And I have filed one application under section 20 of ID Act to release the deposited amount. That is, that's why.
Yes, where is Mr. Shilwant?
That's serial.
Tomorrow I will. ಇನ್ನೇನು ಇದು? 104 relist
At least day after tomorrow.
Friday at 2:30.
CL number 20, my lord. My lord.
Sir, one ನಿಮಿಷ ಇರಿ. 230 matter. 1, ಬಿಸಿ ಜ್ಞಾನೇಯ ಸ್ವಾಮಿ.
End of the list move ಮಾಡಿ ಎಲ್ಲಿ ಹೋದ್ರಪ್ಪ?
ಬಿಸಿ ಜ್ಞಾನೇಯ ಸ್ವಾಮಿ.
Relist tomorrow.
2, ಸಾದಿಕ್ ಗುಡ್ವಾಲ.
96. The notice issued by respondent number 3. In page 96.
Oh, ಇದ ಏನ್ ಗ್ರೌಂಡ್ ಏನು?
Lord, annexure D is my lord FIR registered. Lord, kindly turn to ink page 99.
Hmm.
99.
Yes.
Lord, the page 3 of FIR. Lord, ಈ ದಿನಾಂಕ 15/2/2025 ನಮ್ಮ ತಾಯಿಯಾದ ರೇಣುಕಮ್ಮ ಅವರು ಹಡಗಲಿ ಪಟ್ಟಣ ಪಂಚಾಯತ್ ನಡೆಯುತ್ತಿದ್ದು ಶ್ರೀ ಸುಮಂಗ ಜಯಂತಿ ಪ್ರಯುಕ್ತ ಪುರಸಭೆ ಬಂದ ನೋಟಿಸ್ ಮೇರೆಗೆ ಪುರಸಭೆಗೆ 10:30 ಗಂಟೆಗೆ ಸುಮಾರಿಗೆ ಮನೆಯಿಂದ ಹೋದರು. ಪುರಸಭೆಗೆ ಹೋಗಿದ ಬರದೆ ಕಾಣೆಯಾಗಿದ್ದು ಆಗಿನಿಂದ ಅವರು ಮೊಬೈಲ್ ಸ್ವಿಚ್ ಆಫ್ ಆಗಿದ್ದು ಪುರಸಭೆ ಸದಸ್ಯರಾಗಿ ನನ್ನ ತಾಯಿಯವರು ಪುರಸಭೆ ಅಧ್ಯಕ್ಷ ಅಭ್ಯರ್ಥಿಯಾಗಿ ಹಾಜರಾಗಿ ದಿನಾಂಕ 20/2/2000 ಅವಶ್ಯಕತೆವಾಗದಲೇ ಯಾರೋ ತನ್ನ ತಾಯಿಗೆ ಅಪಹರಣ ಮಾಡಿ ಹೋಗಿರುತ್ತಾರೆ. ಕಾರಣ ಅಪಹರಣಗೊಳಿದ ನನ್ನ ತಾಯಿಗೆ ರೇಣುಕಮ್ಮ ಪತ್ತೆ ಹಚ್ಚಿ ಮಾಡಿಕೊಂಡು ಪ್ಲೀಸ್ madam.
When is the no confidence motion?
Tomorrow.
Trace her and bring her tomorrow morning.
Please.
Trace and bring. His contention is his mother has been kidnapped. So that she does not participate in the no confidence motion. So trace her and produce her in the morning. Then AGA accepts notice for respondent number
124.
4. Who in Adagli?
Town Panchayat. Town Municipal Council.
Yaru TMC who in Adagli?
Inquire and serve the court.
Viresh HM. Viresh HM.
Viresh HM for respondent number 5. Land AGA. ಅದಕ್ಕೂ ಈ ನೋಟಿಸ್ಗೂ ಕ್ವಾಶಿಂಗ್ ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ ಹುಡ್ಕೊಂಡು ಬರ್ತಿರ್ರಿ?
Yeah, Malada, because of this Malada, things are happening.
Land AGA is directed to secure instructions and make his submissions as regard the status of crime number 19 of 2015 registered with the Adgali police station. Release tomorrow.
A copy na kotilla. Yeah, 230. Yeah, one of the all the petitions copy na kotilla.
I have said. Lordship kindly see. I'll give another copy.
ಕೊಡಬೇಡಿ, ನಾಳೆ ಮಧ್ಯಾಹ್ನ ಕೊಡಿ. ಇದು ಅಜ್ಜನ್ ಮಾಡಿದ್ಮೇಲೆ.
ಇಲ್ಲ, I give another set. Tomorrow at 10:30. Because tomorrow is the
tomorrow preliminary hearing.
Puneet Badige.
For the petitioner, very short ground, my lords. Annexure G, my lords.
Yes.
Is the form number 2, my lords, which has been issued, my lords, by the Assistant Commissioner, wherein, my lords, the requisition date, my lords, already your lordships observed in the earlier petitions, my lords, that is not required, my lords, for the considerations of the limitation period, my lords, for 30 days. That is the required one, my lords. The 30 days, count the 30 days. This requisition date, my lords, in form number 2 needs to be affixed, my lord, by the Assistant Commissioner. And the form number 1, my lords, which is at page number 22. May I read the 2 lines, my lords, which has been submitted by the members?
Yes.
Please, my lords. ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆ ಸೊಂಡ್ರು ತಾಲೂಕು ಬೊಮ್ಮಘಟ್ಟ ಗ್ರಾಮದ ಪಂಚಾಯಿತಿ ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀಮತಿ ನಂದಿನಿ ಗಂಡ ಸೋ ನನ್ನು ಅಧ್ಯಕ್ಷನ ಹುದ್ದೆಯಿಂದ ತೆಗೆದು ಹಾಕಬೇಕೆಂದು ಸೂಚಿಸುವ ತಮ್ಮ ಉದ್ದೇಶದ ಬಗ್ಗೆ ಕೆಳಕಂಡ ಸದಸ್ಯರಾದ ನಾವು ಈ ಮೂಲಕ ನೋಟಿಸ್ ಕೊಡುತ್ತಿದ್ದೇವೆ. This is the second round, my lords, round of writ petition. Earlier on 10/1/2025, this honorable court had allowed the petition and quashed the form number 2, and liberty was given to the respondents for this one.
PDO sign ಮಾಡಿದ್ರು.
PDO seal, it was affixed. Now, my lords, by ಯಾರ ಉದ್ದೇಶ ಅಂತ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಇದರಲ್ಲಿ. This annexure F.
ಇಷ್ಟು ಜನ ಸೈನ್ ಮಾಡಿಲ್ವಾ?
ಅಲ್ಲ,
ಮತ್ತೆ
but my lords,
what is your contention here?
well, contention is that, my lords, the requisition date has not been mentioned in the form number 2, my lords, which needs to be affixed because of, for counting the 30 days limitation.
You have the copy of the requisition.
I have, my lords.
24,
Another thing, my lords.
Meeting on 20th February.
But the
So within
signature, my lords, receiving authorities, at least seal could have been affixed, my lords, for seeking, for verifying the genuinity of the document, my lords.
And AGA accepts notice for respond number 1 and 2, 3 Garo,
Let's,
Bomagatta Gram Panchayat, Sabdur Taluk, Bellary.
V. Shivraji Remat.
V. Shivraji Remat for respond number 3. Respond number 2 is directed, Land AGA is directed to secure the records to ascertain as to when form number 1 was received, please, by the Assistant Commissioner. Relist on Yavattu.
Tomorrow is a meeting. Not,
Assistant Commissioner meeting attend ಮಾಡಬೇಕಾ ಇಲ್ಲಿಗೆ ಬರಬೇಕಾ?
let that be, my lords. If that can be postponed to the Monday itself.
No, that cannot.
Let that be tomorrow. It will.
We are not postponing anything by giving any stay.
I agree, my lords.
There is something which is required to be stayed, we will stay.
Please.
We are not going to stay democratic process.
Please. I agree. On Monday, my lords.
Serial number 20.
Monday.
Serial number 20.
Serial number 111, my lord. 230 meter further hearing.
Further hearing.
111.
Further hearing ಎಲ್ಲ ಮುಗ್ದಿಲ್ವೇನಪ್ಪ?
No, my lord.
ಎರಡಿದಾವು.
ಅದು direct 112 submission.
110 and 111.
Hello.
List ಮಾಡಿ.
110, the lordships, I made a submission that the certified copy which was produced by them along with the memo on 6/2/2025 stating that the video has endorsed. I made a submission before the lordship that the Assistant Commissioner has maintained 2 files and it has been acted on the no confidence motion which has been requisitioned. Today I am permitted to file the affidavit. ಅಲ್ಲ, ನಾಳೆ ನಾನು
ನಾಳೆ ಯಾವತ್ತಿದೆ ಮೀಟಿಂಗ್? ಇಲ್ಲ, ಸ್ಟೇ ಆಗಿಲ್ಲ.
ಅಲ್ಲ, ಸ್ಟೇ ನಾಟ್ ಪ್ರೆಸಿಪಿಟೇಟ್ ಅಂತ ಆಗಿದೆ. ದಟ್ ಇಸ್ ಇಟ್ಸ್ ಗೋಯಿಂಗ್ ಆನ್.
Friday.
ಅಲ್ಲ, ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಟೇಕನ್ ಆನ್ Monday.
110 and 111 Monday 2:30.
Serial number 20, my lord.
44. Interim order में kindly wait.
All interim order.
Serial number 20, my lord.
That respondent is a poor lady, your lordship. She badly need of Monday na
ರೀಚ್ ಆಗಲ್ಲ. ನೀವು ಯಾಕೆ ಇವಾಗ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ನಮ್ಗೆ ಮುಗಿತಾ ಇಲ್ಲ?
Monday na.
Monday.
Serial number 20, my lord.
ಯಾವುದು? 89 Monday. 39 Monday.
Serial number.
It will come at 69.
Serial number 20, my lord. Passover matter. Serial number 20. Education. The exam is on 3rd March, my lord.
ನೀವೆಲ್ಲಿದ್ರಿ?
Last Bankar.
ಬಣ್ಕರ್.
First time.
Third ತಾನೇ ಇರೋದು. Serve ಮಾಡಿ.
Tomorrow.
Day after tomorrow, Friday.
My lord, one submission.
Tomorrow, my lord.
One submission, my lord. Serial number 50, I mean possession of the property. My possession may kindly be protected, my lord, because they are harassing and
50 ಅಲ್ಲಿ, needless to say, until the rights aforesaid are excised by the petitioner, the petitioner shall not be dispossessed from the property.
without due process of law, my lord.
Public Premises Act.
Much of that.
Serial number 47, lords. PTCL proceedings are initiated in respect of converted land covered by decision. Sir.
Ramji. Ayodhya Ramji. Waha Ramji.
ಸರ್ ಎಂಟ್ರಿ ಮಾಡೋರು ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಿ. ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಿ.
ಸಾಹೇಬ್ ಬೆಂಗಳೂರು ಏನಾದ್ರು ಕರೀತೀರಪ್ಪ?
ಸರ್ ಹೇಳಿ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಹೇಳಿ ಸರ್.
ಬೆಂಗಳೂರ್ದು ಕರೀತೀರಾ?
ಸರ್ ಬೆಂಗಳೂರ್ದು ಯಾವ್ದು ಸರ್? ಎಲ್ಲ ಮಧ್ಯಾಹ್ನ ಮುಗಿದೋಯ್ತಲ್ಲ.
ಹೌದಾ?
ಹಾ, 2:30 ಮ್ಯಾಟರ್ ಸರ್ ಬೆಂಗಳೂರ್ದು.
ಹೌದು, 4:15 ಕರೀತಾರೆ ಅಂದ್ರು.
ಸರ್ 2:30 ಅಂತಿದೆ. 2:30ಗೆ ಕರೀರಿ. ಯಾವ್ದು ಸರ್ ತಮ್ದು?
ಸೀರಿಯಲ್ ನಂಬರ್ 5.
ಸೀರಿಯಲ್ ನಂಬರ್ 5. ಸರ್ 63 ಹಾಕೊಂಡಿದ್ದಾರೆ. 63.
ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು. ನಾನು ಒಂದ್ ಕೆಲಸ ಮಾಡ್ಲಾ? ಹಲೋ,
ಹೇಳಿ.
ನಾಳೆ ಬೆಳಗ್ಗೆ ನಾನು ಒಂದು ಲಾಗಿನ್ ಮಾಡ್ತೀನಿ.
ಮಾಡಿ ಸರ್.
10:30ಗೆ ಸಾರಿ ಕೇಳ್ತೀನಿ. ನಮ್ಮ ಹುಡುಗರು ಹೇಳಿದ್ದಾರೆ. ನಾನು ಇನ್ನೂ ಕಾಯ್ತಾನೆ ಇದ್ದೀನಿ ನೋಡಿ 3 ಗಂಟೆಯಿಂದ.
ಇಲ್ಲ ಸರ್, ಅದು ಮಧ್ಯಾಹ್ನ ಒಂದು 6:3 ಅಂತ ಕೊಟ್ರು.
ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ.